Hello, Namaskara, Vanakkam. In this video, we will cover complete CA final corporate and economic laws in 100% English. Now, our Hindi marathon is already uploaded on the same channel in two parts, right? That means we have divided Hindi marathon into two parts. However, our English marathon is going to be completely in one single part. So this is the only video that is going to be there for CA Final Law Marathon in complete English. Now, this is just a revision video. If you're looking for full course, you can visit our website, bookmyvideo.in. And now for charts, because I have used marathon, I have used charts in complete revision video, and a lot of students inquire about the charts. Fortunately, unfortunately, for some reasons, we cannot give away you just like that. You have two choices. Choice number one, you can scroll and you can note whatever you want to, and you can revise with us. Point number two, or choice number two, you can purchase it from bookmyvideo.in. So we have made it available. So either you can note it down or you can purchase it. Show your love and care, and this is especially for all my South Indian students and friends. So I hope you enjoy it. Wish you all the very best. Thank you. Okay, revision of the complete chapter of directors, appointment and qualification of directors, containing section number 149 to 172. So we have a lot of sections along with the relevant rules, and we're going to revise the same now. Let's begin. First thing is, what do you mean by directors? See, directors are someone who are appointed to the board of the directors of the company. Directors do not have any power individually, they have collectively power, right? They have collective power, which is, you can say, the board of directors or the directors or the board. These all three terms are synonymously used, and they have the power. Why do we need directors? Because company is an artificial person and company cannot run on its own, so we need someone to direct the company. All the company directions cannot decisions, actions, directions, they cannot be done by the shareholders who are the investors of the company. Simple reason being because they are in huge number and everyone cannot be interfering in the management of the company. That's why we need directors to manage the company. So Companies Act has divided the whole powers of company into two authorities. One is the board of directors and other is shareholders. So at times we need permission from shareholders, and the day-to-day management is being handled by the board of directors. Section 149 mandates that every company must have board of directors. Section 149 tells us that minimum number of directors and maximum number of directors, what are they? Minimum number of directors you need 1, 2 and 3. 1, 2 and 3. 1 for OPC, 2 for private and 3 for public. And maximum number of directors for all types of companies is 15. This 15 can be increased. That means a company may have even 20 directors provided it passes a special resolution in this regard. So by passing SR, the maximum number of directors can be increased by any company, right? This particular requirement does not apply to Section 8 company as well as government company, not applicable to government and Section 8 company, right? That means if a Section 8 company wants to have 20 directors, it can have without even passing special resolution, So minimum 1, 2 and 3, maximum 15, which can be increased. Now, that was the first proviso. This was the first proviso. It can be increased by passing SR. Second proviso to Section 149(1). So we are talking about one subsection and its second proviso, which is very important. That's why you must learn this. Second proviso to Section 149(1). Now, what does it mean and what does it talk about? It talks about woman director. Every company needs a woman director, ma'am? No. If it is a private company, there are 2 directors just, out of which one should be woman. This will be harsh on the directors, harsh on the companies. So this is not the requirement which has been imposed by the Act. What has been imposed is that certain set of companies need at least one woman director. You are such a huge company, you have so many board of directors, out of which at least one director can be a woman director. So this is the mandatory requirement which is imposed on listed company, and listed company means listed public company only pursuant to the definition pursuant to amendment in section 2 clause 52 definition of listed company which I'm not discussing here again right now. And if it is other type of public company, then it has to satisfy either of the 2 criteria. Paid up capital more than or equal to 100 crores or turnover more than or equal to 300 crores. Fine. So if it's a listed company, one woman director must. If it is an unlisted public company, if you come under these 2 categories, any of these 2 categories, then you must have one woman director. Fine, ma'am. Now, if it is a new company, newly incorporated company, and it's paid up capital, the turnover will not be, you will not be able to get to know turnover within 6 months of incorporation undoubtedly, but yes, the paid up capital and the listed criteria it may meet. So the whole intention is that the company pre-hand knows that I have this requirement of woman director, and so it has to appoint woman director within 6 months of incorporation. Otherwise, we don't have any specific clarification or law given as to if the threshold increases by when woman director should be appointed, right? All the directors are being appointed in general meeting, and so this woman director will also be appointed. If we look at the financials, and if we find the financials, yes, it is crossing the threshold, thereafter this will be appointed. But what if it is a listed company and a woman director was appointed for a tenure of 5 years, but before that only the woman director died? This gives rise to intermittent vacancy, because if it is not filled, it has to be filled, because if the woman director has died, there is no woman director and it is non-compliance of law, so it must be filled. Who has the power to fill it? The board has been conferred the power to fill it. By when? Immediate next board meeting or 3 months, whichever is later. So intermittent vacancy has to be filled within this particular time limit. Okay, within this particular time limit. Now, section 149(3), resident director. This is for all types of companies. Even if you are a private company, you are a public company, or a one-person company, you need at least a resident director. Who is a resident director? Someone who stays in India. For how long? For more than or equal to 182 days in previous financial year. More than or equal to, that means if a person stays for even 182 days, he will be called as a resident. He will be called as a resident. So a director who is also a resident of India is known as resident director, and every company must have at least one resident director. Fine. Every company must have at least one resident director. Now, basically, if you try to recall, there are 2 types of directors. One are executive directors and one are non-executive directors. Executive directors who are in the whole time employment of the company, non-executive directors who are not in the employment of the company, that is independent director or part-time director. And executive directors, we have example managing director, whole-time director, right? Ma'am, women director have to be appointed as executive or non-executive. It can be appointed either ways. It's not a requirement that they have to be appointed as executive only. No, even if an independent director on the board of a company is a woman, it is sufficient compliance for second proviso of section 149(1). Okay. Likewise, ma'am, the resident director, has it to be executive only? No. Again, no such requirement has been given. So it can be executive, it can be non-executive, that does not matter. But every company must have at least one resident director. Okay, I hope that is clear. Fine, ma'am. So we know the requirement of directors. Now, how do we appoint directors? See, section 149 is not over yet. It has a huge part of independent director, which we will do a little later. Why? Because I teach you in that manner only in the regular class as well, right? So we will revise it also in the same manner. Now we are talking about the appointment of directors. How the directors are going to be appointed. See, the directors are to be appointed by members, by shareholders in general meeting. That is what section 152 tells us, right? However, in certain cases it can be appointed by the board of directors also, it can be appointed by NCLT also, and it can be appointed otherwise also. So we will discuss how can we appoint the directors. Section 152 gives us three things. How first directors are going to be appointed, the requirements of being a director, and the rotation of directors. So it has three concepts involved in it. Fine, ma'am. Who can become a director? An individual. A company cannot become a director. An individual who is holding in, who is not disqualified, who has given his consent, right? And who has furnished MBP1, right? So such a person can be appointed as the director of the company. Fine. Supposedly I fulfill all this criteria. What are the methods? How can I be appointed as a director in the company? The appointment of first directors is given in section 152. The appointment of subsequent directors is given in section 160. And the appointment of retiring directors is given in again section 152. So that's how the appointment is spread over different sections. Okay, ma'am. So every director who has to be appointed to the board of the company must have DIN. What is DIN? It is an identification number which defines who you are, right? So anyone who wants to become a director in a company must have DIN, director's identification number. Without DIN, you cannot be appointed as a director in the company. So you must have DIN. How do you get it? There are two sources of obtaining DIN, DIR 3 and SPICE Plus. We'll read about this later. Okay, fine, ma'am. So you obtain DIN, you give this DIN, and you give a declaration that you're not disqualified, DIR 8. You give your consent, DIR 12, to the company. The company in turns file form DIR 12 for your appointment within 30 days of appointment, right? Section 170 mandates the requirement of filing return, DIR 12, for appointment and wherever there is change in the appointment or change in the directorship or KMP. Okay, fine, ma'am. So anyone who is an individual, anyone who has DIN, anyone who is not disqualified, anyone who gives the consent can be appointed as the director in general meeting by the shareholders unless otherwise provided in the act. So something else can also be provided in the act. In that case, that will apply, but otherwise this is going to be the appointment. However, for the first directors, we cannot wait till general meeting because we are in a hurry. We need directors immediately when the incorporation happens. Right, because we cannot for one day also who will manage the company, to call general meeting, who will call the general meeting. So we need directors as and when the incorporation takes place, and that's why the first directors of the company, the appointment cannot be deferred. We need immediate appointment of the same. So what is given? According to section number 152, the names should be mentioned in the Articles of Association. So the Articles of Association are going to clearly specify that these will be the first directors of the company. Supposedly the Articles of Association don't specify. They will specify the manner. How will they be appointed? Supposedly they don't even specify that. So we will check whether table F can be applied or not. If we have specifically striked out table F that it shall not apply, then it shall not apply. Otherwise, it will be applicable if our articles are silent. What is table F? Table F is the model articles of association for a company limited by shares. So if our articles give the name Mr. X and Y will be the first directors, they will be. If it has given the manner, they will be elected in such a manner, elect in that manner. If first 2 points are not applicable, table F will apply. What does table F tell us? Table F tell us that it will be decided by the subscribers. It will be decided by the subscribers, whoever has subscribed to the memorandum. Supposedly, no name is given in articles. We don't say provide the manner, and we say that the table F shall not apply. In that case, the individual subscribers become the first directors of the company. See, the subscribers may be individual, they may not be individual. A company can become the member of another company, right? So maybe on the memorandum of association of that company, a company has signed, right? A company's common seal is affixed or their representatives have signed. Quite possible. A company cannot become the director for another company. Only individuals can become the director, because again company will be an artificial person. So all the individual subscribers become the first directors of the company. Okay, fine, ma'am. First directors are going to hold office till the ensuing general meeting, and after that they can be reappointed or they may leave. If they want to be appointed again, they have to give their candidature. Because for appointment in general meeting, how appointment at general meeting is going to happen? When you give your candidature under section 160, your name is proposed, and general meeting, the shareholders pass OR and appoint you as a director. So now that is going to happen. That is going to happen. Fine, ma'am. And after that, you can be appointed as rotational director or non-rotational director in case you are a director of a public company. If you are a director of a private company, you can be permanent directors also, that's not a problem. But if we are talking about the directorship of public companies, then you can be appointed either as rotational director or as non-rotational director. Fine, ma'am. Now, before I move to this particular part, DIR 2, that is the consent part, it is not required in case of not-for-profit organizations, that is not-for-profit companies, as well as for government companies. So they have this exemption from filing DIR 2. Okay. Now, if we are talking about a public company, from the total number of directors, minus your independent directors. Supposedly, a company has total 14 directors and 5 are independent directors, 9 are left. Out of this 9, 2 by 3, 2/3 of 9, that is equal to 6, will be rotational directors. And out of the 6, 1 by 3, that is equal to 2, will be retiring. Will retire at every annual general meeting, right? So, whatever is your total number of directors in a public company, it's 2/3 have to be, at least it's 2/3 have to be rotational director, whose office is going to be determined by rotation, right? Out of this 2/3, 1/3 is going to retire at every annual general meeting, right? So here in this case, as on our example, 2 directors will retire at every annual general meeting. How they will retire? The person who has been in the office for the longest will retire first. Supposedly 2 people have been appointed on the same day, they will mutually decide who is going to retire in this general meeting. If they cannot decide, then some lots will be drawn. And they will decide. Okay, they will decide. Fine. Supposedly, they have to retire at general meeting. That means they will go. They can come back also, but the chances are they will go also, right? So they can go, they can come back. Supposedly the directors did not call general meeting. Can they continue? They cannot. If AGM is not held, they will have to vacate the office on the last day AGM ought to have been held. If AGM is held, then the 2 directors, that is 1/3 of the rotational directors, will retire, they can be reappointed, or in their place someone else can be appointed, or the company may resolve that they don't want to fill the vacancy. Either of the 3 will happen. Either of the 3 will happen. Supposedly none of the resolution is passed, then the AGM will be adjourned. It will not be conclusion of AGM, AGM will be adjourned. When AGM is adjourned and the vacancy is not even filled at the adjourned AGM, it amounts to automatic reappointment of the retiring director. That means he will be automatically reappointed. But there are certain cases of exception where he will not be treated as reappointed. Supposedly Mr. X is retiring and Mr. X has clearly said that I don't want to be reappointed. So he has expressed his unwillingness in writing that he doesn't want to be reappointed. We cannot reappoint him. We cannot reappoint him. Supposedly he is disqualified. He has become of unsound mind. How can we appoint him? Specifically in the act is written that we need OR or SR for his appointment. We cannot appoint him. There is contravention of section 162. When Mr. X was appointed, his appointment was only void. That means he was appointed through a single resolution, wherein appointment was needed by a separate resolution. 2 appointments were made by a single resolution. So it amounted to contravention of section 162. Now since your appointment itself was void, you cannot be reappointed. And we tried for your reappointment. So we proposed a resolution in front of the members to reappoint you, but this resolution was lost. That means our members do not want you to be reappointed. So no automatic reappointment will apply to you. Okay, fine ma'am. Now there is one more point over here. What does it tell us? See, some public companies may say that no, we want a transparent vision in our company, and we want all our directors to retire at every AGM. So all the directors retire, someone who's good comes back and the others leave the company. Companies Act tells if you have such strict provisions, way more stricter than what law says, great, follow them. So if your articles say that all the directors are going to retire at annual general meeting, so be it, right? But if they don't say it, then this is something that you are going to follow. This is something that you are going to follow, right? So section 152(6) tells us about rotation, and section 152(7) tells us how the vacancy will be filled pursuant to this retirement of rotational directors. Ma'am, what if they don't follow? If they don't follow these provisions, we have a section 159, which gives us the penalty, Section 159 tells us that if you contravene section 152, this penalty will be attracted. So the penalty is not given in section 152, rather it's given in section 159. The rotation part does not apply to unlisted government company or its subsidiary. Fine. Okay, ma'am. Section 160. Section 160. What is it? It is a section for new candidates. That means, see, who will be the first directors? They will either be the subscribers or they will be someone who is known to the board. Supposedly, I am incorporating a company and I know an efficient person. I will take his consent and I'll write his name as the first director. So I know that person knows me. That's why he could be the director. But section 160 gives a chance to anyone. If you want to be the director, you can propose your candidature. So anyone can propose candidature. Just to screen out or just to have those serious applications, there is a deposit. A refundable deposit of 1 lakh. It's not refundable in all cases, but it's refundable in these 2 cases. So what you have to do is, if I am a member and I want to become a director of my company, or if I am not a member, or if I know someone, I can propose his candidature also. So we propose someone's candidature. How do we propose candidature? We give it to the company. We say that we want this particular person to be appointed as a director in the upcoming general meeting. What you have to do is you have to give a 14 days notice to the company. That means whenever company is going to hold its general meeting, 14 days prior to that, you must give that notice plus 1 lakh rupee deposit. Now this deposit will be refunded if the person is elected as a director or even if he is not elected but his votes are 25%, more than 25% of the total votes which have been cast, it shows that he was a serious and eligible candidate. So in this case also the refund is made. Fine. So you serve this notice to the registered office of the company. What does company do? Company sends this notice of candidature at least 7 days before general meeting to all the members. It can be done by sending individual notices or a public advertisement in 2 newspapers, English and vernacular. And it also has to be placed at the website of the company. Fine. So all the members receive this notice that someone has been proposed to be a director. At the annual general meeting, simply by passing ordinary resolution, they can appoint the director, or if the resolution is not passed, the person will not be appointed. The section does not apply to a private company, because in private company, not everyone gets the power that they can nominate themselves. No. It does not even apply to a 100% government company, wholly owned subsidiary of such 100% government company, and Section 8 company where election is happening by ballot system. Right? Okay, fine, ma'am. In certain cases, you don't need deposit. Why? Or in what cases? In case of independent director. If independent director is proposing his own candidature, independent directors are someone who are anyway highly knowledgeable, highly professional, highly qualified people. You cannot doubt and you cannot say this is not a serious application. Of course, it's damn serious. So they don't need deposits. Moreover, if a person is recommended by board or NRC, probably they are the people who have much knowledge, and if they are recommending someone, he is a deserving candidate only, right? So in this case, you don't need a 1 lakh deposit. Now, supposedly, someone who has retired, a person was appointed as a rotational director in a public company and he retires according to section 152(6). Now, he wants to be reappointed. The question is, do we need to send the notice and 1 lakh deposit under section 160 for his appointment? The answer is no. Section 160 does not apply for the case of reappointment of retiring director. It clearly says that a person who is not a retiring director in terms of section 152 shall also be eligible to be appointed as the director if he gives a notice plus 1 lakh deposit to the company at the registered office, etc., etc. So that's how the process begins. Fine? Okay, ma'am. Now, we know that individuals who are holding DIN and who are not disqualified can be appointed as the director. So, the next question comes out is, what is DIN? DIN, Director's Identification Number. How do you obtain DIN? How do you get DIN? DIN can be obtained in 2 ways. See, the provisions of DIN are covered in section 153 to section 159. 159 is that last penalty part. Any individual who wants to be appointed as a director, you cannot be appointed unless you have DIN. How do you obtain DIN? You can file an application in DIR 3 with these attachments. There is also an option that Spice Plus. Supposedly, I am forming a new company and I have never been a director of any company. So what choice I have is in Spice Plus only I can fill my details and it is going to work as an integrated form and will also provide me DIN apart from incorporation of the company. Right, so this is also a method of obtaining DIN. Otherwise, the general form and the regular form that we have for DIN is DIR 3. Now, just like you can obtain PAN as and when you need, you cannot obtain DIN as and when you need. For DIN, what is required is that you must be a director of some company. Ma'am, how can we become the director without DIN? You must be proposed to be a director of some company, and only then you can obtain for DIN. That means government needs to know that where do you want to be appointed as a director, and then only they will give you DIN. Why? Because in attachments there is a need for board resolution. So the company which is proposing you to be appointed as a director will give a resolution, and then only you can submit this application. Once your application is submitted, central government examines your application. Central government examines your application. Just a second. Central government, if they find that your application is not defective, then what are they going to do? They are going to allot you the DIN. But if they find that yes, your application is defective, then they are going to intimate you via mail or via website, and you have to rectify the defect within 15 days. So you get a chance to rectify the defect within 15 days. Supposedly the defect is rectified, then again you can be allotted DIN, and if you do not rectify the DIN, then it has to be rejected, right? So the application will be rejected. Now whatever DIN you have obtained is going to stay with you for your life, no matter in which company you become a director. You become a director in XYZ, PQR, X Limited, Y Limited, doesn't matter. One DIN for all the companies and one DIN for your life. It's not going to change. It's never going to change. Fine. Okay, ma'am. Only one DIN is allowed for every individual. Just like you cannot have a duplicate PAN, you cannot have a duplicate Aadhaar, likewise you also cannot have a duplicate DIN. Okay. So first thing, you make an application for DIN in DIR 3. Second thing, central government allots you the DIN when they find the application is in order. Third thing, you're prohibited to obtain more than one DIN. Okay, whatever DIN you obtain, supposedly, if now you want to become the director of any company, you cannot become without DIN. But for the directors who were already directors, before these rules came into picture, before this concept of DIN came, they were already directors. Now they are also being given a time limit that they have 1 month from the receipt of DIN. They have to inform central government. Okay, they have to inform the companies, and the company in turn will inform the ROC. So existing director has to intimate DIN to the company and the company to ROC. That is section 156 and 157. Okay, fine. This is clear. Now, any director, if you have DIN, wherever you are quoting that you are the director of ABC Limited or whatever like that, you must state your DIN. Your name is not sufficient. To identify you, we need that DIN. Just like we quote membership number wherever we are doing that, right? CS membership number, CMA membership number, CA membership number, we quote that, right? That is important. So likewise, directors also have to quote their DIN. Okay, fine, ma'am. Now tell me, ma'am, something that can we surrender our DIN once we have obtained the DIN? Can we surrender the DIN? The answer is no. You cannot surrender the DIN just like that. Supposedly, I have worked as a director in a company, I have done enough fraud, and now I simply surrender my DIN and I go away, and now I take another DIN and I become the director of some other company. So whatever frauds I'm doing, I'm never traceable. Can I do that? The answer is no. The answer is no. But supposedly I have unused DIN. Unused DIN. That means, ma'am, how can that be the case? I was being proposed to be appointed as a director in some company, and that's why I made an application in DIR 3 to obtain DIN. I obtained DIN, but in this company, OR was not passed for my appointment, and so I could not be appointed. And thereafter, I have not been appointed in any company as a director, but I have DIN. I know that I'm not going to use this DIN, so I want to surrender this DIN. Can I? Yes, you can. If you have unused DIN, you can surrender that DIN to the government, and the government is going to deactivate your DIN, right? Otherwise we don't get this power. Then what happens, ma'am? RD or central government can cancel or deactivate our DIN. When? If we have duplicate DIN. If our DIN is being obtained in some wrongful manner, that means we have given some misinformation and we have got DIN, or we have got DIN with the intention to deceive someone. In both cases, our DIN can be cancelled. If we die, if we turn out to be of unsound mind, if we turn out to be insolvent, if we surrender our DIN, or if we fail to do KYC. If we fail to do KYC, that can also lead to deactivation of DIN. What is KYC? We have a rule 12A. Earlier you had to read a lot about KYC, not now. What is KYC? Know your customer, right? So know your director. Basically, it is an annual e-verification. Whenever you become a director of some company, every individual who holds DIN, no matter you are a director or you're not a director, you are holding DIN, you have to file this form DIR 3 KYC. And every financial year there has to be a simple verification DIR 3 KYC web through that, right? So all your records are available. It is an online facility. You just approve the same. Why? Because the government records cannot be updated. We are talking about directors. We are talking about the corporate world. The records cannot be old, right? So they have to be updated from time to time, and the responsibility is being conferred on the person holding DIN. If you have DIN, it's your duty to do that. If you don't go for annual e-verification, your DIN will be deactivated. Fine. Okay, ma'am. We also have another rule, Rule 12, which talks about the changes in DIN. So whenever there is any change, not in DIN exactly, in our details, maybe my address has changed. So it is my duty that I intimate the company within 15 days. Moreover, I file DIR 6. I attach the proof of change. It is verified. That is the DSC of CA, CS, CMA is attached. I submit the form for verification. Central government incorporates all the changes and informs ROC also. Ma'am, why this is happening? Why don't we directly file the form to ROC? See, you are doing an online filing only. So you are filing this DIR 6 also on MCA website, but it goes to the central government and not to the ROC. Why? Supposedly, I am a director in a company of Kolkata, Mumbai, Delhi, Karnataka. So I am a director of 4 companies in 4 different states. To which ROC it will go? So the DIN cell intimates it to the concerned ROCs. Fine, ma'am. Number of directorships. What do you mean by this? Supposedly, I am an eligible person, I have DIN, and I want to become a director in 50 companies. Can I? Why not? 50 companies. If you have that caliber, why not? Well, this is not like eating a donut eating competition or a puchka eating competition or something like that. It is becoming a director in companies, which requires time, effort, energy, efficiency, everything. And the government itself has given a very generous limit of 20, out of which 10 can be public companies. So if you are a director in 20 companies, you should know that you are highly efficient, like Rajnikant or something, right? You cannot be holding 20 directorships in active companies just like that, right? So we have a limit. What is the limit? Maximum number of directorships in all companies, 20. So I can be a director in maximum 20 companies. But this does not include Section 8 or dormant company, but includes alternate directorship. out of which maximum 10 public company directorships I can hold, right? So if I am a director in 20 companies and I have 9 public companies and 11 private companies, this is something which is allowed. But 11 public companies and 9 private companies, it is something which is not allowed. Now, when I am computing which is the public company directorship, I have to make sure that I include this also. What is it, ma'am? Private company. Private company which is either a holding to some public company or it is a subsidiary to some public company. This is going to be treated as public company. This is going to be treated as public company for the purpose of, for the section 165 for computing this limit. Okay. Now, supposedly before commencement, there was a person who was a director in 50 companies and there was nothing rule like this. There was no provision like this. When this provision came into picture, he has been given a time period of 1 year that you choose in which companies you want to stay as a director, and the rest of the companies you have to leave. So you resign in the rest of the companies and you intimate your choices to ROC. Okay, fine, ma'am. But after commencement of act, this is going to be the maximum number of directorships. Now some companies, they do it that if you want to be the director of my company, you cannot hold more than 10 directorships. Ma'am, can the companies do so? Yes. By passing SR, you can have strict provisions in this regard. So you can reduce the maximum number of directorships. You cannot increase it. You can reduce the maximum number of directorships. Fine. So that was section number 165. Section 164, this talks about the disqualification. See, this section is divided into 3 parts. Part number 1, that is section 164(1), which talks about 9 grounds of disqualification. If any of the ground of disqualification is attracted to the person, he is disqualified to be appointed in any company as a director. Okay, ma'am. And supposedly after his appointment, some ground of disqualification is attracted to him, then he has to vacate office according to section 167 of the Act. So we have 2 different sections. One is for disqualification and other is for vacation, but they go hand in hand undoubtedly. Okay, fine, ma'am. Section 164(2) also talks about 2 grounds of disqualification, but these disqualifications are attracted to the individual because the company in which they are holding directorship has done some default. These disqualifications are attracted to an individual. These disqualifications are attracted to a director. If you are not a director of any company, there is no point of this particular subsection. And section 164(3) talks about additional grounds of disqualification. That is, a private company has been given the power that you can provide additional grounds of disqualification also. Okay, ma'am. Let's read them one by one. First of all, the 9 grounds of disqualification that have been given in section number 164(1). First is unsound mind. It doesn't matter whether I consider myself of unsound mind or not. It is that I have to be declared by the court. Undischarged insolvent. The court has declared you as insolvent, but you have not been discharged yet. So in that period, you are undischarged insolvent. Third, if you have applied for insolvency, but you have not been declared by the court as insolvent or not or solvent, whatever, that means your application is not disposed of yet. You have applied. So during that tenure also, disqualification is attracted to you. Next, if you have been convicted by court, that means you have been found guilty by the court. See, you have done some offense. The offense is moral turpitude or otherwise. You have been found guilty by the court. The court has given you a sentence of imprisonment. The imprisonment is 6 months or more. Imprisonment is 6 months or more. Then you are disqualified for 5 years. Okay. See, if your imprisonment is less than 6 months, you are not disqualified even for a single day. If your imprisonment is 6 months or more, you are disqualified for 5 years. But supposedly the imprisonment is 7 years or more. 7 years or more. Then you are disqualified for life. You can never be appointed as a director in any company. Any company, any time in the future, you cannot be appointed. Fine. Whatever disqualification we are checking is of course at the time of appointment of director. So whenever you want to appoint, you check whether the person is of unsound mind, discharged, insolvent, is his application pending, has this disqualification attracted to him. For 5 years he will be disqualified. 5 years from the date of, not court's order, but from the date of expiry of his sentence. So when he has completed his tenure of imprisonment of 1 year, 6 months, 2 years, whatever it is, after that 5 years he has been disqualified. After that 5 years he will be disqualified. Next, court's order. If the court has given you an order that you are disqualified, you are disqualified, simple. Unpaid call till 6 months. Now this is for shareholders. See, a director may be a shareholder, he may not be a shareholder. It's not imperative that he has to be a shareholder only. If he is a shareholder or if a shareholder wants to become a director, then he has to check this disqualification also. I am a shareholder of the company. The share price of the price of one share is equal to rupee 10. Out of which 6 I have paid to the company, 4 is unpaid. The company calls for this rupee 4 and I fail to repay it. I fail to pay it. Now imagine appointing someone like me as a director who cannot pay her own call money. You think I have the capability to collect other people's call money, to be responsible for the compliances? No, this shows my responsibility, how irresponsible I am. Right, but this irresponsibility cannot be checked at the immediate moment, right? So we have been given a time period of 6 months. 6 months, right? So during the 6 months, if I pay, the disqualification is not attracted to me. The disqualification gets attracted to me when the tenure of, or when the period of 6 months has elapsed from the last day fixed for payment. Okay, then I am disqualified, and this particular disqualification attracts only for company in which call money has not been paid. In which call money has not been paid, and not in other companies. So in other companies I am qualified to become a director. Only in this company I cannot become a director. Now supposedly you are already a director. So I vacate the directorship according to section 167 and I cannot be reappointed. Reappointed till when? Till I pay this call. Offence under section 188. Related party transactions offence. So if I have been found guilty for this offence, I cannot be appointed. Till when? Preceding 5 years. So we check for preceding 5 years. If preceding 5 years this offence is existing, I cannot be appointed. If in preceding 5 years this offence is not existing, I can be appointed. He has not been allotted din. Without din you cannot be a director, and if your directorship limit is exceeding 20, you cannot be a director undoubtedly. So on all these 9 grounds, you are disqualified. You cannot be appointed as a director. You cannot be appointed as a director. Fine, ma'am. Then we come to section 164(2). From examination point of view, this is very important, but although it's very small one. Supposedly, I'm a director in some company, and that company fails to file its financial statements or annual return for a continuous period of 3 years. Or It does not pay its deposits, debentures or dividend. They remain unpaid for 1 year or more. Either of the two situation gets attracted, the company becomes a defaulting company. And if I am the director of the defaulting company, I become disqualified. That means if I want to be appointed in some other company, I cannot be appointed. I cannot be appointed. And ma'am, you have to vacate office also from this company? No. This is the catch over here. Not from this company. Not from this company. See, vacation has 8 grounds. If a director is disqualified under any of the ground of section 164(1), he vacates the office. If you are disqualified under section 164(2), then also you vacate the office, but not from the defaulting company. That means if a person is a director in 4 companies, A Limited, B Limited, C Limited, D Limited, and A Limited has not filed its financial statements, the directors of A Limited are disqualified. They cannot be appointed in any other company. And whoever is the director of A Limited is also a director of B, C, D, you have to vacate office, but in A Limited you will continue the office. Right? Because you are responsible for all this. Okay, fine, ma'am. Now, supposedly there is a new director who joins, and before he could actually analyze what's happening in the company, this default gets attracted. And when the default gets attracted, all the directors of the defaulting company, they become disqualified. So Mr. X cannot be appointed in any other company. Oh, very unfair, right? So this disqualification does not apply for 6 months from the date of appointment. So a new director gets the benefit, he gets the time to, he can rectify the defaults, whatever is going on in the company. So he gets a benefit of 6 months. Okay, fine. Clear? For this, you also have to give a declaration, the IR 8, that I have told you a number of times. Now, vacation. Grounds of vacation, section 167. First 2 grounds I have already told you. Third is, if the director is absent in all board meetings during 12 months, see, not in the financial year, not in the calendar year, we check for any 12 months, any 12 consecutive months. So, the director skips the first board meeting, from there we check for a tenure of 12 months. If he does not attend any board meeting, doesn't matter how many board meetings are held during that particular time, if he does not attend any board meeting, he has to vacate the office. He vacates the office, can he come back? Why not? Because this is not a ground of disqualification. So when we want to reappoint him, when we want to appoint him again, we check the grounds of disqualification. We don't check the grounds of vacation. So again, he can start. These 2 grounds both relate to one section, section 184. What is section 184? It talks about interested contracts. A director may be interested in some contract. If he is interested, he must disclose it pre-hand to the board of the directors. So he has to disclose it. Moreover, if he is interested, he will stay away from that particular contract. He will not participate in that board meeting. He will not vote, etc., etc. So there are 2 requirements on part of the director that he has to do. So if you fail to disclose your interest, or if you participate in that meeting of interested contract, both are an offence under section 184. And if you contravene these 2, you have to vacate office of director. You have to vacate office of director. Okay, ma'am. Next is, if you are disqualified by court. If you are disqualified by court, it is included in this. So you vacate office. If you have done an offence, imprisonment 6 months or more, disqualified, included in this, vacate office. Why? Given separately. Because in such situation, the vacation of office is postponed till disposal of appeal. See, whenever anyone passes a court order against us, we get a time period. What time period? We get certain time period to file an appeal. This is our right. So if court has said that you have done an offense and you are being sentenced to imprisonment for 1 year, this is my fundamental right, I can appeal. And when I appeal, will this disqualification be attracted to me? Do I need to vacate office? What is going to happen? So I have made a beautiful chart for that. Let's discuss this. Order of court. So we have a court order and the court order finds us guilty. I have two choices. I can either file an appeal or I don't file an appeal. If I don't file an appeal, I get a chance to file an appeal within 30 days. If I don't file an appeal, on the 31st day, I vacate. If I file the appeal within 30 days, then I will not vacate office till this appeal is disposed of. See, if the court has declared me as guilty, I am disqualified. I cannot be appointed in any other company, but the directorship that I am holding is going to be delayed if I file the appeal. So I don't have to vacate immediately. I will vacate when the appeal gives its order. Okay, so next court order I receive, I'm not guilty, I don't vacate. And if I am guilty, I again get a chance to file an appeal within 7 days. If I file the appeal within 7 days, if I don't file the appeal within 7 days, I vacate on the expiry of 7th day. But if I file the appeal, again I will not vacate the office till this appeal is disposed of. And after this, I don't have a chance for further appeal. So if I'm guilty, I have to vacate. If I'm not guilty, I'll not vacate. Okay. So that's why these 2 points are given separately. Then, if I'm removed in pursuance of the provisions of the Act, Section 169 gives the power to shareholders that they can, by passing ordinary resolution, remove the director. So if a director is going to be removed, he has to vacate the office undoubtedly. And moreover, if he is appointed by virtue of holding office, if he is the CEO of a subsidiary company, and he has been appointed as MD because he is the CEO. If he ceases to be CEO, he will cease to be MD also. Simple. There can be a situation that all the directors have vacated the office. Now, the company again cannot run on its own. So, we need the directors. Where will we go? We will go to the promoters. The promoters will appoint the directors. In their absence, we will go to the central government, and central government will appoint the directors. They will hold office till the general meeting, and in general meeting, we will the regular directors can be appointed, or these directors can only be regularized, right? Just like a private company has the power to provide additional grounds of disqualification, it also has the power to provide additional grounds of vacation also. Okay, fine, ma'am. Now, Section 161, a very important section. Even from examination point of view, it is divided into 4 parts and you have to remember all 4 subsections. Section 161(1), additional directors. 161(2), alternate directors. 161(3), nominee directors, and 161(4), casual vacancy. 161(1), additional directors. Who are additional directors? Anyone. See, if you appoint first directors, if you appoint the directors in general meeting, if you appoint additional, alternate, casual vacancy, whatever type of director you appoint, if you appoint nominee director, if it is appointed by NCLT, whatever it be. One thing is must, or the basic requirements are must. Such person must have DIN, such person must give consent, such person must not be disqualified, and these are basic requirements, okay. So even when you are appointing someone as additional director, you have to ensure these things. General rule given in Section 152 is that the directors will be appointed by the shareholders in general meeting. This is an exception to that. So Section 161 here, the appointment is not happening by the shareholders in general meeting. It's happening by the board of directors, right? So the board of directors are appointing here. For additional director, the board of directors can appoint by passing BR, provided they have an authorization in AOA. If AOA is silent, table F can also authorize. Okay, ma'am. So if the board has authorization, they can appoint someone as additional director by passing board resolution. Now this additional director is going to hold office till AGM only. Supposedly AGM is not held, last date on which AGM should have been held. Okay. Supposedly Mr. X, he was proposed in the general meeting and he could not be appointed because his resolution was lost. Now he approached the board of directors and they appointed him as additional director. This is something which is not allowed. Someone who has been rejected by the members cannot be appointed by the board. So a person other than someone who failed to be appointed at general meeting can be appointed as additional director. Alternate director. Alternate director. If a director goes out of India for 3 months or more, right, the board has the power. From where do they get the power? They get the power from either articles of association or through ordinary resolution in general meeting. So if they have this power, they can fill the vacancy of that director by appointing someone else. How? Simply by passing ordinary resolution. Now, he is a replacement. Although you have to understand that alternate director is not a proxy of the original director, he is not the agent of the original director, he is having a separate terms of employment with the company, but it is just that he is appointed to fill that vacancy. So if the original director returns, he vacates. If the term of original director expires, he vacates. So he cannot hold office beyond that particular period. Moreover, a person who is going to be appointed as an alternate director has to be someone who is not already a director of the company, and one person cannot hold alternate directorship for more than 1%. Right? Alternate director is not an agent of the original director. It has its own duties and own liabilities. Okay, ma'am. Section 161(3), nominee director. See, okay, before that, one more point for alternate director. Supposedly, alternate director is a retiring director. He is a rotational director. And he has to retire at annual general meeting. So he retires. At annual general meeting, there was no ordinary resolution which was passed for his reappointment or appointing someone else or resolving not to fill the vacancy. So AGM was adjourned. At adjourned AGM also none such resolution was passed. So it leads to automatic reappointment of retiring director. Now this retiring director is out of India and we have in its place an alternate director. So who will be reappointed? Alternate director or original director out of India? Original director out of India. So the reappointment is not, automatic reappointment does not happen for alternate director. It happens for original director. Okay, ma'am. Now, nominee director. For alternate directors, you have to remember all those basic points, that it does not matter whether the original director is going to out of India for whatever purpose. So the purpose is not important. When he comes back, he has to vacate, right? So all these minute points also we have to remember. And now fine, nominee director. Nominee director, section 161(3). See, the board, if he gets the board gets a nomination, that means supposedly the company has taken loan from a financial institution and they have an agreement that we are going to give you loan only if you allow one person who we are going to nominate to be a part of your board of directors. So financial institution is nominating a person and the board has to appoint that person as a nominee director on their board. Likewise, it can be nominated by central government if they have a shareholding, of course, in a government company. So that is the situation, and it can also be in pursuance of some law. So if the law states or mandates, that is also going to be nominated. So whenever financial institution or other institution or government, they nominate a person by virtue of their shareholding, by virtue of law, or by virtue of an agreement, the board, by passing board resolution, appoints such person as a nominee director, subject to articles. Clear? Fine, ma'am. Then we have casual vacancy. Casual vacancy is not like intermittent vacancy. The director who has been appointed by the shareholders in general meeting, it is for the director appointed in general meeting and not for the director appointed by board or any other manner. It is for the director appointed in general meeting only. Supposedly his office ends otherwise than in normal course. He was appointed for a tenure of 5 years, but before 5 years only, after the expiry of 2 years, he dies. This is a casual vacancy. This is not intermittent vacancy. Why? Because in intermittent vacancy, it is imperative. It must be filled. Otherwise, it will lead to non-compliance of law. Here, a director has died. It is not non-compliance of law, right? So it may be filled by the board. It may not be filled by the board. Okay. So this is known as casual vacancy. If board has power through articles, it can fill this vacancy. How? By passing a resolution at board meeting. Now, it is a casual vacancy. For 2 years he worked and for remaining 3 years he could not work. So his vacancy is for 3 years only. This is casual vacancy. So whoever fills this position is going to hold office only up to the date which director in whose place he is appointed would have held had he not vacated. That means this particular date. So anyone who is filling the vacancy, casual vacancy, is not going to hold office beyond this tenure, beyond this date, he cannot hold office. He cannot hold office beyond this particular date. Is that okay? Is that fine? Okay. Now, there is one more requirement in case of casual vacancy, because he is going to hold office for a very long tenure. Say for 3 years, 4 years, 5 years, it could be anything, right? For the remaining tenure, it also needs approval from members. So although board has the power to appoint anyone wherever casual vacancy arises just by passing board resolution, they have to seek subsequent approval from the members also by passing OR in whichever next general meeting comes. Okay? Clear? Fine, ma'am. Now, section 162, appointment of directors to be voted individually. This section applies not to a private company. It does not apply to a private company. What does this section tells us? It tells us that appointment of a director, 2 or more directors, appointment of 2 directors or more directors cannot happen by a single resolution. I cannot say that I propose to appoint or resolve that Mr. X and Y be hereby appointed. The members are being deprived of the freedom of choice over here, because either they have to appoint X and Y both or they have to reject X and Y both, which is not allowed. So for every appointment of director, we must have a separate resolution. Appoint X, yes, no. Appoint Y, yes, no. Appoint X and Y, yes, no. Doesn't work. So separate resolution is something which is allowed for appointment of 2 or more directors. However, single resolution may also work. When ma'am? When can it work? When a prior resolution is passed. That means before the single resolution, another resolution is passed which tells us, resolve that appointment of X and Y is going to take place by single resolution, whether you approve or you disapprove. So you are taking prior permission from the members for proposing single resolution, and when you obtain this prior permission, it's not going to be OR, it's not going to be SR, it's going to be a resolution with no vote against it. That means there shouldn't be any objection raised to the passing of single resolution. Before single resolution, there has to be another resolution which has to be passed. Okay, fine, ma'am. Supposedly, you did not meet these conditions, you did not meet this requirement, and without meeting these requirements, single resolution was passed. Without taking this permission, single resolution was passed. Then all the appointments will be void. And this section 152(7) deemed reappointment shall not apply. We discussed this as an exception. When the retiring director automatically reappoints in adjourned AGM, there is an exception. This is an exception. I told you before only that section 162 does not apply to a private company. It does not apply to a 100% government company and wholly owned subsidiary of such 100% government company. Wholly owned subsidiary of such 100% government company. Okay, ma'am. Section 163. Proportional representation. What is proportional representation? See, if there is being given the power in article, some companies may choose to appoint their directors by proportional representation. Normally what happens, a person is proposed, OR is passed. If we get simple majority, he is appointed as a director. But in PR, we have a special voting method. This is by majority, simple majority. The minority shareholders might have to say that we cannot propose someone, our proportion is not being represented, etc., etc. So we have differential voting methods. What are the three voting methods which are recognized by this section? Single transferable vote, cumulative voting, or otherwise. So you have to remember these three names. The procedures are explained in the regular classes. Now, if your articles permit you, the company may resolve to appoint the directors by proportional representation, right? If you choose PR, then at least 2/3 of your directors are going to be appointed by PR, which cannot be removed by using section 169. Okay, this is an overriding section. So if you choose PR, all other things get stagnant. No rotation, nothing. Okay. The appointment is like the elections. It happens for 5 years, again election will happen. So likewise, here the appointment is happening for 3 years, again after 3 years, again PR. Again after 3 years, again PR. Right? The same people can be appointed, that's not a problem. Okay. Now, this section is again not applicable to 100% government company or wholly owned subsidiary of such government company. The directors who are appointed by using this particular section of proportional representation cannot be removed using section 169. They cannot be removed using section 169. Clear? Okay. Next we have section 168, the resignation of directors, a very simple section. Before we go on to resignation, let me discuss with you, what do the directors do? What are their duties? The directors have to act in accordance with the Companies Act. They have to act in accordance with the articles of the company. They must act in good faith. They should not be negligent towards the company. They should have due diligence. Their interest and the company's interest should be common. They should not ever have a conflict of interest. They should never attempt to have any undue advantage of any situation or gain anything which make secret profit or anything like that, right? And more importantly, prohibited to assign office. This is the most important duty which is covered under section 166 of the Act. Prohibited to assign office. You cannot transfer your office of directorship to anyone else. If you do, or if you do not follow or diligently perform any of the duties of the director, then you can be attracted to a fine starting from 1 lakh to 5 lakh. Right? So all the duties of the directors must be efficiently discharged by the directors who are appointed to the board of the company. Okay, fine. Now, resignation by director. Director may resign. Director cannot be stopped by anyone else. If it wants to leave the company, he or she may leave the company. What they have to do is, they just have to give a notice in writing to the company, right? The company, it is company's duty to further inform ROC that their director has resigned. So there is a form DIR 12. Within 30 days of receiving that resignation, you have to inform ROC. Whenever a director is giving resignation to the company, the resignation is going to be effective from the date when the company receives the resignation or the date you have specified in the notice, whichever is later. So from that date, your resignation will be treated to be effective. Okay, fine. And when the board comes to know about the resignation, they have two duties. They have to intimate ROC, plus they have to also include it in their board's report. As and when it will be made. Now, there is an optional requirement given in section 168 which tells that a director who is resigning may also inform ROC. Although it is not this duty of the director who is resigning to inform ROC, it is the duty of the company to inform ROC. But you may also voluntarily inform ROC within 30 days of giving resignation in DIR 11. Okay, fine, ma'am. Now here also there may be a possible situation that all the directors have resigned. So again we will go to the promoters. The promoters will fill the position of directors, and if it cannot be filled, then the central government is going to take charge, right? Central government will appoint the directors. Next is section 169, which talks about the removal of directors. What happens? Supposedly the board wants to remove any of the director. It cannot. The power to remove director is with the members. How can they do it? By just passing ordinary resolution. Now, removal before expiry of their term, because when their term has expired, they automatically leave and vacate the company. Before the expiry of their term, the members have the power that they can remove the directors, right? But for removing the directors, you must send special notice to the company. And to send special notice, you must be eligible. How do we come to know whether we are eligible to send special notice or not? Section 115, right? So it tells us that the members who are holding at least 1% of voting power or 5 lakh paid up capital in value is eligible member. So if you have the eligibility to send a special notice, send a special notice. This is just a name, nothing very special about it. It's just that this notice has to be sent 14 days before general meeting to the company. General meeting, any meeting, AGM or EGM. This special notice can contain two things. One, remove, we propose, or the intention, we intend to propose for the removal of Mr. X as a director. Point number one. Or it may say, we intend to propose to remove Mr. X as a director and appoint Mr. Y in his place. So there are two situations. One is you just want removal and the second is you want replacement. So when you want replacement, you suggest a name also, and when you want removal, it's just removal, right? So there can be two probable situations. So you give this special notice to the company. Now what does the company do? The company sends a copy of this notice to the concerned director, for whose removal the notice has been received. This concerned director gives a written representation to the company, what he has to say to its members, right? This written representation is being requested by the company to be forwarded to the members. But what happens sometimes? The directors, the concerned director tries to misuse this power. He has been given an opportunity that he can convey his message to the members. But instead of using this opportunity, he is misusing the power and writing all the bad things that he can about the company, about its directors, about its management, etc., etc. Now, when the written representation reaches to the company reads it, they get disturbed. And they feel that how can we let this be circulated to our members? So to seek a solution, they may move to tribunal. So they make an application and they say that we understand that the director has a right to make a representation, but such type of representations that he is making cannot be circulated. So the tribunal might order that there is no need for circulation of this written representation, or reading it out at the meeting, right? So in such case, this written representation may not be circulated. Otherwise, it will be circulated. Fine. So eligible member sends special notice to the company forwards the copy to director gives written representation to the company sends written representation plus notice 7 days before general meeting to the members. Quite possible there is time constraint or any other thing, and the meeting and the notice as well as the representation could not be sent, so it will be read out at the meeting. That's not a problem. And quite possible it is sent. Whatever the case be, general meeting is held. By passing OR, the director can be removed. Now, when he is removed before the expiry of his terms, it again leads to vacancy which has been created, right? Ideally, this is a case of casual vacancy, but supposedly we got the special notice of replacement and Mr. Y's name was also proposed. So, by passing OR, Mr. Y can be appointed. Supposedly, he was not appointed or no name was proposed. Then it will amount to casual vacancy which can be filled by the board by using section 161(4). Okay, so we are removing directors just by passing OR. There are certain type of directors which cannot be removed by OR. What type of directors? Director who has been appointed by the tribunal, the director who has been appointed by proportional representation, the nominee director, and see, independent director, he is appointed for 5 years by passing OR. He can be removed by OR. He is appointed again for 5 years, that means for his second term, by passing SR. He can be removed also only by passing SR. He can be removed also only by passing SR. So, independent director in second term removal requires SR. Clear? Okay. Now, broadly we have completed the chapter and we are left with two important topics, independent director and SSD. Before that, section 170. What is 170? It tells about the maintenance of register. So every company has to maintain a register of directors as well as KMP. This is going to be maintained at the registered office, which shall also be open for inspection by the members according to section 171. They can inspect this. It will also be available in every annual general meeting where members can come and see it. They can take extracts. It is company's duty to provide extracts within 30 days. If you fail to do so, an application can be made to ROC, and ROC will order you immediate provision of the same, right? So that is something. Section 171 talks about inspection. Section 170 talks about maintenance of register. Apart from maintenance of register, section 170 also talks about DIR 12. That whenever you appoint a director or whenever there is a change in director or KMP, file DIR 12 within 30 days. Within 30 days. Section 170 as well as 171, they both are not applicable to government companies. They both are not applicable to government companies. Section 172, this talks about punishment. So if the punishment, if you contravene section 149 to 171 and there is no specific punishment provided in that particular section, example, non-maintenance of register, non-appointment of woman director, all this is, no specific punishment is given in that respective section. So you follow the punishment of leftover section, that is section 172, which states that minimum penalty 50,000, 500 per day continuing default, and maximum penalty 3 lakh and 1 lakh. 3 lakh for company, 1 lakh for officer in default. Okay, 3 lakh for company and 1 lakh for officer in default. Clear? Now we move to independent directors. Independent directors. Who are independent directors? Someone who is a highly experienced, highly knowledgeable person and who is not connected with the company. So when he comes to the company, he brings high level of expertise, and since he is not connected with the company, he will bring an unbiased opinion. We don't need independent directors in all types of companies. They are needed in certain limited companies. Listed company, if it's listed, we don't need to check any threshold. Listed companies straight away have to have 1/3 of their directors to be independent. If it's not listed, we have to check 3 criteria, 10, 100 and 50. Paid up capital more than equal to 10 crores, turnover more than equal to 100 crores, or loans, debentures, deposits more than 50 crores. If either of these 3 criteria is satisfied, then you have to appoint 2 independent directors, at least 2 independent directors. Okay. So every listed company, at least 1/3 independent directors, and unlisted public company, if you meet the threshold, at least 2 independent directors. Whatever independent directors you are appointing have to be subject to the requirement of audit committee, NRC, any other law. That means if audit committee says you need 4 directors, independent directors, and this section says 2, appoint 4. Okay. Supposedly, the company is an unlisted public company and has crossed the turnover of 100 crores. So 150 crores is the turnover, you appoint independent director. Next year, the turnover comes down below 100 crore. Again below 100 crore, again below 100 crore. So if for constant 3 years you fail to meet that threshold, then there is no requirement for appointment of independent director. There is no requirement for appointment of independent director. Just like the vacancy in the office of woman director is filled immediate next board meeting or 3 months, whichever is later, like that here also the intermittent vacancy which is created in the office of independent director has to be filled up immediate next board meeting or 3 months, whichever is later. To appoint anyone as independent director, what is needed is the person should be an individual. He should not be disqualified. He should have given in. He should have given consent. He should meet the criteria of independence given under section 149(6). Apart from all that, and his name should be included in the data bank. What is this? What is this? We will read it a little later. Okay, so all these requirements, if they are fulfilled, then his name can be proposed, and when his name is proposed, he is appointed in the general meeting by passing ordinary resolution. Okay, ma'am. To be an independent director, independent director comes under the category of non-executive director. So you cannot be MD or whole-time director or nominee director. You cannot be these three. And if you are not these three, then if you meet the criteria of independence, you can be appointed as independent director. So not MD, not WTD, not nominee director, and satisfying all conditions below can be appointed as independent director. Point number 1. He should be the person of integrity, experience and expertise. Not in our opinion, but in the opinion of board. If it is a government company, in the opinion of respective ministry. He should not be the promoter of company holding subsidiary associate. This you can call as CHSA, this you can call as cash, this you can call as group, however you may learn it. Not related to PD, that is promoter director of cash, PD of cash. Someone should not have a pecuniary relationship, that is a monetary relationship with cash or with PD of cash during preceding year or 2 preceding years, during financial year or preceding 2 years. Now this has an exception. It is quite relaxed that if your pecuniary relationship does not exceed 10% of total income, it's okay, you may have it. Still you will satisfy the criteria of independence. Right, still you will satisfy the criteria of independence, integrity, experience and expertise, not related to PD of cash and not a promoter, not having a pecuniary relationship. So these are the first 3 clauses, easy ones. Then comes D, which is for the relatives. So your relative should not be holding security in cash, that is CHSA. Your relative should not be holding security in CHSA. There is a limit that if it holds security up to 50 lakh or 2% of paid up capital, it is allowed. Your relative should not be indebted to CHSA or PD of CHSA. If it is indebted in amount of less than equal to 50 lakhs, it is allowed. Your relative should not give guarantee to CHSA or promoter of CHSA or director of H. If it gives a guarantee for an amount less than 50 lakhs, it's okay. It's okay. You can write for an amount of 50 lakhs or more. Right? It's okay. Your relative should not have a pecuniary relationship with CHSA. For an amount 2% or more of turnover or total income. Pecuniary relationship, again monetary relationship. We have done a detailed discussion on all these points, right? So now I think you are well in a situation that you can quickly recall this, and this is learnt by you, right? Okay, so clause D was for relatives. 4 points. Not holding security, 50 lakh, 2% paid up capital, not indebted in excess of 50 lakhs, not guarantee for 50 lakhs or more, no pecuniary relationship, 2% or more of turnover or total income, right? So these are the 4 points for relative. Now, you or your relative should not have been a KMP or employee in CHSA preceding 3 financial years. However, relative may have been an employee. You or your relative should not have been employee, proprietor or partner in audit firm of CHSA, CS firm of CHSA, cost auditor firm of CHSA, or such a legal firm which is getting 10 or more % of its total income from CHSA, right, in preceding 3 financial years. You with your relative should not hold more than 2% of the voting power of company. You with your relative, you or your relative should not be a director or executive of such NPO which is getting 25% or more of its receipts from CHSA or the director or promoter of the company, or holds 2% or more voting power. Who possesses other qualification as prescribed? What are the other qualification prescribed? You can be an expert in finance, you can be an expert in law, management, sales, marketing, administration, research, any other discipline, etc., etc. Fine. Now, every person who is going to be appointed as an independent director must give a declaration that yes, he has fulfilled the criteria of independence. So whenever you are appointed as independent director, in the first board meeting that you participate, in the board meeting of every financial year, and wherever there is a change in circumstance, you have to give a declaration. It is your duty. We have a code, Schedule 4, code for independent directors, how independent directors must react to the situations, how they should behave. You must follow that. You must follow that. What will you get? Because you cannot get salary, you are not an employee. You would get profit related commission. Even if there is no profit in the company, then also you will get commission. Then also you will get some amount. You will get sitting fees. Right, you will get reimbursement of expenses. Okay, but you will not be entitled to stock option. That is one thing that you need to remember. You will be appointed for 5 years. For 5 years. You may be appointed for a shorter term also, but you cannot be appointed for more than 2 consecutive terms. And any term shorter than 5 years will also be treated as 1 term only. So here you can be appointed for 5 years by passing OR, again for 5 years by passing SR, and then you need to have a cooling period. Then you need to have a cooling period for 3 years. Cooling period for 3 years. Again you can be appointed for 5 years. Okay, during the second term, if the company's shareholder want the independent director to be removed, they have to pass SR for removal. OR will not suffice. OR will not suffice. Okay. Now, whoever is the independent director or any non-executive director, he cannot be held liable for everything that's happening in the company. He will be liable only for those acts where he has given his consent, he had knowledge, or he had not acted diligently. Only for those cases he will be responsible. Only for those cases he will be responsible. Independent directors don't retire by rotation. Don't retire by rotation. Now, as I told you about data bank, right? What is data bank? Section 150. Section 150 basically tells us about data bank, that central government, see, every company, it is mandatory for listed companies and the companies which are meeting this criteria, it is mandatory for them to appoint independent directors. From where will they get these independent directors? For which central government has maintained a data bank. Now this data bank has been maintained by the notified institute of government. What is the notified institute of government? Indian Institute of Corporate Affairs has been notified by central government. So any company who wants independent director, they can go to that data bank, they can select a person, they have to perform their own due diligence, and if he meets all the criteria of independence of your company, etc., etc., you may appoint such a person as independent director. Fine. Okay, ma'am. Now we have a rule 6. If I want to be the independent director, or I have been the independent director, I have to comply with this rule 6. What does it tell us? What does it tell me? That I cannot be an independent director unless my name is included in the data bank which is maintained by this institute. How do I include my name, ma'am? I have to make an application to the institute along with the relevant fees, and my name will be included. Okay. That means before this rule came into picture, there were many independent directors. They also have to include their name. Yes. They have been given a time period of 13 months within which they can apply to the institute for inclusion of their name along with the fees. The name can be included for 1 year, 5 year, or for lifetime. And after this rule, anyone who wants to be appointed as an independent director, that means some companies proposing you to be appointed as independent director, you must before your appointment include your name in the data bank. And supposedly I'm not being appointed by anyone as independent director yet. I find this as a career opportunity and I want to include my name voluntarily. I don't even have DIN. I'm not a director of anyone. Can I? Yes, you can. So voluntarily also you can apply for your name as an inclusion in the data bank. Now, when you apply for your name as an inclusion in data bank, within 2 years you have to pass a test. Online Proficiency Self-Assessment Test, OPSAT. With 50% passing criteria, there is no limit on the number of attempts. So within 2 years, you have to pass it. You have n number of times. So within 2 years, you can appear for the test n number of times and you can pass this test. You have to. If you don't pass it, your name will be removed from this particular data bank. If you pass it, great. Supposedly, you enrolled your name for 5 years only. The tenure expires. Within 30 days, you can renew it. If you don't renew it, your name will be removed. Fine. Now, what has to be, what else is there in this rule which needs to be remembered is the exemption. What exemption, ma'am? Now, some very proficient people are not required to appear for their test. They will apply to the institute for inclusion of their name and this step is excluded. They don't have to appear for their test. Who, ma'am? Someone who has 3 years of experience as a director or KMP in listed public company, unlisted public company with paid up capital to 10 crores or more, in any body corporate which is listed either in India or in such a country which is a member of FATF or IOSCO. Any body corporate which is incorporated outside India but having paid up capital more than equal to $2 million US. Any other statutory corporation. Or if you have 3 years experience in the pay scale of director or above in the Ministry of Corporate Affairs, Ministry of Heavy Industries, Ministry of Public Enterprises, Ministry of Commerce, etc. Right? Or if you have been in the pay scale of Chief Manager or above in SEBI, IRDA, RBI, PFRDA, so all these are excluded from appearing for test. Moreover, if you are an advocate in practice, if you are a CA in practice, if you are a CS in practice, if you are a CMA in practice, and you've been practice for 10 years, at least 10 years, then also you are exempted from the test. Okay. Fine. And this is probably the last section that we have to discuss, that we have to revise. We've covered all the sections. SSD, Small Shareholders Director. Who are SSD? SSD. The directors who are elected by the small shareholders. Who are small shareholders? Small shareholders are the shareholders who have less than or equal to 20,000 face value of shares of the company. So they are considered as small shareholders. Now this section applies to listed company. and it is discretionary, it's not mandatory. So if a listed company wants, it may suo motu, that means on its own or on receipt of a notice by the eligible small shareholders, it can have one SSD who is elected as who is elected by small shareholders. Who is eligible to send notice? 1000 small shareholders or 1/10 of small shareholders, whichever is lower. Right. So they will send a notice to the company that we are proposing the appointment of this person as SSD, and this is his DIN, this is his consent, and he has given a declaration that he is not disqualified. Right. So along with these details, they send a notice to listed company. Listed company may have one director elected by SSH. Now this is not a normal election which is happening by all the shareholders. So it's not an ordinary resolution in general meeting. It is the election by small shareholders only. So they meet. Only their meeting happens, and in their meeting by majority votes such a person is elected who is going to be non-rotational, who is going to be independent. So he also has to meet the criteria of independence, section 149(6), and he also has to give a declaration in that regard. Okay, and he is going to be non-rotational. He has a fixed term for 3 years. Can he be reappointed after 3 years? No. Then 3 years will be cooling. Again, then he can be appointed after 3 years. During this cooling period, he cannot be appointed or be associated in the company in any manner. In any manner. Okay. Fine. If small shareholders director, someone who is appointed as SSD, is disqualified under section 164 or grounds of vacation are attracted to him, or he fails to meet the criteria of independence, he has to vacate. He has to vacate the office. One person can be SSD in maximum 2 companies, but the 2 companies should not be competing business, should not be in the competing business, okay, or their business should not be in conflict with each other, okay. And no reappointment allowed, that is something that I have already told you. SSD can be removed under section 169. This is something which is allowed. SSD can be removed under section 169, right? So I think we have revised everything. Okay. Hi everyone. Let's now revise our chapter of appointment and remuneration of managerial personnel, right? This particular chapter has sections 196 to section number 205. Not a lot of sections, but 2 very important sections of your curriculum, that is section 196 and 197. So we will start with the appointment part. Every company has some executive directors as well as some non-executive directors. The executive directors, that is MD, WTD, along with the manager, is termed as managerial personnel, although not defined in the act, yet we come to know that we are going to talk about their appointment, we are going to talk about their remuneration along with remuneration of other directors as well. The direct appointment of other directors we have already discussed in the chapter of directors. Moreover, if it's a managing director or whole-time director, there also we have discussed the appointment already. Now, appointment has to be in accordance with section 152. Undoubtedly we know that. So we have section 152, we have section 160 for the appointment, and here the appointment is going to be in accordance with section 196. Clear? A manager plus whole-time director is possible. Manager plus MD is not possible. Managing director plus whole-time director is possible. So you cannot have a manager and a managing director at the same time. Simple reason being because manager is someone who has almost all the powers of the company, and managing director is also someone who has substantial powers of the company. So I made that chart for you, right? made that diagram for you, rather a circled diagram in which we are able to understand who a managing director is and who a manager is and why they are not possible at the same time in the same company. So no company can appoint a manager as well as a managing director at the same time. Whoever you appoint, their tenure is going to be maximum for 5 years. This does not apply to a government company. Right, so a government company may have MD which is going to hold office for 10 years, not a problem, right? But otherwise in all other companies, including a private company, you cannot have MD, WTD or manager for more than 5 years. So at once you can appoint for a maximum tenure of 5 years only, but before this 5 year ends, when 1 year is left for ending these 5 years, you can have reappointment. Right, so reappointment not earlier than 1 year before expiry. That means you cannot do that you have appointed a managing director on 21st Jan and on 22nd Jan you reappointed that person for another term of 5 years. No, it cannot be so quick. See, after 4 years we come to know, yes, about the work, how they have performed, how they are performing. So once we very well know about the work, then is the right time when we can go for reappointment. Reappointment is permissible before expiry of term, simple reason being because we don't want to hinder the flow of work. These are people who are involved in the core work of the company, right? Not exactly the core work, I would say the core management of the company. So the company cannot function without them, and that's why their reappointment is possible even before expiry of their term, but not earlier than 1 year. Section 196(3) tells us about disqualifications of appointment. That is, who can be appointed as MD, WTD or manager. Such person has to be within this age limit. Should not have attained the age of 70 is the language of law, although here I have mentioned 69 is the maximum because ultimately that comes out to be the solution. However, what you will write in examination is that at least of 21 years age and not attained the age of 70. Lesser than 21 is not permissible in or any case at all, but supposedly we have a very experienced person who is more than 70 years of age, who has attained the age of 70 or is even more than that, his appointment is also permissible provided SR is passed. Supposedly SR could not be passed, but the votes that he has got are more in favor than against, then we can take the approval of CG and we can still appoint such person. Okay. What are the other disqualifications? Someone who is undischarged insolvent, someone who has ever done suspension with the creditors, someone who has been convicted for imprisonment for more than 6 months. Such person becomes disqualified for life. He can never be appointed as MD, WTD or manager in any company. Okay. Now, appointment requires approval. There are 3 stages, my dear. BR in BM, OR in GM and central government approval sometimes, not always. So there can be 2-stage process also, board resolution in board meeting, ordinary resolution in general meeting, and that's how the appointment of these people will be made, right? This section of approval does not apply to private company. So in private company, you don't need this approval by central government or this approval by in general meeting. No, nothing required at all. In case of government company also, this subsection does not apply. So if it is a government company and someone needs the approval of CG according to this particular section, for that company, it will be exempted, right? So by far, MD, manager cannot be appointed together for 5 years at once. Then certain disqualifications, that is minimum age 21, maximum age 69, it cannot be 70 or more. If it is 70 or more, SR needs to be passed. Undischarged insolvent, not allowed. Suspension done with the creditor, not allowed. Then you have been convicted for more than 6 months, not allowed. After that, what is the process? The first step is to call a board meeting. Now, in the board meeting, you pass a board resolution, you appoint MD, WTD or manager, and in the next general meeting, you need their approval. So, in the next general meeting, you take approval. So, whoever is appointed by passing board resolution is being clearly told that this appointment is subject to the approval in general meeting. If it is approved, then great. If it is not approved, then you have to vacate the office. However, your prior acts, whatever you have done as the managing director or whole-time director, shall be considered to be valid. Okay. Whenever you appoint someone as managing director, WTD or manager, you have to file a form. For appointment of KMP, for appointment of director, we have a form DIR 12 for filing within 30 days of appointment. However, this form is not required because for managerial personnel, these three, you have a form MR1 which has to be filed. MR1 has to be filed within 60 days of this board resolution. Within 60 days. This marks the appointment of managerial personnel and it is the intimation to ROC. Now, in certain cases, you need the third approval as well. 3 stage I told you now, BR, OR and then CG. CG approval is not needed in all the cases. CG approval is needed in certain cases only. If you comply with conditions given in part 1 of Schedule 5, no need for central government approval at all. But if you don't comply with these conditions, then also you can be appointed subject to approval by CG. How do we get approval by CG? For that we file the form MR2. It has to be filed within 90 days of board resolution, and when we file that form, CG will either approve our appointment or it will reject our appointment. If we don't get the approval, then the person so appointed cannot continue as the managerial personnel. Okay. So what are the conditions which are given in part 1 of Schedule 5? There are 19 acts. If someone has been imprisoned even for a single day under these 19 acts, you have not complied with the conditions of part 1 Schedule 5, and hence either don't be appointed as MD, WTD or manager, or if you want to be appointed, seek government approval by filing MR2 with central government. Clear? Moreover, if you have been fined under these 19 acts for an amount exceeding 1,000, then also the same thing applies. What are the 19 acts? Central Excise Act, Customs Act, GST, Wealth Tax, Income Tax, FEMA, PMLA, SCRA, SEBI, Companies Act, Competition Act, IBC, Stamp Act, SICA, Food Adulteration, Essential Commodities, Fugitive, Economic Offenders, Foreign Trade Act, Industries Development and Regulation Act. Right? So you don't have to learn every act name by name, but you should be able to recall whether this is, if you hear a name, you should be able to recall whether this particular act is under those 19 statutes or not. So that is something which is important for you to learn. Next, if your convicted person is appointed as MP with approval of CG, no approval required for any subsequent appointment. Simple meaning that once you have taken CG approval, you don't need this approval again. You don't need this approval again. Second thing, so we have basically 4 conditions given in part 1 Schedule 5 which needs to be complied with by a person who is proposed to be appointed as a managerial person. If he does not fulfill these conditions, then his appointment is made subject to CG's approval. If CG doesn't approve, his tenure will terminate immediately, right? What are the 4 conditions? First is imprisonment or fine under 19 statutes. Second is detention under Conservation of Foreign Exchange and Prevention of Smuggling Activities Act. So even if you have not been imprisoned, you have not been fined, but you have been detained for any inquiry or for any purpose, then also you have not complied with the conditions. If you have completed the age of 21 years and not attained the age of 70 years, that means if you're below this or if you're above this, you have broken the condition. You must be the resident of India. So if you comply with these 4 conditions, that is no imprisonment, no fine under 19 statutes, no detention, attain the age of 21 and not attain the age of 70 and a resident. If you comply with all these 4 conditions, then you can be appointed without CG's approval just by passing BR plus OR. Otherwise, you need CG approval as well. Otherwise, you need CG's approval as well. Right. Apart from this, what do we have in appointment part? See, whenever you are calling a board meeting or a general meeting for the purpose of appointment, then you will clearly specify in the meeting that what are the terms and conditions of appointment, what is the remuneration that is being proposed, and other important details. Right. Section 196(4) and Section 196(5) does not apply to a private company. Section 196(2), 4 and 5 does not apply to a government company, as I have already told you that. Whatever appointments you're making, rather whatever forms you're filing, be it MR1 or MR2, it has to accompany the mandatory attachments. In MR2, you also have to furnish the copy of board resolution plus the copy of OR or SR. You will tell to the government that our board has approved, our members have approved the appointment, and now it's your turn because he is not complying with the conditions of part 1 of schedule 5. So you give the permission so that he can continue the appointment. And when you're filing MR1, it has to have board resolution along with it, and it is going to be, of course, certified. Fine. Okay, so we proceed further. Next is our managerial remuneration. Managerial remuneration, we don't get exact how much should we pay to our directors, rather we get an upper capping or upper limit as to what is the maximum remuneration that we can pay to our directors, to our manager, to our non-executive directors. There are 2 cases of remuneration. One is profits and one is loss or inadequate profits. We have in detail discussed about what do you mean by inadequate profits and when can we identify whether the profits are adequate or inadequate. Moreover, you understand profit and loss very well. So if there are ample of profits, there are adequate profits in the company, the overall maximum managerial remuneration limit is 11% of net profits. What do we mean by net profits over here, ma'am? Net profits will be computed according to section 198. Okay, fine. Supposedly we want to pay more than this particular limit, we need to get authorization in general meeting if we want to pay more. Authorization means simple resolution. Now, this 11% limit is the overall limit. We have 4 sub-limits also. 5, 10, 1, 3. When we are paying to our managerial personnel, if there is just one of them, 5% to him, maximum that can be paid. If there is more than one, then 10% is the maximum that can be paid to all of them. To other directors, if there is managerial personnel, that means he is there to work, so only 1%, and if there is no managerial personnel, 3% of net profits is the maximum that can be paid to them. Supposedly, we want to increase this limit. We can increase this limit by passing SR. But we want to pay our directors more. We want to pay our directors more than the limit which has been specified in the Act, but we don't have money to pay to our debenture holders, to repay our creditors, to repay our loan. In such a situation, Companies Act doesn't allow you. It tells you that first you obtain the approval of people you haven't paid their money. So if there is a default and repayment of dues to bank, public financial institution, to the debenture holders, to the secured creditors, so take their approval and then you take the approval of members for paying more. Okay, so prior approval of bank or PFI, in case it is applicable, and SR if it exceeds the above specified rate, if it exceeds the above specified rate. Okay, fine ma'am. Now, supposedly the company does not have adequate profits. There are losses in the company. Then whatever payment is going to happen will happen according to Schedule 5. Schedule 5 has different parts, part 1, part 2, part 3, part 4. Part 1 relates to appointment, we have discussed. Part 2 is divided into further 5 sections. We have section 1, we have section 2, which is the most important one over here. Section 1 tells us that if company has profits, pay according to section 197. But if company doesn't have adequate profits or if there are losses, then pay according to this schedule, section 2, item A and item B. What is it, ma'am? Item A is the limit given based on effective capital. What is the limit given, ma'am, based on effective capital? If your capital is less than or negative or less than 5 crore, then you can pay maximum managerial remuneration to your executive directors plus managers 60 lakhs, to others 12 lakhs. If it is 5 crores or more but less than 100 crores, then 84 lakhs, 17 lakhs. So exactly divided by 5 comes out your limit to other directors. If it exceeds 100 crore, if it is 100 crore or more than that but less than 250 crores, then 120 lakhs and 24 lakhs. If it exceeds 250 crore, 120 lakhs plus 0.01% of whatever is the excess to 250 crores. Likewise, 24 lakhs plus 0.01% of excess. Right. So this is the limit which has been given under item A. How do we calculate effective capital? Effective capital means paid up share capital, securities premium, your loans, your reserves and surplus, minus your investments, minus your losses, minus your preliminary expenses. So you get the figure of effective capital. Right. So whatever is the effective capital, supposedly you want to appoint a person as managing director, but you know that your company has been into losses for the past 10 years. Now, whenever you are going to fix his remuneration, you know that you cannot give him remuneration 11% of net profits. How? The company doesn't even have profit. So you know the maximum remuneration that you can pay to him in case of losses is calculated according to Schedule 5, Part 2, Section 2. So you come here, you check the effective capital of the company. Supposedly the effective capital of the company is 2 crores. So now you know that you can maximum pay him 60 lakhs per person per annum. 12 lakhs per person per annum. That is for other directors and this is for executive directors plus manager. Right, but these limits can also be increased provided you pass a special resolution. Right? Okay, fine, ma'am. Now, what is item B? Item B tells us about the appointment of director or managerial person in the professional capacity. What is professional capacity? Someone who is not holding the shares of the company or holding a subsidiary except for ESOP. And that too just 0.5% of the paid up share capital. Just a second. So if you are not holding any shares in the company, if you are not connected to the promoters, if you are not connected to the directors of the company, you are not related to them, and basically we are trying to eliminate the promoter group and you have the graduate level qualification. So if you have all these three, then you can clearly say that I am a director who is working in the professional capacity. If a person is working in the professional capacity, then he can be paid remuneration according to item A. That clearly means that in case company doesn't have adequate profits, they are suffering from losses, then they can pay remuneration to their directors, to the directors who are working in professional capacity. Like if we have Reliance Industries Limited, there may be Mukesh Ambani. He is not a person who is working in professional capacity. Why? Because he is connected to the company, he is related to the company, right? So someone who is working in a professional capacity can also be paid remuneration in case of losses, in case of inadequate profits, when SR is passed. So for such appointments, you need SR. I have told you the whole history, why law is harsh over here, what is the logic behind everything. But as of now, the only thing that you need to remember, just a second. The only thing you need to remember over here is that if you fall under item A, you have to pay, that the company can pay maximum managerial remuneration based on effective capital. And if you don't fall under item A, if you fall under item B, then also the maximum managerial remuneration that can be paid to any director is according to item A. So ultimately what you have to remember is the chart of effective capital, right? So effective capital, whatever category you fall into, you will pay remuneration according to that effective capital. Clear? Okay. So that is item A and item B. Now moving further, because we have a lot in schedule 5, first of all, let's try to wrap up schedule 5 and then we will switch to other points given in section 197. We have certain special cases also. Certain special cases as in the remuneration. Okay, before that, certain special cases, if the company has inadequate profits or if the company, this I have already told you, if the company has loss or inadequate profits, then if the director is employed in professional capacity, then he also may be paid remuneration according to item A only. What is item A? Item A is according to effective capital, right? If you want to increase even beyond that, SR is needed. If you want to pay within the limit given in schedule 5, no SR is needed. But if you are falling in the item A, then SR is needed even if within the limit. Fine. Now, limits under A or B are going to be available if, or you can say pay according to item A and B if. So these are the 4 conditions which must be satisfied, then only you can pay according to section 2 of part 2 of schedule 5. That means if a company has inadequate profits, you can pay within the limit of 60, 84, 120 and 120 plus 0.1%. Likewise 12, 17, 24 and 24 plus 0.01% to executive plus manager and to other directors if these conditions are complied with. That means you obtain the approval of an RC or board, there is no default in payment of dues, and if there is default, then prior approval of there is obtained, OR or SR, if it is within the limit, OR, if it exceeds the limit, SR, and details in explanatory statement. So there are certain general disclosures, certain information about the company, about the appointee, etc., etc. All that has to be given in the notice of general meeting. Okay, fine. Then we have some special cases. In these cases, the remuneration can be paid even more than given in section 2 of part 2 of schedule 5. If the remuneration is being paid by other company and in that company it is within the limit of managerial remuneration, plus you can say that it complies with the conditions of section 197, right? So if it is so and the remuneration to this company's directors are being paid by some other company, then that is permissible. If it is a new company, then for the first 7 years it is permissible. If it is a sick company and has been referred to BIFR, then for 5 years it is allowed. If it has, if a resolution plan has been approved with respect to a company under IBC, then for 5 years it is allowed. If the remuneration is fixed by NCLT, then it's allowed. Provided all these cases, remuneration will be allowed if the remuneration is not being received by some other company. If I have a managing director at 2 places and at some other place I'm receiving remuneration, then I cannot be paid extra remuneration if I fall into this category also. Certificate of no objection from creditors for extra payment. Certificate of no default to creditors. So these are the 2 certificates that will be made by the company secretary, and these are the 2 certifications that we need, apart from a confirmation that the person to whom remuneration is being paid is not deriving remuneration from any other company, right? Of course, all these cases that I am discussing with you are not so important ones. Now, one more thing that is given in Schedule 5, although it is given at the end, but I am discussing it with you right here. Okay. A person is a managing director in 2 companies. We usually think that we have to check limits for the respective companies only. That means he is an MD of A Limited. We have to check the maximum managerial remuneration in A Limited. And if he is the MD of B Limited, we have to check the maximum managerial remuneration in B Limited. Mr. X can get maximum from both places. It is not so. He cannot get maximum from both places. His total remuneration cannot exceed the maximum of the highest of all the companies from which he is getting remuneration. So this is one small point that you have to keep in your mind. Now, apart from that, we have section 4, which talks about the perquisites. Perquisites which are not part of managerial remuneration. One disclaimer I'm giving right here, this is just revision and recalling of all that we have studied in absolute depth, right? So if you have forgotten the provisions, please refer to the original videos, then only you will be able to recall the complete concept. If you remember the concept, then this revision is going to help you in immense manner. Now, perquisites, some perquisites which are being paid to the director do not form part of the managerial remuneration. What are they? If there is contribution to PF, gratuity up to a certain limit, leave encashment. So these 3 perks will never form part of managerial remuneration, just like sitting fees doesn't form part of that, right? But if it is an expatriate person, then children's education allowance, holiday passage, as well as that leave travel concession, that is also not going to form part of the managerial remuneration. Okay, so that was about Schedule 5, a lot of content. Now we come back to Section 197. Section 197 tells us the case. If you have adequate profits, you have a limit. If you have inadequate profits, you go to Schedule 5. And we have read about the whole Schedule 5 over here. Now, what else is there in Section 197? Because it is a huge section. How can we pay remuneration? We can pay it as monthly, we can pay it as percentage of profits, or it can be a combination of that. How do we determine remuneration? If it is given in articles or 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 SR, if articles say so. Now, excess remuneration, supposedly any director receives excess remuneration, then that has to be refunded to the company within 2 years. This refund can be waived if SR is passed, but before passing SR, you need approval of bank or PFI if there is default. Okay. Whatever you are being paid other than or whatever you are being paid in professional nature, that is not going to form part of your managerial remuneration. Usually the rule is that whatever company pays has to be within that limit of 11%, because it is considered as managerial remuneration, but your sitting fees is not considered as managerial remuneration. Your amount that you are paying in excess of in your professional capacity, that's not considered as managerial remuneration. Example, a doctor is also MD. So as MD, whatever he is drawing is managerial remuneration, but as doctor, if he gets some visiting charges, that is not managerial remuneration. That will not be considered as a part of a managerial remuneration, right? So when it will be considered as professional, if the services are of professional nature and director has such requisite qualification according to board or NRC. Now, sitting fees that can be paid over and above remuneration, we have to keep in mind maximum sitting fees that can be paid to anyone is 1 lakh. But one more thing that we have to keep in mind is that whatever you pay to a woman director as well as independent director should not be less than what you pay as sitting fees to other directors. So this is also one thing that you have to keep in mind. Okay. Section 197 is not applicable to government company when there is no default, of course, and Schedule 5. It's not applicable to government company. Section 197 is not applicable to government company, and this is only for, of course, public company, because in the very beginning it's written that the remuneration payable by a public company shall not exceed. So, of course, this section is not for private company as well as not for government companies. Now, apart from that, we have certain certain requirements, disclosure requirements, which is for every listed company. So listed company has to disclose that median remuneration, the increase in remuneration, increase in median remuneration, the permanent employees, average increase, average, that is average percentile increase, then whatever remuneration you're paying according to the remuneration policy or not, the name of top 10 employees who are drawing the highest salary, the names of employees, names and details of employees who are drawing salary more than equal to 102 lakh per annum. If they are employed for part of the year, more than equal to 8.5 lakh per annum, per month, right? So all these details are also needed. These are disclosure requirements which are needed. Now, apart from that, any insurance premium that is paid by the company to secure the liability of directors shall also not form part of managerial remuneration till the time the director is proven guilty. Okay. And then you have punishments, penalty for non-compliance, etc. Okay, moving on to our next section. Before we move on to section 199, let's quickly recall section 198. What is not to be or what is permissible credit? We have 4 things. What is allowed as income? What is not allowed as income? What is allowed as expense? What is not allowed as expense, right? So government subsidy allowed. Securities premium not allowed. Whatever you get from profit from reissue of forfeited shares not allowed. What you get on profit on sale of undertaking not allowed. Then profit on sale of immovable property, fixed asset over and above the original cost not allowed. If there is change in carrying value not allowed. If this is revaluation profit, notional gain not allowed as a credit. Now we come to debits. What is allowed as a deduction? Working charges, depreciation, bonus, special tax, interest on debentures, on secured loans, on unsecured loans, charitable contributions, whatever repairs are there, brought forward adjusted losses, compensation, insurance, bad debts, all these are allowed. What is not allowed? Income tax, not allowed. Any voluntary compensation that you are paying, that is not allowed. Then change in fair value and loss on sale of undertaking, that is also not allowed. So you have to keep in mind what is allowed and what is not allowed. Then we have a section 199 which talks about recovery of remuneration, not in the case where you have paid excess remuneration because you could not ascertain net profits in advance, but this is a case when the restating of financial statements occur. So in case of fraud, in case of non-compliance to accounting standards and all, you have a chance that there is a possibility of revision of financial statements. That means you are recasting your financial statements. It may lead to a situation that your net profit is reduced and thereby the overall limit of remuneration is also reduced and you come to know that you have paid excess remuneration. So in such a situation, company has been given the power that can recover the remuneration from MD, WTD, CEO, manager, whether past or present. So it can be past also. Maybe the person is now gone, and now you are revising the financial statements of some old tenure, and you come to know that okay, we have paid excess remuneration. So that is something which has been given power over here. Now, apart from this, section 200, a very small section again, it empowers the company to fix a limit. A limit on what? A limit on the remuneration. Supposedly the company has inadequate profits or losses. In that particular situation, company can fix a limit. Company can say that okay, Schedule 5 gives us the maximum limit of 60 lakhs, but we say that you are being appointed at a remuneration of 5 lakhs per month, but we will not pay you more than 2 lakhs if there is a case of losses, right? So they can do this while granting approval with respect to appointment or remuneration of MD, WTD, manager. Then we have a section, compensation for loss of office, section 202, an important section from your examination point of view. Who is entitled to compensation? MD, WTD, manager, and no other person. When is entitled to compensation? When there is a loss of office. When there is a loss of office. Fine. So if their office expires before their term, they have been appointed for 5 years, but they have been removed by the company after 3 years. So for 2 years, they will be paid compensation. What is the maximum compensation that can be paid to them? Lower of your unexpired tenure or 3 years. So if your unexpired tenure is 4 years, you have just completed 1 year and 4 years are remaining, you will get compensation only for 3 years. But if your 2 years are remaining, then you will get compensation for 2 years only. So whatever is your unexpired term or 3 years, whichever is lower. What remuneration will I get actually earned? How do I calculate it? Based on average of 3 years profit. If I have not worked for 3 years, such shorter period. Okay. There are certain cases where this remuneration will not be allowed. What are the cases? When the director has got another office pursuant to amalgamation or reconstruction, when the director has himself resigned, when the director, any disqualification is attracted to him and he has to vacate the office, when due to the negligence of director winding up has started, when not due to negligence of director, winding up has commenced either before leaving or within 12 months of leaving, and the amount after repaying all liabilities are not even sufficient to repay share capital. So in such a situation, his compensation will not be paid. And if he is found guilty of fraud or breach. Okay. If he is found guilty of fraud or breach. Again, an important section from examination point of view, appointment of KMP. This actually does not prescribe us the whole process of appointment, rather tells us the requirement of appointment. Listed company and public companies with paid up capital of more than or equal to 10 crores, it is mandatory to have these 3 people. 3 for different set of things. To manage the business, to manage the finance, and to manage the compliances. MD, WTD, manager or CEO, any one of them, and CFO and CS. Moreover, there is a rule which tells that private company with paid up capital more than equal to 10 crores has to appoint a CS. Only a CS, not others. Others are not needed. So a private company may or may not have MD. There is no requirement that you must have MD. And even in public companies, there is no such requirement. But if your public company has paid up capital more than equal to 10 crores or it is a listed company, then certainly there is a requirement, right? How are they going to be appointed? Of course, we have read about the appointment of these people. It's going to happen according to section 196 only. However, CFO, CS, they all will be appointed by passing a resolution at board meeting. If the office of any of these becomes vacant, that is the situation of casual vacancy which has arisen, it is going to be filled by the board within 6 months of the vacancy at board meeting only. At board meeting only. Fine. Now, there is one more requirement, that one person cannot be MD as well as chairman at the same time. However, it is permitted if the article so provided, if the company does not carry multiple businesses, or even if the company carries multiple businesses and it has appointed CEO for each business. It has appointed CEO for each business. Okay. Now, a person can be maximum MD in 2 companies, and that too if specific notice is sent and unanimous resolution is passed at the board meeting of the second appointment. And if you talk about KMP, one person can be KMP in only one company. It can be KMP in more companies also, provided those companies are only subsidiaries, right? However, he can become director with the board's permission, that's not a problem. And lastly, we have one more section, secretarial audit. It is again needed for certain big companies only. So we have listed company, we have public company with paid up capital more than equal to 50 crores, and we have public company with turnover more than equal to 250 crores, or we even have, it is also applicable to every company having outstanding loans or borrowings from banks or financial institutions more than equal to 100 crore. So in such a case, they have to get their secretarial audit done by a CS in practice. The report is going to be in form MR3, which is going to be annexed with the board's report. And just like an auditor gives a qualification or remark, the board replies to it, gives his explanation. Just like that, if CS also brings a qualification or remark, the board, it is the duty of the board to give an explanation on the same. After that, we have section number 205, which talks about the duties of company secretary. What company secretaries have to do. See, company secretaries are the king of compliances, right? So they have to check the compliances undoubtedly. So they will guide the board of directors about the compliances. They will also be responsible in convening the meetings, obtaining necessary approvals, presenting themselves in the front of authorities or regulators. Whatever board tells them, they are going to perform that. Whatever articles, whatever act tells them, they are going to do that. They have to ensure 2 compliance with the act and compliance with the secretarial standards. That's very important. And of course, perform the duties which are being entrusted to it through act or through board. In this particular chapter, we have discussed one case law of Bell versus Lever Bros, which you have to remember, Okay. Fine. Hi everyone. Let's now revise the chapter Meeting of Board and its powers. So this is a huge chapter containing a lot of sections and very important from your examination perspective. It commences with section number 173. But before we start section 173, let's have a basic understanding of how board takes its decisions. Now, why do board need to take any decisions? Because company is an artificial person and company cannot take decisions on its own. Hence, the decision making powers are being distributed over a board of directors as well as the shareholders, right? Whenever board has to take any decision, that means any issue comes up in front of all the directors collectively known as board, they have to resolve the decision. They have to resolve the problem. So a resolution is passed. What is resolution? Majority or you can say voting happens, right? That is, all the directors have to give their assent or dissent, whether they agree that this should be done or they disagree. If majority of the directors who are present and voting agree, then we consider that board resolution is passed. However, if they don't agree, we consider that the board resolution was put forward but it is lost. So, the decisions of board of directors are taken by a board resolution. Now, sometimes section 186, section 203, you also have Unanimous board resolution. There is a difference between board resolution and unanimous board resolution, that is UBR. This is that whoever is present at the board meeting, so all the directors present, they cannot refrain from voting, they cannot abstain from voting, they have to vote, and they have to vote in favor. So when all the directors present vote in favor, then a UBR is passed. The UBR is not required at all times, it's required in 2 sections in Companies Act, and in fact it's required under a rule also, but that is not something that we are going to consider right now. Now, how this board resolution will be passed? Undoubtedly, ma'am, all the directors should come together, then the issue will be told to them and then they will resolve the issue. That's how things happen. There is another way of passing board resolution, which is by circulation. That means the decision of board can be taken either at the board meeting or by passing the resolution by circulation. Now this board meeting may be virtual, it may be physical. It may be virtual, it may be physical. Earlier we had this provision that some matters cannot be dealt in at a virtual board meeting, but now there is no such restriction and all the matters can even be dealt at virtual board meeting or the board meeting that's being conducted through video conferencing, right? So this is the general thing. Now, one thing which is imperative from this discussion, which we come to know, is that we must meet, that the board of directors must meet in order to take decisions. And since their meeting is mandatory, they must meet. Companies Act has put in some mandatory requirements about board meeting. Starting from section 173(1), we come to know about the minimum number of board meetings which every company must conduct. See, board meeting is, the matters can take place or directors can vote directly from their place also through circulation, resolution by circulation, but that is something which is not allowed for every matter. There are certain matters for which it is clearly specified that you must meet to take decisions. Okay, you have read section 161. In section 161, there are 4 parts. Section 161(1), additional director. Section 161(2), alternate director. Section 161(3), nominee director, and 161(4), casual vacancy. Now, out of these 4, only 161(4) says that resolution at board meeting. That means this is a section which clearly specifies that the resolution has to be passed at board meeting only and the resolution cannot be passed through circulation. So a lot of times matters are being specifically reserved for board meeting. So for all the other 3 cases, you may have a resolution by circulation, but not for this one. Right? So there are restrictions which have been imposed. Moreover, we have a section 179. Which says that certain powers are exercisable by the board only at the board meeting. Okay, so although decisions can be taken through circulation also, but still it is imperative that the board meet, so that all the directors are aware about what is happening in the country and moreover to take the decisions which are being specifically reserved for board meeting. Okay, now what is the requirement? First board meeting has to be held within 30 days of incorporation, and thereafter every company is going to have a minimum 4 board meetings in every calendar year. In every calendar year. The gap between 2 board meetings is not going to be more than 120 days. So maximum gap 120 days. This is the general rule that we have for all types of companies. However, there are certain exemptions. Now, before I go on to exemptions, you have to understand that even if the meeting is adjourned, that also has to happen within the time limit specified. That means if you call a board meeting, it is adjourned and held after 4 months, the gap between 2 board meetings should not exceed 120 days. So this applies to adjourned meeting also. Now, for Section 8 company, we have the requirement minimum 1 meeting in every 6 months. I hope you understand and remember the difference that I have told you in classes. 6 months and half year. So that's a difference and you must understand and remember that. So Section 8 company, 1 board meeting in 6 months. OPC, small or dormant company, 1 meeting in half year. Minimum gap should be 90 days. Minimum gap. Here maximum gap was specified, here minimum gap. Now, private company which is startup, again the same thing as of OPC, small company, and dormant company. OPC with 1 director only, the section doesn't apply. See, meeting, introspecting, all this does not happen when you're talking about company. When you have to take the decisions of company and you are the only one to take decisions, why you will call a board meeting and meet with your own self? Obviously no, right? So you will not meet. Then comes your section 173(2), which talks about video conferencing. That means a board meeting may also happen through video conferencing. I'm not telling you over a telephonic call or a teleconversation. No, it has to be AV, audio, visual, both. So it may so happen, that means a director, if he is unable to attend the board meeting physically, he can also attend the board meeting virtually. So we have a whole procedure which is being listed when the meeting is happening virtually, or when the directors are participating virtually. So what is the procedure that's going to be followed? What are the requirements that are going to be followed? What is needed? So section 173(2) read with rule 3 and 4. So that's how we are going to read it. I mentioned this before that earlier there was rule 4 which prescribed certain matters which could be dealt only at a physical board meeting, but now those matters have been removed. That has been omitted. So now we don't have any matter which is specifically reserved for a physical board meeting. Okay, fine ma'am. So a director can attend in person or can attend through video conferencing only. The only requirement is that whenever a company is going for a virtual meet, it has to ensure that whatever setup it is establishing, it is capable of recognizing the people and recording the director's presence and storing everything along with date and time. Moreover, the chairperson and the company secretary who are responsible for convening a board meeting, they have to make necessary arrangements to avoid any type of failure and should take reasonable care for these. See, whenever a board meeting is happening virtually, it's a welcome move. Undoubtedly, it's a welcome move by the government. But there are issues with respect to confidentiality, security, and other like matters, right? If we are in a closed, compact conference room and a board meeting is taking place, we are sure that no one else who is not entitled or authorized is listening to us. But if we are sitting here out in open and everyone is participating through different places, there might be some insecure surroundings. There might be, right? So this raises a doubt on the confidential matters of any company. However, duty has been imposed on the director as well as the company. That director also has to ensure that you are not around anyone, and the company also has to ensure that the director is sitting alone and only authorized access is being given to the in the board meeting. Right? Fine. So what has to be taken care of? Security and integrity, availability of equipment. All the proceedings will be recorded and thereafter minutes will be prepared. You have to safely keep the records for future. You have to ensure authorized attendance only, as I just mentioned. However, if a person is disabled and request for an attendant, then that person will be allowed one, and ensure proper audio visual. Okay, so these are the requirements which must be fulfilled, and then only you can go for VC. What is the procedure? And one more thing, is AV mandatory? If a director is unable to attend a board meeting, he requests the company to provide for audio visual facility, and the company ignores and rejects the plea. Is it valid? I would say no. It is mandatory that you provide audio visual or video conferencing facility to the directors if they want that. Okay, For this, we also have a case law, Achintya Kumar. Now, what is the procedure? Because normal board meetings, people come, we count, we see things, right? We see things, we hear things, we are in a closed compact room. How the things are going to happen over video conferencing, that is also the procedure which has been laid down. What is the procedure? The first requirement. Well, if you want to call someone for your birthday, for your anniversary, for anything, you must give an invitation, right? Or even if it's not a very formal invitation, you must at least notify. If I want to call you for a class, I will at least have to notify when that's going to happen, where it's going to happen, at what time, place, all these details, right? Likewise, when company wants to call its directors, either physically or virtually, it's their choice. They have to at least inform the directors. How do they inform the directors? By sending notice. What is to be included in the notice? That we will read in section 173(3) later on. In the same section, we have the provision of notice also. But right now, I am concerned about one particular part in the content of notice, that is an option of VC. So when a director receives the notice of board meeting from the company informing when board meeting is going to take place, he is also given an option that the meeting may be, you can participate in the meeting through video conferencing, and this is the information with respect to that, right? So this is the disclosure that's given in the notice. I have received the notice, so I will attend the meeting. But this is something which is not very common. Although it's becoming common, but I have to intimate the company that I am going to attend through VC so that company can make adequate arrangements. If I don't intimate anything, it is deemed that I am going to attend in person. Fine. So I informed the company made adequate arrangements keeping all this in mind. And I attend the meeting through video conferencing in the mode as has been specified by the company. What happens is that at the board meeting, the chairman is going to ensure quorum. The next question arises, what do you mean by quorum? Quorum is the minimum number of directors which are required to constitute a meeting, only then the meeting can proceed. The question is, ma'am, do the quorum need to be physically present or it can be virtually present? See, it may be a situation that all the directors are virtually present. It may be a situation that some are physically present and some are participating through VC. Never mind. The directors who are physically present as well as the directors who are virtually present, they both are counted for the purpose of quorum. So we count the physical directors. If they are present, it's a physical board meeting, right? And that we don't need to compute further, right? So that is how the case is. Once quorum is there, the meeting begins. Then happens the roll call. Roll call is like an attendance. You must have seen a lot of CBI inquiries or police inquiries in movies and web series. What happens? They ask or they interrogate, and the first thing that they ask the accused is that, tell your name. Although I know the name, but still I ask them to tell the name for the record. Right, same thing is happening here also. The directors are being asked to tell their name, the place from their attending the meeting, the fact that they have received the agenda, and the confirmation that no one else is around. So they have to give this for the record. Although the chairman clearly knows that particular director, but still a roll call happens for the record. Then what will happen? Of course, the meeting has started, there will be people discussing and then there will be voting. So when the people are discussing, there might be these directors also who want to participate and contribute to the discussion. So whenever they contribute, they will identify themselves, and if their voice gets disturbed by any means of disturbance, they will repeat it. Okay. And then voting happens, voting again, roll call, voting. That's how it happens. The chairman at the end announces the summary, and everyone, if they have any objection, they can raise it. After that, the minutes are drafted. That is the true and fair correct summary is being recorded or is being put in writing. Once it is written, it is circulated to all the directors who attended the board meeting. Okay. So they have the chance, they have the option of raising or of commenting on the accuracy within 7 days. If they don't comment on the accuracy, or if they don't have anything to say, it is deemed approval, and if they have anything to say, accordingly they raise that objection. After that, it is going to be entered in the minutes book. The minutes book is prepared under section 118 and is open for inspection under section 119, right, and is signed by the chairperson. Clear? Fine, ma'am. Then we have section 173(3), which talks about the notice of board meeting. See, what are you concerned in the notice? You have to inform the directors. What do you have to inform? Date, place, time, venue, option of VC, and agenda. What are we going to discuss in the meeting? Right? And when we have to inform? That means if the meeting is commencing at 1 PM, I cannot call at 12 and say the meeting starts in 1 hour at this particular place. Right? A lot of cities where the traffic is huge or commuting takes time, they will not even be able to reach, even if they are willing to, and they leave immediately. Then also they might not be able to reach, right? So there has to be a sufficient time given to the directors to prepare themselves for the meeting, to make themselves available for the meeting. So ideally 7 days time is required. So company gives 7 days notice to all its directors. To all its directors. No particular form of notice, 7 days notice in writing to every director, either by hand delivery or by post, which has a proof, or by electronic means at his address which is registered with the company. At his address which is registered with the company. If you don't give notice, then 25,000 fine on officer in default. Fine. Now I said one particular point with a lot of emphasis, that is agenda. What is it? Agenda is the matter which we are going to discuss. Now, Companies Act does not make it mandatory to give agenda along with the notice. However, as a part of good secretarial practice, it must be sent, and if we talk about the practical world, it is always sent. Because the directors must know what are we actually going to discuss. However, this may so happen that 3 agendas are specified and the chairman wants to take up another matter which is required, and a board meeting is already in existence, so they can take up that matter, right? Simple reason being because the agenda is not mandatory under law. Fine, ma'am. Now, a lot of times this also happens that we don't have time. We don't have time to wait for 7 days to discuss a particular matter, and that's why we want the directors to come together at a shorter notice. So this is also something which is permitted for urgent matters, but there is a requirement. What is the requirement? That one independent director must be present in such a meeting which has been called at a shorter notice. Now, this may so happen that that no independent director is available or no independent director attends that meeting. So there is another solution. What is the another solution? It is supposedly a shorter notice is given, meeting called, no ID attends it, no independent director attends it. So circulate the decision to all the directors, and if at least one independent director ratifies it, then it's going to be valid. Ma'am, what about the companies in which we don't have independent directors? This is not the requirement, so you can call the meeting at a shorter notice. Simple. Okay. So this restriction has been placed on those type of companies only which have independent director. Okay. Sometimes students have this confusion that, ma'am, can board meeting be held on a holiday? Yes. Can it be held outside business hours? Yes. Can it be held outside the city or registered office? Yes. It can be even held outside India. Okay. So board meetings, that is something which is very well possible. Okay, fine. Now, Section 173(4) is only about the penalty that I've already told you. Moving on to the next part, section 174, that is quorum of a board meeting. Quorum is the minimum number of members which are required to constitute or to validly conduct a board meeting. 1/3 of total strength or 2, whichever is higher. Although articles may specify a even larger or higher quorum, articles don't have the power to specify a lower quorum as it will be non-compliance of law, but it can specify a higher quorum. So articles may say that in my company the quorum will be 5 directors. So irrespective of what section 174 says, you have to have at least 5 directors to constitute to conduct a board meeting. Fine. Okay, fine, ma'am. Now, what if the quorum is not present? What is going to happen? The meeting will be adjourned. If quorum is not present, the meeting will be adjourned according to what articles say. If the articles don't say anything, it will be adjourned to same day, same place, same time next week. Supposedly at the adjourned meeting also quorum is not present, the meeting will be cancelled. In general meetings, we have read the opposite. What we have read in general meetings is that if in the adjourned meeting also quorum is not present, the members who are present shall be deemed to be the quorum. This is not the case in case of board meetings. Fine. So in board meetings and general meetings, this particular provision is different. Fine. Okay. Now one more thing that you have to understand, that what is interested directors? Who are interested directors? We have a section 184, in which we talk about the disclosure of interest and like things. See, there might be a situation that I am a director and the company is entering into a contract with my father. So I would definitely want that this contract should take place because I'm interested. Somehow I have an interest, and therefore my discussion, any contribution to the discussion, any contribution to the voting cannot be unbiased. Or even if I am so competent to be unbiased, others might not believe it, right? They will still have the feeling that I will give a biased opinion only. So Companies Act prevents such a situation and tells the directors who are interested to not be a part of such meetings, to refrain yourself from participating in such meeting and voting in such meeting in which you are interested in any contract. Okay, fine, ma'am. Now, supposedly there are 9 directors, and out of which 2 directors are interested. So 1/3 of 9 comes out to be 3 or 2, whichever is higher. So out of these 7 remaining directors, you can have at least 3 directors who are present and they will constitute the quorum. That's not a problem, because interested directors, since they cannot participate in the meeting, they are also not a part of quorum. Fine. But let's imagine a situation. There are 9 directors and out of which 7 directors are interested. So if I calculate 1/3 of 9, it will be 3. We don't even have 3 directors who are not interested, because 7 directors are interested. We just have 2 non-interested directors. So in such a situation, there will never be a quorum. So for this situation, it has been specified that if the interested directors at any time is more than or equal to 2/3 of the total strength, then higher of number of disinterested directors or 2 directors shall be the quorum. Okay, it shall be the quorum. Now, one relaxation in private companies, because in private companies you will be interested in almost all the contracts and you are only the member, you are only the director. So if you are interested, you are allowed to vote. It's just that you have to give proper disclosure. So this does not apply to a private company. Now, for section 8 companies, quorum is different. 25% of total strength or 8 directors, whichever is lower. However, in no case it shall be less than 2. Okay. Now let's imagine a situation. Ma'am, my articles say that you need 5 directors to be the quorum and I have only 3 directors. So how? Because my 3 other directors have died. So how can I get 5 directors? How can I conduct a board meeting? In such a situation, you can call a board meeting even with lesser number than the quorum to increase the directors or to call general meeting. So for these two purposes, even if there is no quorum, the directors may act. Okay. Section 175. Passing of resolution by circulation. One thing that I have already told you, that resolution by circulation is not allowed in all cases. For the cases where it has been specifically mentioned that you have to deal with this item at board meeting only, then board meeting is needed. We are reading about the notice, we are reading about the quorum, all for the board meeting, not for passing resolution by circulation. So here we don't have any such requirement. What is the process then, ma'am? You draft a resolution, attach necessary papers which help the directors to take a decision, and send it to all the directors by hand delivery, post or email at their address. If you get approval by majority, then in the subsequent board meeting you will note it and include it in the minutes that such a resolution was passed. Okay. Sometimes it may so happen that I have received this draft resolution and I sincerely feel that this is a matter which should be taken up at the board meeting because it needs a lot of discussions. So, if 1/3 of directors require that the resolution should be passed at board meeting, then chairperson shall decline this particular thing and they will call a board meeting and the matter is going to be decided at the board meeting. Clear? The matter is going to be decided at the board meeting. Then comes your section 176, a very small section which just talks about the defects, or you can say validity. See, a lot of times it may so happen that we appointed a director, his appointment was defective, or some disqualification gets attracted to him, or he has to vacate some office, some grounds of vacation has been attracted to him, but he doesn't know, the company is not aware. In such a situation, he continues to act as a director even during that period of disqualification for say 6 months, 7 months. Now during this tenure, he has passed a lot of resolutions, he has taken a lot of decisions, he has entered into a lot of transactions with other parties, third parties. Once we come to know that his appointment was defective, that means he was not a director, proper director, and that means all the acts that he has done as a director are not proper. That means we have to reverse all the acts. The answer is no. Section 176 gives us a clarity that if the director appointment was invalid by reason of defect, disqualification or termination, then whatever acts are done by the company whatever acts are done by the director till company becomes aware of it, they shall be deemed to be valid. Okay. So after his appointment has been noticed by the company to be defective, thereafter all the acts will be invalid, but before that the acts will be valid. Okay. Before that the acts will not be considered to be invalid. Just a second. I try hard not to waste your time because I understand you are into such heavy professional studies, and at this particular time, at this particular point, if I am asking you to devote 1 hour with me, then I have to understand the importance of that 1 hour, and I cannot be like only half an hour to be productive and half an hour some chit chat or this example or that joke. So I refrain from cracking a lot of jokes when I'm into serious studies. Of course, for the flow, for keeping the classes entertaining, you know that we need stories, we need jokes, we need situations every now and then, so that has to happen. But of course, when I'm doing this continuous revision, I don't want to waste your time, and that's why I am trying to be as quick as I can. If you still want that the flow should increase somehow, you can increase the speed, but I wouldn't a lot suggest you that. For the topics wherein you are very confident, you may skip this revision, you may increase the speed, but for the topics you are not very confident, then this is going to help you only, right? So you can revise along with me. I'm trying to cover all the aspects of all the complete section. I'm not leaving anything for you. Now, section 177, audit committee. See, 177 has two aspects, audit committee as well as vigil mechanism, and section 178 has NRC and SRC. First, we'll talk about section 177, audit committee, or as of that matter, any committees that we're talking of. What are these committees? They're nothing but a group of directors of the same company. So they are dedicatedly being appointed to the cause of something. When I'm talking about audit committee, they have been some directors who have expert knowledge in finance, or who understand finance, who understand the financial statements and all, who understand how audit is being conducted, what is the importance of audit and like things. They are being included in this committee. What do? They see that which auditor should come, so they can give recommendation with respect to auditor, his remuneration. They can see how audit is being performed. They can see other internal controls of the company. They also have to approve some related party transactions, right? So they investigate into certain matters. So not just audit, but overall control of the company. So they have certain powers and they have some certain functions that they need to discharge. So they are going to oversee all those things. Okay. Ma'am, do we need audit committee in all types of companies? The answer is no. See, as the company grows and expands, then you need specific expertise areas. Otherwise, one person can handle it all. One person can handle audit also, he can handle the employees also, he can handle the operations also. So even if you have two directors, they can handle everything. But as company grows, you need different dedicated team to handle things. So the companies which are required to appoint independent directors, the same companies are also required to constitute audit committee. Okay, that means listed public companies or public companies which have paid up capital of more than equal to 10 crores, turnover more than equal to 100 crores, loans more than 50 crores. So these companies are required to constitute audit committee, which is mandatory. JV, that is joint venture, wholly owned subsidiary, dormant, not applicable to them. So they are not required to constitute. Now, we need to understand what is going to be the composition of audit committee, what are the powers that they have been given, what are the functions that they need to discharge or they need to perform, any disclosure and punishment for not doing it. The punishment is not given over here, it is given under section 178. So we don't have any punishment which has been specified in section 177. For the for contravention of section 177 also, the punishment is stated in 178 only. Okay, now composition. Minimum 3 directors, of which majority shall be independent and with the ability to read and with the ability to read and understand financial statement. They have to be financially literate, not just literate. Okay. What do? They recommend auditors' remuneration. One important point to note over here that they recommend. They cannot impose their decisions on the board. It is board's discretion only whether they want to appoint or nominate the auditors. Auditors appointment of auditors is a matter of ordinary business which is being dealt at the general meeting of the company, but board nominates the name of the director, nominates the name of the director, nominates the name of auditor. This name is being suggested by the audit committee. When an expert is giving you a recommendation, you must follow it. Although it is your life, your decision, you might not follow it. But when you reject that expert's recommendation, you must have a strong backing reason for that. The same goes for the board. Board, if you are rejecting, if you are not accepting the recommendation of audit committee, you must disclose the reasons in the board's report why not, along with the composition of audit committee. Fine. So they recommend, then they review auditor's performance, how the auditor is performing, so that we can give a feedback. No, this auditor is not correct. We should not reappoint this auditor, or this is performing brilliantly. What is happening, right? Then examining the auditor's report. If auditor has given any qualification in his report, then you are going to discuss it with the auditor why this particular qualification has been given. If it is a clean report, no problem at all. Right, but then you will see on what aspects auditor has examined, on what aspects auditor has not examined, what are the things that are happening in the company. So it also acts as a bridge between the management as well as the auditor. Then scrutiny of loans, assets, internal control, monitor use of public funds, additional things, and approval of related party transactions. So section 177 out here is read with section 188. Is read with section 188. One by one we'll do it. Now, to discharge all the functions, you also have been given certain powers. You can call for comments of auditors, you can review financial statements, you can discuss issue with the auditors, you can investigate and oversee vigil mechanism. We'll do this later after we do this. Fine. Now, what is related party transaction? What is related party transaction? For this, you need to understand what is a related party. Section 2, clause 76 defines related party. Company, the director of company, relative of director. KMP is relative. Any firm in which they are a partner. Any private company in which they are member or director. Any public company in which director or manager is the director and holds more than 2% of paid up share capital of the company along with its relatives. Then any body corporate according to whom you are acting, or the body corporate who is acting on according to you. Then we have holding subsidiary, associate, investing company, subsidiary of holding, any other as may be prescribed. So all these are related parties. All these are related parties. Company enters into a contract with the related party. Company is buying some goods from related party. Now this is a contract which is specified in section 188. I'll repeat. Section 188 has 7 specified transactions if entered into with related party needs approval. Approval from audit committee, approval from board, and if ceiling limit exceeds, then approval from members also. So audit committee approval, board's approval as well as members approval if ceiling limit exceeds. Members approval is needed only if ceiling limit exceeds, right? That means you need audit committee's approval also. So audit committee will grant the approval. Fine, ma'am. Audit committee has an option to give omnibus approval also. What is omnibus approval? It is one-time approval. See, if the transaction is not covered under section 188, of course you don't need to give any approval, you can only give recommendation. If the transaction is covered under section 188, then you need approval. But even within that, if the amount is less than 1 crore, and you don't take approval from audit committee, then audit committee can ratify it within 3 months, and if not, it is going to be voidable at the option of audit committee. But if the amount is more than 1 crore and the transaction is specified under section 188, then either you can take approval transaction wise, or you can take prior approval for maximum 1 year. Okay. For this, audit committee is going to check how repetitive the transaction is and how justified the transaction is. So based on that, they will give prior approval for the whole year, that okay, this is the maximum value, that during the whole year, maximum up to 1 crore you can enter into transaction, or maximum up to 10 crores. Per value transaction is not going to exceed 1 crore. You have to make these disclosures. These transactions are not permitted, and I'm going to review from time to time. Okay, so this, by imposing such conditions, audit committee can grant omnibus approval for related party transactions which need approval under section 188. Clear? If you contravene this, penalty is there. This is the penalty which is given under section 178. Clear? Now, audit committee is also required to oversee vigil mechanism. What do we mean by vigil mechanism? Vigil mechanism is set up for the benefit of employees, for the benefit of directors, so they can report their concerns, their grievances directly. A lot of times it happens that employees are being caught in the web of manager or the exact upper hierarchy. They don't have the access to move to higher authorities. They don't have any access to complain. They don't have any medium to complain, right? Even if they go to their own manager for complaining about him only, he's not going to listen. So for such purposes, for the companies, if your company is a listed company, if your company has accepted public deposits, or if your company has borrowings more than 50 crores, then in these situations it is mandatory for the company to establish vigil mechanism. Okay, now vigil mechanism is just a system where you can register your complaints, where you can have access to people who will listen and resolve your problems. For the companies which have audit committee oversees the vigil mechanism. In many companies, it may so happen that you don't have audit committee, but because you have accepted some public deposits, you are required to establish a vigil mechanism, and therefore you do it. So in such a situation, the board is going to nominate a person to oversee vigil mechanism. It also happens a lot of times that people take undue advantage of this system and they file unnecessary or frivolous complaints. So in such a situation, action will be taken against that employee also. I'm sorry. Clear? Fine. So this was about section 177. Now we move to section 178. NRC and SRC. Who is required to establish NRC and for what reason? NRC is again being established by those companies who are required to have independent director or who are required to constitute audit committee. So the same companies are also required to constitute NRC. What is NRC meant for? NRC is going to identify persons who should be appointed as director, who are deserving ones, who are required in the senior management, who should be removed. Formulate the criteria. In fact, even develop the criteria for evaluation of the performance of board, that he is a director who is performing really well, or he is in the senior management, he can be promoted as a board of directors. So this is the criteria that I have developed for evaluation of performance, like who attends at least 7 board meetings. So this is the criteria that they have maybe set up. Now this can be evaluated by them only, or it can be evaluated by some external agency also, or by the board also, right? So All this is the function of NRC. The composition of NRC is slightly different than audit committee. Here you need 3 directors, only non-executive directors, 3 or more, at least 3 non-executive directors, of whom half shall be independent directors, Now, whoever is the chairperson of the company can become the member of NRC, but he will not be the chairperson of NRC. He is the chairperson of company, he is an executive director, he can still be the member of NRC, but he will not be the chairperson of NRC. Clear? Okay. Then we have Stakeholders Relationship Committee. Ideally, when we talk about stakeholders, we include everyone, be it government, be it our suppliers, be it our employees, be it our vendors, all of them. But here, stakeholders mean the persons who have invested into the company. They are the security holders, they are shareholders, they are deposit holders as well, they are debenture holders, they are any other security holders. So collectively, if this number exceeds 1000, then comes the requirement of SRC, that is Stakeholders Relationship Committee. What are they going to do? Vigil mechanism for the reporting of complaints by employees. This is also for reporting of complaints or grievances or problems of stakeholders. Some might not have received the dividend, some has the issue with respect to share warrantor, etc., etc. There can be ample of things, right? So they can file their grievances. Stakeholders Relationship Committee, a group of dedicated directors who are going to oversee that all the problems are being resolved or not. So the basic idea is to protect the interest of all security holders, okay, not just your equity shareholders, but all the shareholders, right? Now, sometimes it may so happen that I'm genuinely trying to resolve a problem, but the other person is not listening at all or is in some other angle. So if you have tried to resolve the problem in good faith and you are unable to do that, then it will not be deemed to be contravention of the same. Okay, so no contravention if inability to resolve the problem in good faith. You have the penalty. What is the penalty? 5 lakh and 1 lakh. Section 177 plus section 178. So if you contravene any of the provisions of these sections, then this is the penalty. Penalty on company 5 lakh and penalty on officer in default 1 lakh. Right? Now, Section 179, powers of board, or I can say powers exercisable only at a board meeting. See, first thing that you need to understand for this section is that what board of directors can do. Anything that a company can do, its board can. What company can do? Company has to comply with Companies Act. The board also has to comply with Companies Act. Company has to act within the purview of its memorandum of association. So will the board. So you have to understand that anything that a company is permitted to do, its board can do. But there are some powers or there are some acts which only shareholders can do. Like altering the articles of association. A company is permitted to alter its articles even after it has been drafted, but this power has been specifically reserved for the shareholders. So such a thing cannot be done by the board of directors. So all the acts which a company can do within Act, MOA, AOA, or any regulation which the shareholders have imposed in general meeting. So within these powers, board can do all the acts which company can do, but board cannot do the things which are specifically reserved for the shareholders. Now, so board has ample of powers. Out of these ample of powers, there are certain things which have to be dealt at board meeting only. These powers cannot be exercised or these matters cannot be dealt through resolution by circulation. Okay. So BR in BM is needed. That is, board resolution and board meeting is needed for transacting these items. That means whenever you want to call money on shares. See, I have given you a mnemonic of learning this. I hope you remember that and you have learned this well. Calls on shares, buyback, issue of securities, approval of merger, diversify business, approval of financial statements, political contribution, takeover, appointment of KMP, internal statutory auditor, removal of KMP. And then you have big powers. Borrowing money, investment, and giving loan guarantees security. These two are covered in section 186 and this is covered in section 180. So section 180, company can borrow, company can give loan, company can invest, company can give guarantee, company can give security. Company can do this. It is not such that these things are not permitted. These matters can be dealt only at a board meeting. However, these three, that is these three big powers, BIG, big powers can be delegated. You call a board meeting, you pass a board resolution, resolved that the power to borrow money has been delegated to managing director of the company. He is now empowered to borrow money on behalf of the company. The maximum amount that he can borrow is this, etc., etc. So by imposing all those conditions, you can delegate the power to a managing director, manager, commercial, the principal officer of the company or branch, right? He can be a director also. So I hope that's clear. Now, board of directors has all the powers which company has, subject to act, memorandum, articles and regulations. Now, there are around 13 matters which require board resolution at board meeting. Only then they can be discussed or they can be dealt with. Out of these 13 matters, there are 3 matters which can be delegated, right? Now, we come to section 180, borrowing. This is the major thing that is given in this section. Section 179 tells us that the company can borrow, but to borrow it has to hold a board meeting. However, it may also be delegated to someone, but whatever power is delegated, it has to be within the limit which is given in section 180. What does section 180 tells us? Section 180 restricts the general and vast power that has been given to the board. The board can borrow. The board can borrow money. Section 180 tells, hold on, you can borrow only up to this amount. If you want to borrow more than this, you need to go to the members and take special resolution. You need to pass SR and take their approval. Moreover, you also need SR for these things. So in these 4 cases, SR is needed by the board of directors. Case number 1. Company wants to sell its undertaking. What is undertaking? Undertaking is a separate unit. How do we identify whether a particular venture is an undertaking or not? If that particular venture is giving you or is worth 20% of net worth, more than 20% of net worth, or it's generating more than 20% of income, then it's an undertaking. So if you want to sell off that undertaking, the board cannot take decision on its own. It has to go to the shareholders and get SR passed. If the company wants to sell only substantial amount of undertaking, not the whole undertaking, but a substantial amount of undertaking. What is substantial amount of undertaking? 20% of that undertaking. So if you want to sell that, then also you need SR. Clear? Sometimes on merger, you have received some amount. Company has received some amount. Now you want to use this amount for some purpose. It's not your money, it's the money of shareholders. You need to take their permission and then only you can use this amount. Supposedly, company has given some loan to a director. Now, can company give loan to a director? Yes, subject to section 185. Subject to section 185. Supposedly, company has given loan to a director and now the director is unable to repay. The director comes to the company and says, I need one more year. The board says, okay, fine, take it. Today is your day, tomorrow our day will come. No. The board does not have the power to give extension to the director. For this, you need SR. And lastly, if the amount of borrowing exceeds a particular limit, what is the limit that has been given? Borrowed plus proposed exceeds paid up capital, free reserves, securities premium. If this exceeds, then SR is needed. If it does not exceed, then SR is not needed. That means if your total borrowings are less than equal to paid up capital, free reserves or securities premium, then you don't need SR. If it exceeds that particular amount, then you need SR. In this section, in this particular point, we have a concept called as temporary loans. Temporary loans. What are they? Temporary loans. Like you have any short-term loans, they are not going to be part of that borrowing. For example, if there are short-term loans 50 lakhs, and then you have long-term loans again 50 lakhs, and the company proposes to borrow further 50 lakhs. So how will I compute this limit? I will say that my existing borrowings is 50 lakhs and my proposed borrowing is 50 lakhs. So 1 crore is the total borrowings. Now, if this amount exceeds this, then I need SR. So I will also calculate paid up capital plus premium plus free reserves and I'll see which one is higher. If my borrowings is less than or within that limit, then I don't need SR, otherwise I need SR. Okay. Section 180 does not apply to a private company. So in private company, the board can borrow any amount that they want to. They don't need to get any special resolution. So for private companies, you can borrow any amount that you want to. There is no restriction or there is no limit which has been imposed. Fine. Section 181. Contribution to bona fide or charitable funds. This is a very small section. Company wants to contribute to these funds, you can. If you want to contribute up to this particular percent, it is within board's limit, and if it exceeds more than 5%, then you need OR and then you can contribute. Then comes your section 182, which is political contribution. Again, a lot of students have this problem that, ma'am, why political contribution is so liberal that any amount, you can contribute any amount. So I have told you the logic behind this, right? See, any company other than government and a company which has been in existence for less than 3 years, they can contribute, they can give any amount they want to a political party. It's just that cash contribution is not allowed. They have to either contribute through check, draft, ECS or instrument. So they can. They just have to disclose in P&L account. Okay, fine. Contribution to National Defence Fund. This is an overriding section. It overrides everything. It says that if company wants to contribute to NDF, National Defence Fund, or any other approved fund for defence, go ahead. Even if your articles restrict you, then also you can. There will be no contravention, absolutely no. Okay, fine, ma'am. If you contravene this, there is a penalty. This reminds me, if you contravene section 179, section 180, section 181, that is powers of board, then you have restriction on powers of board, and even if you have charitable contributions. these three sections that we read before, they don't have any penalty which has been specified. That means, ma'am, we have been given that we have to discuss this matter at board meeting only. But supposedly we don't discuss this matter at board meeting and we pass a board resolution by circulation. What is the penalty? You have the penalty which is not specified for the section. So you go to a specific section of penalty, which is section 450, general section of penalty. So for all the sections where a specific penalty has not been specified under Companies Act, we have a general section, section 450. Now, disclosure of interest by director. A director has to give disclosure of interest. For this, again we come back to our related party. For the students who have not done very thorough study, might not understand that what is the connection between related party and section 184, ma'am. Section 188 is for related party, section 184 is not for related party, but you have to understand that there may be situations when both the section applies. Why? Because we have interest in our related parties. No matter how much we say that we are interested in our neighbors or this or that or this or that, no, we are interested in our family, our relatives, our people. Right? If my mother is being appointed as one of the employees of a particular company, I'll be interested in that contract. If some XYZ person is being appointed, I'll not be interested. So my interest is somehow connected with related party, though it may not always happen so. Now, if I am a director, I have to check in which companies I have the holding, in which firm I am a partner, where body corporate, where association I'm interested. And I have to give all these details in the first board meeting in which I'm participating as a director. I've been appointed as a director. In the first board meeting that I participate, I have to give this disclosure. Thereafter, every year in the first board meeting, I'll give disclosure. And if there is any change in my interest, then after the change in interest, the first board meeting that happens, there also I'll give disclosure. So I have to give disclosures in this manner. The form specified is MBP 1. I give the disclosure. The company maintains a register MBP 4 for recording these things. Okay, fine. There is another subsection, section 184(2), which is more important for examination point of view, that deals with specific disclosure. Specific disclosure. Now, this is when the company enters into a contract or arrangement with body corporated firm and the director of the company is interested in such body corporated firm. Now, this interest has been specified. Section 184 interest has not been specified, so you have to give disclosure in all respect. But here, you have to give disclosure only when you hold more than 2% of paid up capital, or your promoter or manager of CEO and partner or owner of the firm in case of firm. So you have to, if above situation arises, then this director must disclose his interest in the board meeting in which first time the contract is discussed, and he shall not participate in it. Supposedly there is contravention of the same, the contract becomes voidable, such director has to vacate office and there will be a fine of 1 lakh on interested director. On interested director. Okay. Again, it does not apply to private company, because in private company, the directors who are interested, they can vote. After giving the disclosure, they can vote. Fine. Moving on to our next section, section 185, that is loans to directors. See, the first thing, company is prohibited to give loan, guarantee or security to the directors of the company, the directors of holding company, the relative of such director, partner of such director, and a firm in which such director or relative is a partner. So you cannot give loan, guarantee or security to your director, to your directors of holding company, and to other concerns in which the directors are related. This is the logic, this is the section which it says, but then it has exceptions. See, section 185 deals with such a situations when there is loan guarantee or security to the directors or its concerned entities. If the director is not related to any entity, this case does not fall under section 185, because section 185 deals with loans to directors, etc. So we are talking about loans, giving loans to director directly or giving loans to the entities in which director is interested. So one is that prohibition, you cannot give to these people. Second is that you are permitted to give to certain people in which director is interested if you pass SR. If you pass SR. Okay, ma'am? Permitted to give loan to or guarantee or security to private company in which director is a director or member, body corporate whose board acts according to us, and body corporate in which we hold more than equal to 25% of voting power. So you can give to such entities in which director is interested. Loan can be given to such body corporates in which the director is interested if explanatory statement is given to the members and SR is being passed. Clear? Now, it's not applicable to private company if no body corporate has invested in that private company and the borrowings are within this limit and there is no default. It is also not applicable to government company if they have obtained the necessary approval from their respective ministry and no default of filing. Moreover, it is not applicable if loan is made to MD or WTD as employee. They are executive directors, right? That means they are employees of the company. So just like advance salary can be given to other employees, it can be given to these directors also. So fine. There might be some scheme which has been released by the company, and in pursuance of that scheme you can take loan. So you can take loan, not a problem. There might be a situation when you give loan in ordinary course of business like NBFC or banking company. It is their business to give loan. So just like they give loan to other customers, they have given loan to director also. But obviously when you give loan to your internal employees, to your internal directors, you give loan at some reduced rate. In any situation, your rate should not be less than the government security yield. If you will give loan to your wholly owned subsidiary, if you give guarantee to your wholly owned subsidiary, guarantee or security to your wholly owned subsidiary. So these are the exceptional cases where it is permitted, right? Where it is permitted. Moving on to next section. Loans, investments, etc. by a company, a very small section, section 186, or rather I would say it has two perspectives. Sorry, 186 is not a small section. It has two perspectives. One is putting a restriction on layering of investment companies, and the second is LGSI limit. First thing you need to understand for this section is what do you mean by investment companies, and since you have to understand about investment company, I am going to take you over here. Investment company is what? Whose principal business is investing. How do you identify whether a company is investment company or not? See, if I want to check, I open a balance sheet of any company. If that's a factory, it will have a lot of assets as plant and machinery. So I come to know, okay, a lot of manufacturing is taking place in this company. Likewise, if I open the balance sheet of an investing company, I will see a lot of assets as investments only. So more than 50% shall be them. Or if I check the P&L account, I will see more than 50% of its income is coming from that investment sources only. Right? So that's how I identify whether a company is an investment company or not. Although we can talk about any type of company, there is a restriction on number of layers of subsidiaries. But this section 186 talks about investment companies only. It restricts the number of layers of subsidiaries to maximum 2. It does not mean that a company cannot have more than 2 subsidiaries. Undoubtedly, it can have hundreds of subsidiaries, but it cannot have more than 2 layers of subsidiaries, which means a company has a subsidiary, this company has another subsidiary, and this company has another subsidiary. So layer 1, layer 2 and layer 3. So layer 3 is not permitted. Fine. There are exceptions. What are the exceptions? Banking company, NBFC with net worth more than 500 crore, government company, insurance company. These are the exceptions. One more thing, that wholly owned subsidiary is not counted as a separate layer, that is merged with that company only. And we have a company, this company acquires a foreign company. It becomes a subsidiary. Now this foreign company already has 5 subsidiaries, 5 layers of subsidiaries, I would say. 1, 2, 3, 4, 5. And this is something which is permitted in that country. So this foreign company is not doing anything unlawful. It is a lawful act. And now you want to acquire, you want to make this foreign company as your subsidiary. An Indian company wants to make this foreign company as their subsidiary. You can. So if Indian company is a foreign company, if the investing company is a foreign company with permitted more layers as per foreign law, it is allowed. Now we have other provisions of section 186. This is LGSI. Loan to any person or body corporate, guarantee with respect to the loan, security with respect to the loan, or investment in body corporate. This is shortly known as LGSI. For this, you need unanimous board resolution. So for giving loans to anyone, for giving guarantee, for giving security, or for investing in any body corporate, you need UBR. More than that, apart from UBR, if the ceiling limit exceeds, you also need approval from members. You also need approval from members. So what are the cases? UBR is must in all cases. If LGSI made plus proposed does not exceed the limit which has been specified. What is the limit? This is the limit. Higher of 60% of paid up capital plus free reserves plus securities premium, or 100% of free reserves plus securities premium. So you check this limit, you compute this limit. If your LGSI which is already there plus proposed exceeds this amount, you need SR. If it does not exceed this amount, no SR is required. Okay. Now, if it does not exceed the limit, no SR needed, you just need UBR. Plus you need PFI approval if there is default in repayment. If there is no default in repayment, no problem. Fine. But if your LGSI exceeds this limit, you need UBR. You also need SR, as well as you also need PFI approval. Ma'am, even if there is no default, yes. If it exceeds limit, you need PFI approval also. Fine. Apart from this, whatever loan you are giving, at least this has to be the rate. The minimum rate is going to be at least yield of government security closest to the tenure. Right, when we compute this 60% of paid up share capital, we have to take capital as both preference plus equity, as well as we deduct call scenarios which have not been received, because we are computing paid up capital. So whatever has been received, that only is taken. There has to be no subsisting default with respect to deposits. If there is, you cannot go for LGSI. Disclosure has to be fully made in the financial statements. Okay, full disclosure in financial statements. Apart from this, there is a register for LGSI which is being maintained, MBP2. This register is also going to be open for inspection by the members, and there is contravention. If the company contravenes these provisions, minimum fine 25,000, maximum 5 lakhs. So your fine can range between this. On the company and officer in default, imprisonment less than equal to 2 years, and again fine between that. Fine. Section 187, a very small section. Whatever investments you are holding, whatever assets you are holding, whatever securities you are holding, it has to be in your own name and in your own possession. Simple. That is the general rule. So company, if it is holding any investment, it has to be in company's name only. However, there are certain exceptions. Sometimes it is important that you have, for compliance of law, you have to hold it in your nominee's name, hold shares. Sometimes you give it to the bank for collection of dividends. Sometimes you have to transfer it to the bank for facilitating sale. Sometimes you transfer it, rather give it as a pledge for obtaining loan. Sometimes when your shares are in demat form, you're not the registered owner. Your depository is the registered owner and you're just the beneficial owner. So in these situations, investments might not be in your own name. For this, you have to prepare a register in MBP3, which is going to be kept at the registered office, preserved permanently, and is going to be open for inspection. Section 188. Again, we have a punishment also for this. 5 lakh and 50,000. Okay. Section 188, related party transactions. Now, see, whatever transaction is happening between the company and its related party, not all the transactions are covered under Section 188. First of all, if they are at arm's length price in the ordinary course of business, they are not covered. Secondly, if they are not at arm's length price in ordinary course, then we have to check whether they are covered under the specified 7 transactions. What are the specified 7 transactions? Sale, purchase, or supply of goods or material, disposing of property, leasing of property, availing or rendering of services, then with or without agent, that is clause E. Then appointment of OPP, office or place of profit, underwriting of securities. So these are the 7 specified transactions. If the company enters into a contract or arrangement with related party, the transaction which is specified under Section 188, you need BR. If it exceeds the limit, you also need OR. Simple. For BR, notice of board meeting will be sent with agenda explaining everything. At board meeting, resolution will be passed. The interested director is abstained from participating and voting. Next thing is we have to check whether it exceeds the limit or not. If it exceeds the limit, then notice of general meeting will be sent along with the explanatory statement, and the ordinary resolution will be passed. Related member will not vote. If it does not exceed, no OR is required. No OR is required. Right? Transactions between 100% subsidiary and holding, no OR is required. Whatever transaction is being entered with the related party will be adequately disclosed in board's report. The next question arises in our mind that, ma'am, what is the limit? What is the limit? If it exceeds limit, we need OR. But what is the limit? The limit, sale, purchase of goods, material with or without agent, more than equal to 10% of turnover, OR. Property more than equal to 10% of net worth. Leasing more than equal to 10% of turnover. Services more than equal to 10% of turnover. 2,50,000 per month and 1% of net worth exceeds that. Now, if the contract needed approval from board or approval from members, but that necessary approval was not acquired and the transaction took place, the contract was entered into, what happens in that case? Does the contract become void? The answer is no, it becomes voidable. First of all, it can be ratified within 3 months. Even if it is not ratified, it becomes voidable at the option of the board or the members, whatever the case be. Right? If there is any director who is involved, he is going to indemnify the company for the loss. Okay. You have the penalty. In case of listed company, 25 lakh. In case of unlisted or others, 5 lakhs. Right. Now we have very small sections remaining. Section 189, the register. So for section 184, for section 188, you have to maintain the register, MBP4. The register is going to be preserved permanently, kept in the custody of company secretary. when we give disclosure under section MBP1, that details are going to be included in the register. Register will be kept at the registered office. It is going to be open for inspection, produced at every general meeting, and there is a penalty for non-maintenance, that is 25,000. Then comes section 190, which talks about the contracts of employment with MD or WTD. See, whenever a company is appointing MD or WTD, it enters into a contract of employment. If there is no contract of employment, then it will at least have a memorandum of understanding where the terms are being boiled down to writing, right? Whatever it is, it has to be kept at the registered office of the company, and which is going to be open for inspection for members. This is not for private companies. So only in public companies this is going to be an open thing for members, right? Again, there is a penalty, fine less than equal to 25,000 and 5,000 respectively for company and officer in default. Section 191 is somehow related to 202, because here we compensate for the loss of office. Section 202 gives compensation only to MD, WTD and manager. However, this section gives compensation to all the directors. In case of sale of undertaking, sale of shares, takeover, there is any loss of office to the directors, then they can get compensation which is not going to exceed the compensation given under section 202. So within that limit, the compensation can be given. Compensation can be given undoubtedly to the executive directors as well as non-executive directors. So when I am talking about executive directors, there are some restrictions. Since they are involved directly in repayment of deposits, repayment of debentures, repayment of bank loan, taxes, then payment of employee dues, or dividend to preference shares or redemption of preference shares, if there is any default in all these, they will not be entitled to get compensation. The non-executive directors will still be entitled, but they will not be entitled, right? Moreover, an additional point to note over here is with respect to the quorum. Usually, see, one more important thing. When we are talking about section 191, we give compensation to all the directors by passing ordinary resolution. So when we are passing ordinary resolution, it may so happen that the meeting was adjourned, and at the adjourned meeting also the quorum was not there. So deemed quorum and the resolutions were passed. This shall not be passed. No deemed approval in case of this section. Okay, penalty 1 lakh. Then we come to section 192, restrictions on non-cash transactions. That is a kind of barter system. Again, this is not going to happen unless OR is passed. So if you want to enter into any transaction with a director which is non-cash, you have to take prior approval by OR, and the value shall be determined by the registered valuer. If it is not so obtained, if the approval is not so obtained, the transaction will be voidable at the option of the company. Okay. Lastly, we have section 193, that is contract by one-person company. It is absolutely nothing. One-person company is entering into a contract with the sole member, who is the director also. So what disclosures you will give, what board meeting you will hold, what permissions you will take, nothing required. You just have to enter it in the minutes book, and you have to inform the ROC within 15 days about the transaction into, because he is a related party, right? So that's how things will take place. That's it with this particular chapter. Okay, let's now revise the chapter of inspection, inquiry and investigation, starting from section number 206 till section number 229. So it has quite a few sections. The initial sections, that is 206, 207, 208 and 209, relates to inspection and inquiry, and the latest sections are all about investigation except a few parts which apply to all the cases. Now, there are three terms involved in this particular chapter, as you can very well see: inspection, inquiry and investigation. What do we mean by these three terms? Of course, these three terms are different, and you have to understand the difference, then only you will be able to understand the provisions. Inspection is something that happens, examination of books and accounts. Inquiry is like asking people, interrogating people and all that who are involved. And investigation is something which is next level, the detailed examination of things. So maybe first of all inspection is being ordered, and if the result of inspection creates even more suspicion that there could be some fraudulent activities going on in the company, then that results to investigation. So then investigation commences. Okay, so we have a whole flow of things. Let's start with section 206. Undoubtedly this is a revision class, so not everything in absolute detail, but I'm going to explain you in such a manner that you understand the whole chapter. Section 206, company files a document. Undoubtedly, we all know that with ROC, a lot of documents is being filed, a lot of information is being received by ROC. Supposedly, ROC receives any piece of information for which ROC finds that the piece of information is creating some suspicion or is incomplete and seeks for more information. So at that particular point of time, ROC sends the first notice to the company. First notice, not for inspection, not for inquiry, not for investigation, but just for seeking some more information. On receipt of information, there are possible cases that you reply or you don't reply. And even if you reply or you reply with some extended time, the reply may be satisfactory, the reply may be not satisfactory, or the reply may be inadequate. So in case where the reply is not satisfactory, the reply is inadequate, or you haven't replied at all, in all these three cases, registrar gets a reason to go for inspection. That means it will call complete books and accounts and papers and inspect them. Right, so it gets a reason to do so. It will record the reasons and send you the second notice, which is of inspection. So now again calling off books and accounts, not just some piece of information, but books of accounts for inspection. Right, how inspection will be carried out? Inspection will be carried out according to section 207. Here one more power comes into picture, which is of central government. Central government may also, if it deems fit, can order inspection. So maybe ROC carries out inspection on its own, or CG appoints some inspector and that particular person carries out inspection. So quite possible there are two cases. Whatever it be, even if registrar or inspector, whoever is carrying out the inspection on whatever grounds, they prepare a report of their inspection which they are going to submit to central government, right? Now when they submit the report, they also give a recommendation that what is their analysis, what do they suggest, that is there, could there be a probability of fraud involved? So should they go for investigation? What do they recommend? It's only their recommendation. This does not bind central government to initiate investigation. Okay, so it's just their recommendation. So report made and submitted to CG under section 208 with recommendation, then CG may carry out investigation. Now inquiry is also given in the same section 206, which tells us that any piece of information, again anyone approaches registrar or registrar receives some information and registrar is satisfied that some fraudulent activities are going on in the company, or there is non-compliance of provisions, or the grievances of people are not being addressed. So in these three situations, registrar, what will registrar do? Registrar will inform the company that these allegations have been imposed against you. If company can give an adequate reply, great. Otherwise, registrar will give an opportunity of being heard to the company undoubtedly, and thereafter initiate inquiry. In the same manner, CG had the power to initiate inspection. Here also CG also has the power to direct inquiry. So CG may appoint inspector for the same. So, and they'll carry out inquiry. So registrar or inspector can carry out inspection or inquiry as given under section 206. How they carry out inquiry or inspection as given under section 207. So after the order of inspection or inquiry is passed, registrar or inspector, they call for books of accounts and other papers, and it is going to be the duty of the officers and employees, past plus present. They are going to produce books and papers, furnish information and give all assistance. If they don't, imprisonment and or fine, and if they do, then registrar is going to conduct inspection or inquiry. What powers are given to them? They get the same powers as of civil court. They can also place identification marks, take copies of the books, papers, etc. And after they have completed the inspection or inquiry, they will submit the report to central government as given in section 208. Now, sometimes it may also happen that central government wants report in between inspection. The inspection is yet not over, inspection is going on, and central government wants some report, updation as to what is happening. In such cases, you have to submit interim report. So ROC or inspector will give interim report to CG if they so direct, and otherwise on completion of investigation, on completion of inspection or inquiry, final report shall be submitted. Now, this power to receive report has been delegated to regional director. Next, we have the section of search and seizure. This power is also given to registrar or inspector, but they have this power only when they take approval from central government. Sometimes it may so happen that they know, or during inspection or inquiry, they come to know that there might be a situation that some documents of the company are missing, and these documents may be destroyed by people involved, or they may be mutilated, they may be secreted, they may be falsified. In such situations, you go to the special court, you obtain the permission of special court, not of CG but of special court. So registrar or inspector, after obtaining special court's permission, they can enter into the places, they can search and seize the documents. Seize documents means you are taking the documents into your custody. Now, when you are taking the documents into your custody, the company might ask for some photocopies, so you'll allow them to take photocopies and seize the documents and take them with you. There is a limit of 180 days. That you can keep these seized documents only for 180 days, and thereafter you are bound to return them. If you want to examine more, then you can again call them back, right? So you have to remember two important points in section 209, which is entering into the premises with special court's permission and keeping the seized documents only for 180 days. Why am I telling you to remember these two important points? Because when we read the seizure under investigation, this is a seizure over here. When we read about search and seizure under investigation, that is section 220, then these 2 points are missing in that section. No restriction to inspector under investigation. They don't need to seek any approval from special court. Moreover, they also don't have this restriction of 180 days. So exactly replica section is 220 with that difference. Okay, so that we will read. Now, these were the 4 sections relating to inspection and inquiry. Now we start with the sections of investigation. We have 5 sections of investigation. 3 sections about investigation into affairs of the company, 1 section about investigation into membership of the company, and another section about investigation into affairs of other companies, related companies you can say, right? So 210, 212, 213, 216 and 219. So we have these 5 sections of investigation. Now we are talking about the first 3 sections first. That is, you are investigating into affairs of any company, right? What happens? When can you investigate? That is the first question. When can you investigate? See, after submission of a report by the inspector or ROC, after they have done inspection or inquiry, they submit the report to central government along with the recommendation. Central government receives the report, and central government, based on the report, decides whether I want to carry out further investigation or not. So on receipt of report, CG may order investigation. Secondly, the members of the company have a very strong doubt that some fraudulent activities are going in the company, so they pass a special resolution and they send the special resolution to company by suggesting that it is our wish that you must carry out investigation of this particular company. Again, CG has a choice. It may not. And in public interest also, CG may do so. So section 210, there are four grounds on which investigation may be carried out by central government. However, the fourth ground, that is in front of NCLT, some proceedings are going on where NCLT or court discovers that this company has some problems, some serious issues, and investigation must be carried out. So NCLT directs CG to carry out investigation. So since an order is being passed, it is the duty of central government to carry out investigation. So in the first three instances, CG has a choice. In the last ground, as mentioned in section 210, CG doesn't have a choice and must order investigation, right? So whatever it be, CG may order, CG must order. The order of investigation has been passed. After passing the order of investigation, CG appoints an inspector. CG appoints inspector. In some cases, if CG finds that the case is big, the case is huge, the case is serious, and it needs more expert people to be employed to investigate into the fraud or the scam, possible scam, then in such a situation, CG doesn't appoint inspector to investigate into the case, rather assigns the case to a special dedicated office, which is SFIO. Serious Fraud Investigation Office, just like we have CBI. Okay, that is section 212. I told you there are three sections of investigation into affairs of the company. One is 210, where there are four grounds on which CG orders investigation. Second is 212, where CG assigns the case to SFIO. And third is 213, where members don't go to CG by passing SR. Rather, some eligible members go to NCLT and files a complaint. They file an application, and NCLT in turn, if find suited, then orders CG. So you make a direct application to NCLT and NCLT orders CG, and thereafter investigation takes place. Ultimately, CG is only doing the investigation. CG is either appointing inspectors or assigning the case to SFIU. But then there are three sections. I hope you get that, right? Now section 213, where who can make an application to NCLT, either the members or any person. Which members? If the company has share capital, then at least 100 members or members with 10% voting power. If the company doesn't have share capital, then 1/5 of the members. They become the eligible members. With supporting documents and reasons, they can make applications seeking investigation to tribunal, or any other person can make application. But when any other person make application, tribunal has to be satisfied of any fraud or any unlawful activity, any oppression. If the company is formed for unlawful purpose, the management or the promoters are involved in fraud, or the members are not being given complete information. So in such situations, tribunal after giving reasonable opportunity of being heard to parties, then decide about investigation, that whether investigation should be carried out or not. And if tribunal decides that yes, investigation should be carried out, then it is going to direct CG the same, and CG is bound to order investigation. CG cannot say that okay, I'll see whether it has to be done or not. No. So CG will appoint inspector, and the inspector will prepare a report and give it to central government. Okay. Now comes into picture SFIU. What is SFIU? The establishment of SFIU is given in section 211, which is not a very important section. It just tells us about the composition. CG has the power that by notification it can establish SFIU, and it has done that. Head office, Delhi, it has director, it has experts, it has the number of employees, the terms and conditions as prescribed, etc., etc. Now, the important section is 212. Where central government assigns some cases of investigation to SFIU. Which cases, ma'am? That is completely a discretionary choice of government. However, in these 4 cases, government can do so. When government receives a report under section 208, when SR is being passed by the company in public interest, which is an open ground, and on request from Department of CG or SG. Central government is of the opinion that investigation must be carried out by SFIU only, then it assigns the case to SFIU. When the investigation is started by SFIU, all other investigating agencies will stop their investigation. Whatever their findings are, they are going to give it to SFIU. Fine? Okay. Now what will SFIU do? SFIU, the director of SFIU, that is the highest authority, will appoint an investigating officer who will also be called as an inspector under the Act. That person is going to conduct the investigation in the prescribed manner. Ma'am, it has to be a detailed evaluation, a detailed examination. So what do you think? How much power should be given to him? That means who he can call, who he can ask, where can he go, from where can he extract information, what can he arrest, etc., etc. So what powers are given to him? He is given the powers which are given under section 217. So we have a separate section for the powers which will be given to him. Okay, as of that matter, the powers which are given to any inspector during investigation. Apart from the general powers which are given to inspector, he also has a power, a very special power that you will not see in Companies Act ever, and the subsection which is very important, 212 subsection 6, 212(6), that gives the power to arrest. So the offences under this section are cognizable. That means people can be arrested even without warrant. However, not anyone can go and arrest them. Someone not below the assistant director, that is assistant director, additional director and director. On these orders only arrest can take place. Right? So if someone is found guilty of offence, that means I get some material information during my investigation and I'm sure that I have this evidence and I know that this particular person is involved in fraud. So I can arrest that person if I have that authority, undoubtedly. So I can go out and arrest that person. Now when I arrest that person, I have to do 2 things. First, arrest order plus this material information I have to give it to SFIU so that my department clearly knows that this arrest has taken place on these material grounds. Secondly, I have to produce this person in front of the magistrate or court within 24 hours. Now, when I present, the other person would want a bail, right? Bail will not be given so easily. That means there are strict conditions of bail. Bail will only be given when public prosecutor has been given an opportunity to oppose the bail. That means government lawyer. Our lawyer will go and oppose the bail. So once he opposes the bail, then court has to decide. If court is satisfied that this person who has been arrested is not guilty, and he must be released on bail. He's an innocent person. He will not commit any offense when I release him on bail. If court is satisfied of that thing, then only the court will release him on bail. But sick, infirm, under the age of 16 and woman, these are the 4 people who get relief. That means even if special court, if they want, they will not give an opportunity to public prosecutor to oppose the bail and grant bail. So it is at the discretion of special court in those cases. Okay, so here we have the whole part of arrest. Here we have the whole part of arrest. The inspector appointed will carry out the investigation, submit the report to central government. If central government directs, then it will also submit interim report, otherwise just the final report. And the report may state that yes, these people have committed fraud. So CG will take an action in pursuance of the report. What will be that action? CG will direct SFIO that okay, file the complaint and start the prosecution against these people. That means the legal proceedings will be started and adequately they will get the punishment. If some person has got some benefit, then to recover that benefit, CG will file an application with NCLT, and that is known as order of disgorgement. So NCLT will pass an order of disgorgement, that is for recovery of all the illegal gains that have been made by the persons, right? Okay. So that was about investigation into affairs of the company. Moving on to investigation into membership of the company. Sometimes it may so happen that on record there is another member, but actually the benefit is being passed on to some other member, which we call as beneficial owner also, as we have read in section 89 and 90 of the Act, significant beneficial owner and all that part. So sometimes it may so happen that the control is being projected as in someone's hand, but is actually not in that person's hand. So sometimes you need to figure out who the real owner is, then only we will be able to establish that what is the fraud, where the money is flowing, and a lot of other things. So if a complaint is being made by some person or suo motu by government or by reference by NCLT, then CG shall order, and in these situations CG may order investigation into membership. Right, to determine who are the financially interested people, who are able to control the policy, who are beneficial owners, etc. So for this regard also, CG shall appoint inspector who shall investigate into matters relating to the company and membership and shall report it to central government. Now, when you are discovering about the membership or when you are discovering about the ownership, it may so happen that you want certain restrictions to be imposed upon securities. You want to find out who the security or where the benefit is going on, and before you could reach that person, the transfer of securities is taking place from one person to another to another. So you want this to break. In such situation, or if any person files a complaint, then tribunal understands that I must find out the details about this particular security, and to find out the details I must put some restrictions. In such situation, tribunal can put restrictions, but not for more than 3 years. This is something which is very important for you to remember, that tribunal, although has been given the power under section 222 to impose restrictions, yet the restrictions cannot be imposed for more than 3 years. Okay, now investigation into affairs of related companies. Related companies does not mean the related party definition that we have read. Related companies means the companies or the entities which have been specified in section 219 only. So when an inspector is investigating into the affairs of a company under these 3 sections, he believes that to find out the whole truth, I also must investigate into these related companies. Then after taking approval from CG, he can do that. Now, what are the related companies? Subsidiary, holding. Subsidiary of holding. It could be past also. Managing director, manager, employee. Any body corporate which is being managed by the managing director or manager. It may so happen that currently you are the manager and it was being managed by the past, or currently it is being managed, you are the past manager, so is, was, it could be, right? Any body corporate whose board of directors includes the nominees of these companies, or any body corporate whose board of directors are acting according to the directions given by the directors of this company. So in such situations, there is a link between these two companies. And quite possible there are a lot of transaction flows from one company to the other related company, and to find out the whole truth where the actually money is going, I need to investigate into affairs of these companies also. So after taking central government's approval, you can do that. Next is section 221. Next is section 221, which talks about freezing of assets. Freezing of assets of a company. Freezing of assets of a company. See, if central government makes a reference, or if a complaint is made by members specified under section 244, that is oppression and mismanagement, or if creditors file a complaint, the creditors who have at least 1 lakh amount outstanding, or any other person, they file an application to tribunal, and tribunal believes that company might be disposing of, might be selling off some assets which is not in the best interest of the company, which is prejudicial to the interest of creditors, members, then in such a situation, tribunal can put restrictions on these assets, just like it was putting restrictions on securities to find out the whole truth. It is putting restrictions on assets also. It is freezing the assets. That means it is giving the directions that you cannot remove, transfer or dispose of the assets. But again, the restriction is going to be for maximum 3 years only. It cannot be for more than 3 years. It cannot be for more than 3 years. Okay, ma'am. Now, section 220. I told you we have a section 209 which is exactly replica of 220, except for the two differences that I told you. So during investigation, if inspector has reasonable grounds to believe that books are going to be or are likely to be mutilated, altered, destroyed, falsified, secreted, then inspector may enter, seize and search and seize documents and return them on completion of investigation, not within 180 days, and no permission from special court. Okay. Fine. Okay. Now, the next section that we are going to discuss is inspector's report. Here I'll give you some clarification. We have read about inspection and inquiry and its report under section 208. So, when inspection or inquiry takes place, the report is submitted under section 208. When investigation takes place, the report is given in section 223 and the action that has to be taken after receipt of report is given under section 224. However, when investigation is being carried out by SFIO, then what report has to be submitted, in what manner, what actions shall be taken after submission of report, all that part is given in section 212 itself. Okay. So section 223 as well as section 224, it is about investigation, it is for the cases of investigation, except section 2112, that is SFIO. Fine. So apart from the inspector appointed under section 212, all other inspectors after investigation have to submit a report undoubtedly to central government. If central government wants an interim report, then you also have to give an interim report. The report is going to be obtained the report is going to be authenticated by seal or certificate of public officer. Remember, I explained you the whole procedure of public officer in the class, in the main class, right? That who is a public officer, how the things happen, so that you get that practical knowledge as well. And a copy may be obtained by making an application to central government. So if you want to know what is the result of this particular investigation, what happened, what was the scope and everything, you can obtain the copy of it by making an application to central government. Central government is going to give you that. Okay. Now, when central government receives the report, what actions it can take in pursuance of the report? Central government receives the report, central government studies the report and finds out that okay, these 5 people were involved in fraud. So undoubtedly these 5 people have to get punishment. So central government will initiate prosecution against these people. So legal proceedings will be started and adequately they will be punished. Now, this is one thing. Central government, after receiving the report, finds out that it's important that the company must be closed. So we must sell off the assets, pay off the liability. So winding a petition may be filed by CG. It may also so happen that central government finds the case of oppression or mismanagement, and hence CG files an application to NCLT for obtaining relief from oppression and mismanagement, or both application may also be filed. So first thing, CG initiates prosecution against the defaulters. Second, makes an application for winding up or relief from oppression, or both. Third, files a suit for recovery of property or damages. It may so happen that the company involved has lost a lot of property because of fraud. So for recovering that property, CG has filed a suit on behalf of the company. And when CG has filed a suit, CG will be indemnified by the company because CG is recovering the property on their behalf, right? And lastly, disgorgement. If someone has got illegal gain out of this fraud, then that money can be recovered from him. How? CG makes an application to Tribunal, because Tribunal is the judicial authority over here. CG is not the judicial authority. So CG will make an application to Tribunal. Tribunal will pass the orders of recovery, that is orders of disgorgement. Okay, fine. Now, see, we also have a section 225 and 214, which are both related type of section. Often there is a confusion amongst students that, ma'am, so much of investigation is taking place, then who is going to bear the expenses of investigation? That is the question, right? See, one is section 214, which initiates, just to rule out not so serious applications. What happens if someone has filed a complaint to CG, or there is SR being passed by the company and CG receives that SR and CG initiates investigation. Before appointing inspector, it will ask the applicant that you deposit a sum not exceeding 25,000 as a security, because we are going to take an action on your request. What if the request is some fake evidence and some false request? So you submit some security. If this turns out to be false, then you will not get your money back. But if this turns out to be true and actually some fraud has taken place and this results in finding someone as guilty, then this money will be refunded to you. So if it doesn't end up in prosecution, then we will use that money to carry out the inspection investigation, and we will take the help of company, whoever is involved in whatever not so in order things. Otherwise, if this results in prosecution, that means the end result of investigation is such that we find some people guilty. So whoever has been found guilty, we will recover from them. If if the investigation ends up in recovering some property of the company, then from that property, central government will have first charge on that property. It can use that property to reimburse the money. So all that portion is given in section 225. Right? So that's how central government obtains, or central government gets money to carry out this process of investigation. If it doesn't end up in prosecution, of course, the applicants and the company concerned. Fine? Okay. Now, procedure powers of inspector, section 217. So whoever is carrying out investigation and some part of inspection and inquiry, they have these powers. What are the powers? They can call for information, and it will be the duty of past plus present officers to preserve books, to produce books, and to give all assistance. Now, whenever an inspector is taking books, they can keep them in their custody for only 180 days. Ma'am, earlier you told that there is no limit. I told that there is no limit under section 220. That is the section of seizure. This is a normal section when you ask for books and papers and you have taken books and papers. There you have entered into premises and you have seized the books and papers. Okay, so that is the difference. Now you can examine people on oath. Which people? Anyone? No, not anyone. The employed officers, you can examine them on oath, but if you want to examine some other person, then you have to seek approval from CG, and then you can do that. You will get the same powers as of civil court. All the police, other authorities, government, they all are going to provide you assistance if needed when you take the approval from CG. There is one special point in section 217 which talks about reciprocal arrangements. What happens in that? See, it is very easy to discover truth, find out evidence, inquire people in our country, but when the laws change, to get evidence from a foreign source is extremely difficult. For that, if we want to obtain some evidence from a foreign country, we have to check whether our government has a reciprocal arrangement with them or not. If they have a reciprocal arrangement, it gets extremely easy. How? We will tell our Indian court that there is an evidence which is out there. Indian court will send a letter of request to foreign court. Foreign court will summon that person who is concerned, will inquire that person, will collect evidences and give it back to the Indian court, and Indian court will give it to the inspector concerned and he will prepare the report. Likewise, since it is a reciprocal arrangement, so give and take, foreign court, if they want some evidence from our country, they will send a letter of request. Our government will forward it to Indian court. Indian court will either summon the person himself or call the inspector and assign the case to him. Inspector will investigate, inspector will prepare a report, collect evidences, give it to the court, court will give it to the government, government will give it to foreign court. I hope you get the procedure. So it's give and take. These reciprocal arrangements may be there. Okay. Now, another section, protection of employees. The employees get sometimes scared to disclose the insider information of a company during investigation just because they may be fired later. To protect them, if an investigation is being carried out under these sections, all the 5 sections are mentioned over here, or some pendency of proceedings of prevention of oppression and mismanagement, in both these cases, if the company proposes to suspend an employee, dismiss him, demote him, right, or change his terms of employment to his disadvantage, then in all these cases it will not be allowed unless you take approval from tribunal. So you have to file, the company has to file an application to tribunal that I am proposing to dismiss this particular employee when the investigation is going on. The tribunal will not give you a reply like, okay, fine, you dismiss him, or don't dismiss him. No, you have to wait for 30 days. Within 30 days, either tribunal will send a notice of objection or tribunal will stay silent. If you don't receive any objection notice from tribunal within 30 days, then company can proceed and take action against that employee. Okay. Now, if tribunal objects and the company is not satisfied with it, company can file an appeal to NCLAT within 30 days. Okay, apart from this, we have section 226, which is a very small section and states that doesn't matter you have passed SR for winding up, doesn't matter any winding up proceedings are going on, doesn't matter there's an application for oppression and mismanagement. These things are not going to affect the investigation. So, despite that, if an investigation comes into picture, it is going to be carried out. We have another section, section 227, which tells us an inspector cannot compel the legal advisor to disclose any information other than client's name and address. Likewise, an inspector cannot compel banker to disclose any information other than information related to the company concerned. Banker cannot be compelled to disclose information of other customers, right? And section 228, which tells us that the provisions of inspection, inquiry and investigation are going to be applicable to foreign company also. And section 229, that if in the whole process you do some fraudulent activity, that means you give some false answer to the inspector, you make some false entry, you try to destroy some paper, anything like that, then you will be attracted to the section of fraud. What is the section of fraud which gives the punishment for fraud? It is section 447, right? So that's it with the revision of inspection, inquiry and investigation. Okay, let's now revise the chapter of compromises, arrangements and amalgamation. In this chapter, we have sections 230 to 240. Not a very huge section, but sometimes the students don't understand the underlying concept in this chapter, and hence they end up thinking that this is a very boring chapter. However, if you ask me, this is the most relatable chapter to your practical life. If you have to, or if you're planning to pursue your career somewhere in the field of mergers, acquisitions and like, then undoubtedly this is one such thing that you must know. If I share with you, although we have discussed all this in our regular class, but if I share with you one of the scheme of compromise, scheme of amalgamation arrangement, you can clearly see that under sections 230 to 232 of Companies Act 2013. So this is not something which has been drafted by me, but it is the scheme of amalgamation which actually happens in the real life, in the practical world, between Bharti Infratel and Indus Towers, right? So actually you find the relevance of the section. It is absolutely, of course, along with other provisions, this is something which is very important. Now, since it is a revision class, we cannot go into very much depth about the terms, and I have already explained you the terms. However, the chapter involves three broad terms, that is compromise, arrangement and amalgamation. If I talk about compromise, compromise means some type of sacrifice. The sacrifice could be between members and the company, or between creditors and the company. So might be creditors are sacrificing something for the company. Maybe the company is not in a very good financial state, and so the creditors are sacrificing some portion of their debt, or maybe some interest portion or something like that. So that is a scheme of compromise that's taking place. Arrangement is a kind of residuary terms which includes every other thing which is not compromise or amalgamation. It could be some reconstruction of capital, alteration of capital, etc., etc. Now, what do you mean by amalgamation? Although the chapter heading uses only the term amalgamation, when we switch to the sections, we find the term merger, amalgamation, demerger, all of that. So what do we mean by that? If I talk about merger, it could be by formation of a new company or by acquisition. By acquisition means or by absorption means X plus Y is equal to Y. So you don't form any new company. An old company absorbs another company into itself. Or the merger could be by formation of a new company. So I could say that maybe A plus B is equal to C. So there is a new company which has come into consideration and two old companies have lost its existence. Now when I switch to amalgamation, amalgamation could be in the nature of merger or could be in the nature of purchase. In the nature of merger, if it satisfies all the criteria, right, and if it doesn't satisfy all the criteria, then it's going to be in the nature of purchase, right. That is something which is not needed because the Act does not identify or does not recognize any difference between two and has not stated different provisions for amalgamation, merger in the amalgamation in the nature of purchase, demerger. No, there are like provisions for all these cases. Okay, and we have section 230 which is for compromise or arrangement and section 232 which is for merger, amalgamation, demerger. However, section 232 is not complete. It does not give us an elaborate, a detailed and exhaustive procedure as to how merger and amalgamation should be proceeded with, and redirects us to section 230. So I hope you understand that the most important section of this particular chapter is section 230 undoubtedly. Fine. So we'll start with the revision. The very first section, section 237, where there is a power to make compromise or arrangements with creditors as well as members. So company may enter into any scheme of compromise or arrangement. As I told you, example could be internal reconstruction, example could be some debt restructuring and like things, between company and creditors, between company and members. So in this situation, they have to take permission of NCLT. For taking permission, they will make an application. There is a whole procedure which has been given under section 230. It starts with making of an application. Members, creditor, liquidator or company, they can make an application in form NCLT 1 to NCLT. This application will be accompanied with the affidavit containing disclosure, copy of scheme and fees. Now this may be accepted, this may be rejected. Once it is accepted, the next step is that NCLT orders to hold meeting. Hold meeting of whom, ma'am? NCLT is concerned that are all the creditors, are all the members who are concerned, who are involved, happy about it? Right? Are they happy and have they actually approved it? That is the main concern of NCLT at the first place. So NCLT asks the company that send notice to your creditors and members and take their approval, and thereafter report to me whether they have approved or not. Then we will consider and sanction your scheme. Okay, so NCLT orders to hold meeting. Chairperson calls the meeting by sending notice. The notice which is sent to the members, to the creditors, is accompanied by the details of compromise or arrangement, valuation report, effect and other matters. At the same time, one notice is also sent to the statutory authorities. Statutory authorities could be income tax, could be central government, SEBI, Registrar, Stock Exchange, Competition Commission of India and all that. Why it is sent to the statutory authorities? To seek objections from them. If they have any objection, they can also give objection within 30 days. Okay. Now this notice is also advertised, English newspaper, vernacular newspaper, and is placed on the website. If it is a listed company, it's also sent to Stock Exchange and SEBI. Fine. Now, after sending this notice, advertising it, placing it on website with all these details to creditors and members, then the meeting is held. In the meeting, the creditors members will vote. Accordingly, they will give their approval, right? Fine, they will give their approval. How can they vote? They can vote in person, they can vote by proxy, they can vote by postal ballot. So an option of postal ballot is also made available to them. Now here, the approval is not a normal one. That is, if there are 1,000 members, we cannot say that if 600 members have approved, then we accord the approval. No. The approval is a two-way approval. Majority of members holding or representing 3/4 value, and this is not of total, it is of the members who are present and voting. Okay. So if the number of members is 500, then majority comes out to be 251. So at least 251 members holding 3/4 value share capital. Say supposedly the share capital is 10 lakh, then at least 7,50,000 share capital should be held by these 251 members who have given the approval. If that is so, then only we will consider the scheme to be approved. The same goes for the creditors also. Creditors majority in number representing at least 3/4 value. Okay. After this approval is taken, the next thing is that NCLT also needs auditor's certificate that whatever accounting treatment is going to be taken place in the books, that will be in accordance with the accounting standards as well as Ind AS applicable, right? So after it has been approved, after CA certificate has been received, then tribunal sanctions the scheme, of course after considering the objections of statutory authorities. Whatever order is passed shall bind everyone. However, the tribunal shall send the order to the company within 30 days, file it to registrar. What is going to be the contents of order? What is going to be the contents of order? Variation of rights, that is the first thing. Variation of rights means what? We have a section 48, which tells that if you have to vary the rights of a shareholder, then in that situation you need to take their approval, right? If it affects some other class, then you take approval of that class also, etc., etc. So there is a procedure which has been given. In case your compromise or arrangement is somehow altering the rights, then you must follow section number 48. Section number 48. Okay. Then to dissenting shareholders, exit offer is given. Conversion of share capital. When preference share capital is being converted into equity under a scheme of compromise or arrangement, supposedly there was some preference capital on which preference dividend was not paid for 4 years. Now under a scheme of compromise, they are converting. Under a scheme of arrangement, they are being converted into equity. Option will be given to them that those pending 4 years dividend, either you take in cash or an equivalent amount of shares. Get that converted into an equivalent amount of shares. Fine. Then all the proceedings of BIFR shall abate. What do you mean by proceedings of BIFR shall abate? See, if it is a sick company, it moves to BIFR to revive itself. Now, supposedly we have interacted with our creditors and the creditors have somehow reduced our repayment burden in some manner. Now the company itself is in a position to grow. Earlier the company, all the money that the company was earning was going into the EMI. Now it has been relaxed and the company has funds to invest into the core business and thereafter earn huge profits. Right, so there is a ray of hope that the company will automatically come back to its good financial state post this compromise or arrangement, and hence that BIFR proceedings are not required, so they shall come on hold. Okay, so and this buyback or reduction of capital, what I have written, it simply means that if you have to go for buyback, then you will also follow the scheme of buyback, that is you have to follow section number 68. Okay, and now we come to section 231. Tribunal has sanctioned the scheme. Tribunal has the power to supervise its implementation, make modifications as and when needed to implement, give directions, and if at all tribunal finds that it is impossible to implement the scheme in a manner as it was sanctioned, and it will not bring a right effect, and if not implemented, the company will not be able to pay its debts. That means company is in a kind of insolvency state. Then in such a situation, tribunal might pass winding up orders, that is closing down the company. Okay. Fine. Now we come to section number 232. Merger and amalgamation of companies. So we are talking about the case of merger, amalgamation, demerger, all of that. Whenever an application, here also you need NCLT approval, here also there is a whole elaborate procedure and exactly the same procedure as we have read in section 230. However, the section is different, and so we cannot say that if I am talking about a case of merger, I give my answer in accordance with section 232. No, in accordance with section 230 to 232. Fine. Okay. So applicant makes an application to NCLT for seeking approval. NCLT finds that the application relates to merger, amalgamation or demerger. So it will order the meeting of creditors, members, any class, as it does in section 230 also, and the same provisions of section 230 will apply. That is, the notice will be sent to persons, advertisement, website, everything, statutory authorities notice, then approval will be taken from members or creditors, and thereafter scheme will be sanctioned. Okay. There is one more point which is written over here, objection allowed, which I haven't explained you in section 230. What do you mean by objection allowed? It is very important point. Okay. See, some of the members or creditors, since the company got the approval as needed of 3/4 value majority, so the company proceeded with the scheme, but there might be some people who are not very happy about it. See, there are two types of people. One who are not happy but still they accept it, and ones who are not happy and become rebellious. So these are the rebellious ones. They want to oppose. We have to check, are they capable enough to oppose, because capability criteria has been specified. Who is eligible to oppose, that has been specified. Who can object more than equal to 10% of share capital or more than equal to 5% of debt in the case of members and creditors respectively. Okay. So this is how that is going to take place. The same objection criteria is specified here also, because the same provisions apply in this case also. But ma'am, undoubtedly there should be something different in section 232 or something additional in section 232, because we have a separate section for mergers and amalgamation and a separate one for compromise and arrangement. So undoubtedly there is some difference. Yes, there is. There are two major differences, or there are two major additions in case of merger and amalgamation. One, you have to circulate additional documents. Two, your scheme will contain for these. Okay. So along with the notice, there are some additional documents which have to be sent. That is draft notice, draft scheme, complete scheme. There was only then its confirmation that it has been filed with ROC, valuation report, financial statement, or you can say supplementary accounting statement if it's not in all cases, if the financial year end was 6 months ago. So in that case, a supplementary accounting statement, the report by directors with regard to effect of merger and amalgamation along with the exchange ratio, what is the price they are going to get and all that, right? So this will additionally be circulated along with the notice if it is a case of merger, amalgamation, demerger. If all the conditions are satisfied with and certificate of auditor received, then tribunal may sanction the scheme. Now the scheme must contain for these following, since it is a case of merger, amalgamation or demerger. After it is sanctioned, the order is sent to the company and company files it with registrar within 30 days. This point I'll discuss little later. First we are going to discuss the orders. The points which must be there in the scheme, otherwise tribunal can pass orders in this regard. First is transfer of undertaking. Whenever a scheme of merger or amalgamation takes place, undoubtedly there is transfer of assets, liabilities. Sometimes it could be transfer of just one undertaking and like things. Whatever it is, you have to give adequate information about what is going to be transferred, how it is going to be transferred. Second is with respect to purchase consideration. So what are you going to allot? Allotment of shares, right? So order about that. Continuation of legal proceedings. The legal proceedings or the legal cases shall be now against the transferee company. So from transferor company, they'll come to transferee company. The transferor company, that is the old company which is being now merged into the transferee company. This company, all the assets, liabilities have all been taken over by this transferee company. Now this company is a kind of empty box which has nothing in it. However, it does not die because it has to die a legal death since it is a legal person. So we have to dissolve it. So no winding up needed because it does not have any assets, liabilities. However, we must dissolve it. We must remove its existence. Okay. Then shares to non-resident shareholders. We have to make sure that FDI compliance is done. The employees of transferor company to go to the transferee company. Set off of fees. And before that we have listed companies. Supposedly a listed company is being merged into unlisted company. So this unlisted company will remain unlisted only. It will not become listed just because it has acquired a listed company. No, if you marry a celebrity, you don't become a celebrity, or you do actually become a celebrity, but here the same is not going to apply. And set off of fees. What do you mean by that? Supposedly A plus B is equal to C. So we have to incorporate a new company C. Incorporation fees is there, but these A and B, they are going to dissolve. So whatever fees have been paid by them, they can be set off. Other incidental matters, right? Apart from this, we have this another point, which is the scheme of amalgamation merger takes quite some time, and if it is at a stretch of 2 years, 3 years, at the end of every financial year, within 200 days, there has to be a certificate of compliance certified by CA CMA, which is going to be filed with ROC. Okay, that yes, whatever scheme was sanctioned by tribunal, we are following the same. Now, merger and amalgamation of certain companies. This is also known as fast track merger, but it is not available for all types of companies. Okay. It is available for small companies. It is available for holding and its 100% subsidiary. It's available for prescribed companies which are startups and startup with a small company. So in these 4 cases, companies, instead of going through that long route, they can also opt for fast track merger under section 233. What is the procedure that they have to follow under section 233 is a matter of concern over here. We don't need approval of NCLT. That's the most important point over here. Instead of NCLT's approval, we need CG's approval. Ma'am, how is it going to be fast then? Undoubtedly, taking approval from CG is way more easier than NCLT because CG is as good as MCA, right? So we have to take that approval. But before that, we have to take approval from members and creditors. Members and creditors. So first of all, we take approval from members as well as our creditors. This is not the case in section 230 or 232, but here we have to take approval from both members and creditors. We sent a notice to seek objection to just 2 people, that is ROC and official liquidator, who is the officer of High Court. So we sent the notice. If they have objection, they will give objection, and thereafter when we get sanctioned, when we get approval from our members and creditors, we file this with central government, and central government grants us approval and the scheme is implemented. So that's how the process works. Both the companies, that is the transferor company and the transferee company, they both file declaration of solvency with registrar, and this is a separate requirement. Here the process starts. First thing that they are going to do is send a notice inviting objections from registrar and official liquidator. And after that you have to call meetings of shareholders, meetings of creditors, right? So you call the meeting wherein they are present, and you need to take their approval. How, ma'am? Approval has to be as it was in section 230? The answer is no. Here the criteria of approval is different. And you have to very well remember the criteria of approval under section 233 and section 230. They are two different things. Their majority number representing 3/4 value, dual type of approval was needed. Here for members you only need that members should represent at least 90% of shares. 90% of shares. And if it is creditors, majority representing 90% value. So here you need dual approval. Here you just need 90% of shares. Fine. Okay. If registrar or official liquidator wants to object, they can make objections within 30 days. They have a time period of making objections. Now, you called the members, you called the creditors, took their approval, you also sent a notice to ROC and official liquidator. The next step is that after taking the approval, within 7 days, you file the scheme with central government, ROC and official liquidator. There are two instances which may happen. ROC or official liquidator have an objection, they don't have an objection. If they don't have any objection, central government finds no problem, central government will register the scheme, pass the order of approval, the same order of approval will be sent to the company, company will file it with ROC. The old company will dissolve and other transfer of assets, liabilities all will take place. Okay. If objection is there or central government finds that it is not in the public interest that this merger should take place, then central government leaves the case and transfers it to tribunal. So central government makes an application to tribunal and requested that you consider the scheme under section 238 because you are more competent to do so. Now it is at the discretion of tribunal that they can sanction the scheme or process the scheme according to section 232. Fine. Okay. Next is section 234, merger or amalgamation of foreign companies. So Indian company can merge into foreign company can merge into Indian company. The provisions are the same. So we have to follow section 230 to 232 only for this also. And here one important point that you have to remember is that foreign company does not mean company incorporated outside India and having a place of business in India, as we read in the definition. No, whether having a place of business in India or not, that is the foreign company for this particular section. So what is the additional requirement, ma'am? If we have to follow the section 230 to 232, what is the additional requirement? Additional requirement is that you need RBI's approval. You need approval from RBI. Moreover, the consideration may be paid in cash, depository receipts, or a mix of both. One more point which is there in rule, it states that supposedly Indian company is being merged into the foreign company. So the foreign company will pay shareholders of these Indian companies. What will they pay? What will they pay? They pay us an equivalent amount of shares. So what is going to be the exchange ratio? That will be decided by that foreign company. So foreign company will take help of a competent person. Here we have registered valuers. What about there? So it is stated that their valuation should be done by some members who are undoubtedly the member of a recognized body which follows internationally accepted principles of valuation, so that we can be sure of fair valuation. Okay, so this is an important point that is there. Fine. And moreover, we also have to take care of the jurisdiction, that foreign company which must be incorporated in certain jurisdictions where securities market regulators, there are anti-money laundering, etc., and that we have to take care of. And you can merge only with the company of that particular jurisdiction. Fine. Moving on to the next section, section 235. One company wants to acquire another company as its 100% subsidiary. That means want to buy all the shares of that particular company. So the company gives an offer to the shareholders of that company that you sell your shares to me because I have an intention to take all the shares. I give you 4 months, you can either reject or accept, it's completely your choice. But supposedly it is accepted by 9/10 value of shareholders. Then it's going to give a huge power to the company. The company now gets the power to acquire shares of even those people who did not agree. This might sound harsh to you, but I hope you remember the logic that I explained to you in the comprehensive class, right? So we have discussed it thoroughly, that why this section is being introduced, and it is for the good. No, it's not, definitely not harsh. Okay, so within 4 months they can accept or reject. In case this approval is acquired but there are some shareholders who disagree, then in such a situation, transferee company, what they will do is they will send a notice to the ones who disagreed that we are going to acquire your shares. They are not happy with it. So within 1 month they can apply to tribunal. If tribunal finds that something wrong is happening to them, tribunal will give the result in favor and we have to stop. But if the appeal is dismissed or you don't apply at all, then we will take our next course of action, which is executing the transfer deed for transferring the shares of yours into our name, but we'll not give it to you. We'll give it to your company. So we will give the transfer deed, we will give the notice that we sent it to you, copy of notice, as well as the money to your company, and this company will inform you that the shares are no more yours because the company has registered the shares in our name. So the transfer has taken place. So it will be informed to the dissenting shareholders that the shares are no more yours, they have been transferred to this company, and the fact that we have received your money and it will be disbursed in 60 days. Okay. So this is the case. Section 236 is quite close yet has a difference. What is the difference over here, ma'am? That before that, let me take you over here. Section 238, it just tells us about the attachments, that whenever a transferee company gives an offer, it also contains the board of directors recommendation, the statement that if you accept the offer, necessary cash will be available, you will get adequate cash and thereafter you can sell the shares, and that we have registered the circular with ROC. See, whatever offer you are giving, you also have to register it with ROC. If ROC refuses to register, you cannot go ahead and make an offer. There is a penalty also of 1 lakh for that. Okay, now section 236, purchase of minority shareholding. Supposedly over the period of time some person has got or has become the shareholder of more than equal to 90% of equity share capital, then he can acquire the remaining ones also. How? You will notify your intention to minority shareholders. There are 2 options. They might also offer to sell their shares, or you can make an offer. Now this is something which is which has to be considered. Predetermined price whatever offer you will be made at a predetermined price, and this pricing has been quite illustrated through the rules also. A registered valuer will be higher, he will value the price, yet that will not be the price. We have to ensure that what SEBI releases as the fair price, or if it is an unlisted company, then what is the fair price that can be calculated on the basis of what price has been paid in the last 12 months. All this is not something that you must remember, but I'm just telling you for information. So based on that, we decide that higher of what registered valuer has taken out or what SEBI has given as a fair value. So according to SEBI regulations, what has come at the fair value, higher of these two, that is the predetermined price. Okay, that is the predetermined price. Because here at once the offer is not being made, offer is made in chunks. Sometimes you are buying 2 shares, 3 shares, and likewise you have attained this particular point already, and now you are availing this particular section. So what you will do is, you will deposit consideration in a separate bank account. You give the money to transferor company only. So transferor company only receives money, pays money, collects share certificate, discards it, issue new certificates. It acts as a transfer agent in that regard. And deposit money in separate bank account, which remains valid for 1 year. So 1 year anyone can take payment from that bank account. The amount has to be disbursed within 60 days. Now, one important or additional point which is there in this section which students fail to understand is that there is this minority which was already 10% or lesser. In this minority, there is a majority and minority. Majority which holds more than equal to 75% of holding, and minority which holds less than equal to 25% of holding. Now, in this minority, the majority negotiates with that shareholder, with that actual majority shareholder, and gets a higher price, or get some more money for sale of shares, because they are good chunk, they can negotiate, or they reach an understanding that I want more money. Whatever more money they receive, they have to give, or they have to share that additional compensation even with the minority segment of shareholders. Okay, fine. Section 237. If central government is satisfied that 2 companies must merge into one another, central government can pass such order. What about our wishes, our will? Central government will first draft the order, send it to both the companies that you both have to merge. This is my order. If you have objection, you can give the objection within 2 months. Your rights and liabilities will not be affected. If at all the rights of members, creditors are affected, then you will get compensation for it. And if you're not satisfied with the compensation, you can even appeal to tribunal within 30 days. So draft is made, it is sent to the companies. Companies can object within 2 months. If companies don't object, fine. If they object, then central government will consider the objections, make necessary modifications if needed, and thereafter pass the final order in official gazette, which will implement the merger scheme. And this is also going to be laid in the Houses of Parliament, right? After that, we have section 239, which just says that whatever company has been merged, has been amalgamated, the books and papers of that company cannot be disposed of, destroyed without the permission of central government. So you need to make an application to central government for seeking permission. Central government will ensure that there is no evidence left of any offence, prospective offence, and thereafter permit you. Section number 240 states that if 2 companies are merged, the old company had committed an offence and some officer in default was responsible, he will continue to be liable even after this merger, demerger, amalgamation, whatever is taking place, right? So that is all about this particular chapter's revision. Okay, now the revision of prevention of oppression and mismanagement. We have very few sections read with rules and some case laws in this particular chapter.
This chapter comprises of not many sections, starting from section number 241 till section number 246. If we look at the chapter overview, if oppression and mismanagement is taking place in any company, and if you're being oppressed in the capacity as a member, that is a continuous act of oppression that you're suffering from, then if you happen to be the eligible member, then you can make an application to tribunal for seeking relief from that oppression or mismanagement. This chapter intends to provide the preventive remedy and not the exact cure after an oppression has taken place. So oppression and mismanagement, these are the two terms which are not defined in the act, defined in this whole chapter. However, when we look at section number 241, we are being given two cases when an application may be made. So if you satisfy the criteria, if you fall into those cases and you meet the eligibility requirement, then you can make an application. So when we start with the chapter, we start with understanding the meaning of the two terms. There are two perspectives. One is the general meaning that we understand of the two terms, and second is the given intended meaning, the given intended precise meaning in the section which we have to present in our answers, right? So the very first thing, the chapter begins with a rule, that is majority rule, Foss versus Harbottle, which states that all the decisions will be taken by majority, which is fair enough. Because if we remove this particular rule, we will not have any proper procedure to take decisions in a company, in our lives, in anywhere, right? So obviously, if the decisions are to be taken by board of directors or the members, they are going to be taken by majority of people, which is the majority rule, which is nothing wrong at all. And the courts will not intervene in this internal management as long as the decisions are being taken in the manner they ought to be. However, this chapter says something as an exception to this Foss versus Harbottle majority rule, and it states that sometimes the decisions being taken by this majority could be oppressive, could be creating some atrocities to the minority group, to some group of members, to one member, two member, four member, five member, and in such a situation, courts will intervene. How the courts will intervene? NCLT gets the power under this chapter to entertain such applications and complaints, right? This is the slight background that I have given to you. Since it's just a revision class, we're not going to get into very much in-depth meaning of each and every term. Once again, if we come back to the chapter overview, someone is entitled to make an application under section 241. Who is entitled? The members' eligibility criteria or requirement is given in the section 244. So before reading section 241, you need to have that understanding of section 244 and remember who is eligible to make an application. So someone who is eligible to make an application, if the circumstances prevail which are given in section 241. What are the circumstances? There are two cases which are given. One case is termed as oppression and one as mismanagement. Although section does not define the terms, section only states the circumstances we believe it to be the case of oppression or mismanagement, right? So if the members are eligible, they can make an application. If there are the circumstances prevalent, they can make an application to tribunal under section 241. Tribunal passes certain orders under section 242, and out of those orders, a few orders have certain consequences also, some after effects. That is given in section 243, and we have a separate segment, class action suits, given under section 245 and 246 is absolutely nothing, right? You're not being asked any question. It is nothing. It's just about the applicability of some part. So that we are not concerned with. We start with the revision of first section 241. But before that, let's have a look at who is eligible to make an application. There might be a company with share capital, there might be a company without share capital. If it is a company without share capital, we don't have any share capital, we just have the number of members. So we can straight away say 1/5 of the total number of members. So if the company is without share capital, 1/5 of the total number of members. But if the company is with share capital, then ideally we have three things. And we can say lowest of all these three, or we can have a division that number wise also criteria could be met, or the value wise criteria could also be met. A company is having share capital. Who are the members who are eligible to make an application? Lowest of either 100 members or 1/10 of the total number of members, or the members who are holding at least 1/10 of the issued share capital. Here it means preference plus equity both. Point number one. Secondly, it's not paid up capital, it's issued capital. So you have to keep this thing in mind. So if you meet any of these three criteria, you become eligible to make an application. However, what is important is that you must have paid all the calls and sums due to the company. If you yourself have failed to pay the calls of the company, then your eligibility requirement also fails, and in that case you are not an eligible applicant. Moreover, sometimes it may so happen that although you fail to meet the eligibility requirement, yet your case is severe and your application is genuine, and you must make an application for seeking relief. In such a situation, tribunal can waive the requirements. Tribunal can say, fine, even if you're not 1/10 of members, you can still make an application. Even if you don't hold 1/10 of issued share capital, you still make an application and we will admit your petition, right? So this is something which is possible. NCLT may permit the lesser number of members. That is something which is something that I have told you. Now, although these points are established through a lot of case laws as well, but two things I am telling you over here. One, I hold 100 shares and so I am eligible. After making an application, I sell my 50 shares. So my shareholding gets reduced. Later on, after making an application, will my application be still valid? The answer is yes. So I am supposed to hold the requisite number of shares only at the time of filing application and not thereafter. Secondly, I have given my consent, but subsequently I have withdrawn my consent. Will my application be still valid? The answer is yes, right? So both these requirements, that is the shareholding as well as the consent, is needed only at the time of filing of application and not thereafter, Thereafter, if it is subsequently reduced or withdrawn, it doesn't really matter. So one thing is clear, who is eligible to make an application? So we check whether the company is with share capital, without share capital, where do you fall, and do you meet the criteria as given or not. If you meet the criteria, then you may complain. If oppression takes place or if mismanagement takes place, are likely to take place, right? Because it is a preventive remedy. So one, if the affairs of the company are being conducted, have been conducted or are being conducted prejudicial to public interest. What do you mean by prejudicial? Prejudicial is harmful. So if it is harmful for public, it is harmful or oppressive to the members, it is harmful to the interest of the company. So if any of these things exist and you are eligible member, then you may complain. Secondly, there is some change in the management. or even without the change also this takes place. However, what is being given in the section, if there is change in the management, and now it is expected that whatever actions they are going to do, it will prejudice us. Why change in the management is written over here? Because if there is no change, then affairs are being conducted in a harmful manner. So if there is no change, this point covers it all. But if recently some board of directors have changed, or maybe the two companies have come together, or maybe some shares have been acquired by a particular group, so that ownership in shares have been changed, so now whatever resolution will be passed, they will have the majority and they will be taking the decisions. So if there is some change, if there is no change, either the affairs will be running good or not good. Not good, you can use this ground and you can complain. If there is change in management, then you come to this particular point, right? So there is change in the management, you are expecting that it will be harmful to members, so you have proper circumstances and evidence which suggests the same, then you may also complain. And CG in public interest can also complain, so you can make an application to tribunal. And if tribunal is satisfied that yes, the allegation, the application is genuine and the above affairs exist, above state of affairs exist, and the company is in such a condition that the company must be wound up. But if we go on to wind up the company, it will not be fair for the members who have made the application. Right? Something wrong has happened to me, and you're closing down the company. It doesn't rectify what wrong has happened to me, right? So in such a situation, tribunal, instead of resorting to winding up, takes some other actions. What are the other actions? This part is given in section 242. So these are the orders of tribunal, what orders may be passed, although tribunal can pass any order as they deem fit. However, there is some list of orders which are given which may be passed, right? So what orders can be passed? The tribunal can say that we are going to regulate the affairs. Fair enough. The tribunal could say regarding the purchase of shares by some group or by the company. The tribunal can instruct the company that, okay, fine, you buy the shares of these people at a fair price. And since you're buying back the shares, it should result in, or it should comply with all the provisions of reduction of share capital. Right? Sometimes it may so happen that some transfer of shares is constantly taking place, which is not in the best interest of the company, and all the shares are being rerouted to a group of shareholders who are misusing their powers or something like that. So tribunal can restrict that transfer. Some further shares are being issued, and if these shares are issued to a particular group of people, they will become majority from minority. Tribunal can stop that allotment. Now, tribunal can terminate, set aside, modify the agreement between directors and company, or between company and some third party. If tribunal does this, it has consequences of 243. Only in this point. Only in this point we have consequences. For all other points, we don't have consequences. What do you mean by that, ma'am? Company has hired, or company has appointed Mr. X as the managing director for 5 years, but tribunal terminated their contract and said that you have to leave the company. Right? In such a situation, two consequences follow, which are given in section 243. 1. Although if a managing director is removed before expiry of his term and he fulfills the conditions given in section 202, he is entitled to compensation. However, if he is removed under section 242 by tribunal, he will not be entitled to compensation. Moreover, because tribunal has found him guilty and that's why has removed him, so he will be disqualified for 5 years. If he wants to be appointed as a director before 5 years, then he has to go to tribunal, seek its permission, and then it can be appointed. Okay. Likewise, although third party and company, tribunal doesn't have the right to terminate a contract of third party and company, right? But still, here tribunal gets that power. Tribunal will discuss with the third party, will take permission from the third party, and then terminate, set aside, or modify the agreement with the third party. However, even in that situation, the third party also shall not be entitled to any compensation. So, no matter if tribunal has terminated or set aside or modified the contract, then absolutely no compensation, and the concerned directors will be disqualified for 5 years of appointment until they seek the permission from tribunal. Next, setting aside a fraudulent preference. For this, you need to recall and understand what do you mean by fraudulent preference. Giving someone preference for a fraudulent motive or intention. That is fraudulent preference. Like what, ma'am? I have 10 creditors, and if I have to genuinely make payment of these 10 creditors, I will pay the creditor who has been waiting for the longest, right? But instead of making that particular payment, I paid to some creditor who I know is a good friend of mine. So this is giving fraudulent preference to that creditor just because I know that the company is running out of funds, and if I start in that sequence, my friend will not get money. But that's how it should happen. That's a fair play, right? But instead of going for that fair play, here we are involving some fraudulent motive and doing this. Tribunal has the power that in the past, if these type of transactions have taken place, they can set aside this transaction. Tribunal can remove MD, manager, director, appoint them who is going to report to NCLT. They can give instructions about the cost of this and recovery and other matters as they deem fit. So these are the orders which may be passed by tribunal. An application may be given by the eligible members to tribunal. Tribunal on receipt of application is satisfied that yes, it exists and winding up would be unfair. Then tribunal passes certain orders. Whatever order is passed, that has to be furnished to ROC within 30 days. Within 30 days. Okay. Now, we have another point over here on which we have not done a lot of questions, because these are some recent amended sections which have been incorporated and a new thing which has been incorporated. But then this is important. Okay, so there is something more. What is it? Application to tribunal for relief in case of oppression, etc., and powers of tribunal, and section 243. Ma'am, we have read section 241, we have read section 242, we have read even section 243. Then what is it? It is a combination of all three of them. It is an absolutely different topic, but it is not given in one section. Some part of it is given in section 241, some in 242, and some in 243. Okay, so let's begin from the very first part. See, if central government, on the basis of some circumstances, has a belief that there is a director in the company who is not fit enough to be the director. Fit enough means he is constantly negligent in his duties, he is not performing his duties well, or maybe he's constantly indulged in fraud, right? Some people are there who do mistakes, but some people are there who have a habit of doing mistakes, right? So if central government comes across any such person who is guilty of fraud or breach, or has not done the business according to the principles, or has been doing the business with the intent to defraud or cause injury, then CG wants to know, is he fit enough? CG wants to know, is he fit enough? So CG initiates a case and makes an application to tribunal. Now, tribunal should also have the confidence that do I really need to inquire about this person? So for that, CG gives a concise statement that why CG believes that yes, some inquiry should take place for this person. I don't find this person to be fit and proper. I don't find him to be fit enough to be the director, right? So central government gives the application to tribunal to inquire and record whether or not such person is fit and proper to hold office. Under section 242, tribunal records its decision. So tribunal will hear the case, will call him, will look for evidences and all that, and finally come to a conclusion that yes, he is fit, or no, he is not fit, right? So whatever conclusion he comes across, he records that decision under section 242. And if he is fit, great enough. If he is not fit, then such person shall not hold office for 5 years from the said decision without the leave of tribunal. So if he wants to be appointed, he can take permission of tribunal, and such person shall not be entitled to compensation. Just the same thing that we have read before also. I have made another chart for you all in the same capacity so that you understand the whole for the same topic, so that you understand the whole concept well once again. Central government, if these circumstances suggest fraud, negligence, or default, not sound business principles, or serious injury to trade or industry, or intent to defraud, then it can make an application to NCLT to inquire along with concise statement. This part is given in section number 241. After hearing, NCLT shall pass order. This is given in section 242 4A. If he is fit, no further action needed. If he is not fit, then these three parts are given over here. Such person shall be removed, disqualified for 5 years in any company. If tribunal terminates or sets aside some agreement with the director, he is disqualified to be appointed for 5 years only in that company. But if tribunal finds that a person is not fit enough, then he is disqualified for 5 years to hold office in any company. That's the difference. And also entitled to compensation for that loss, right? So you get double clarity this way, right? So I think this is clear. Okay, now we probably have this last section that we need to discuss. Class action. Class action is a benefit which has been given, and this benefit is not just for the members but also for the depositors. I have made you a proper differentiate between section 241, section 245, that there are also some members are coming together and making an application. Here also members are coming together and making an application. So what is the difference? All that difference I've already told you. Right now we'll focus just on revising our concepts, right? So members can also go for class action, and depositors can also go for class action. If members, we are talking about members, the company may be with share capital, without share capital. If it is with share capital, the lowest of 100 members, 5% of number of members, or if it is a listed company, members holding 2% of share capital. If it is unlisted company, members holding 5% of share capital. Fine. If the company is without share capital, 1/5 of the number of members. You have to learn it. If you don't learn it, no, you will think and try to focus that what is ma'am trying to tell us. I'm unable to gain this. I'm unable to retain this. So you will face a lot of problems if you don't learn. Wherever in law there is a limit, my dear, you have no choice but to learn. Right? Other than these numbers and limits, all that concept building helps you to retain the concepts throughout, but this learning part has to happen. Okay. And if it is depositors, exactly the same thing. 100 depositors, 5% of depositors in terms of number, or the depositors who owes 5% of total deposits. So this is in terms of value and this is in terms of number. Fine. Now, if you are eligible, you can make an application. On what ground? That management of affairs are being conducted in a prejudicial manner. Tribunal will consider the factors. Tribunal might admit your application or it might reject the application. Right? You are making an application to seek these specified remedies which may be granted to you. There is an option at the end, other remedy as well, which is a leftover option. Now, before this, what is the procedure of class action? In the procedure of class action, once tribunal receives an application, tribunal gives a public notice. Public notice as in we have received a class action application. Now all the members are being given a public notice. There might be some members who want to opt out from this, they can. But if they don't want to opt out, they are deemed to be a part of this class action application, right? Maybe there might be a situation that two class applications have been filed in the same regard, so they will be clubbed into one and one lead applicant will be selected. Now, it is the choice of the applicants only to select one lead applicant. However, if there is a conflict between these applicants, then tribunal can take a call and tribunal can decide about the lead applicant, which is going to be binding on everyone. Fine. So what orders or what types of remedies can be obtained under this section? The company can be stopped from doing an ultra vires act, from committing some breach, and some resolution can be declared as void. A resolution for altering a particular regulation of articles of association was passed, but there was some problem which we have discussed in classes, so that can be rendered as void by the tribunal. Restraining company to act on above resolution. Since the above resolution has been rendered to be void, then obviously you will not even act on that resolution. If that resolution was valid, you will take its actions. But if it is not valid, then you will stop yourself. You will not go ahead. Right? Is stopping the company to act in contrary to the provisions. You can claim damages from the director, auditor, expert, others, and any other remedy which may be granted, right? So these are the different types of reliefs or remedies which may be given under a class action suit. Fine, so that was super quick revision of the chapter of prevention of oppression and mismanagement. Now let's revise the topic of winding up. Winding up is a huge chapter and has a lot of sections, however, not very important from examination perspective. What is winding up? First thing that you have to understand is winding up is different from dissolution. Winding up is actually the process of realizing the assets and paying off the liabilities. Of course, to realize the assets and pay off the liabilities, you need to do a lot more work than you can think. Collecting and actually verifying all the claims, that who wants money from our company, which is basically the creditors or the contributories, and from whom we can take money, our prospective debtors, our assets. From where can we realize? Some assets might be on lease, some assets might be in someone else's possession, some assets might not be on paper belonging to the company, wherein they actually belong to the company. So a lot of efforts have to be taken, and moreover, to carry out this process, we need someone who is independent and who is not biased towards the company, not biased towards any of the creditor, not biased towards any of the director, etc. Because it is also important to extract and bring out any fraud if there exists in the company. So for that, you need an independent professional person who is known as a liquidator. Now, who works as a liquidator? It could be an official liquidator, like the central government officers which work under the High Court. It could be the insolvency professionals. right, about which we read in IBC, that is Insolvency and Bankruptcy Code. Now, when we begin with the chapter, the very first section is 270, but before that, you have to understand that post in IBC, after Insolvency and Bankruptcy Code came into picture, there are broadly one thing which has been eliminated, that is the topic of voluntary winding up. So earlier, if companies are properly solvent, they don't have any issue, yet they want to close down, they had the option under this chapter. Now they don't have, they have the option only under IBC. Moreover, a creditor was able to be a petitioner. See, this process of selling the assets and making payment to the creditors is going to be done only on the permission of NCLT. So anyone who desires to go into that process have to make an application to NCLT. Be it the company itself, be it any of the shareholder, be it the registrar, be it anyone. So if company does anything which is not acceptable, there are grounds when this winding up can take place. We will read about the grounds. So if anything like that is done which is unacceptable, a petition is made to NCLT. NCLT passes the order, and thereafter this process of winding up takes place. So if a company has taken a loan but the company is unable to repay the loan, can bank file a petition with NCLT that close down this company, sell their assets and make my payment? The answer is no. Why? Because this ground has been removed. So the creditors are not entitled to make a petition. After IBC, if you have any issue, if you are an operational creditor or a financial creditor, you have to move to IBC, and therein you can make an application. Okay, not over here. So there are slight these changes which have been witnessed after IBC. Okay. So we are left with just one mode of winding up under this chapter, that is winding up by tribunal. Now, tribunal is not going to order winding up just like that. Okay, fine, close the company, sell the assets and realize the assets, pay off the liabilities, close the company. No. Someone has to complain, someone has to file a petition. Now, someone will not file a petition just like that. There have to be proper grounds. So what are the proper grounds? If SR is passed by the company, if the company is acting against the sovereignty or integrity or friendly states with other countries. So if you're acting against any of these, then central government or state government, they can also intrude and they can also file a petition with NCLT that close down this company. This company is working against the sovereignty of our nation. So close down the company. Fine. The company cannot be closed down just like that. You have to understand that there are so many creditors, there are so many stakeholders rather. There are employees, maybe their salaries have not been paid. There is government whose dues have not been paid. Maybe there are creditors, there is a bank from whom we have taken loan. Right. So all these stakeholders cannot be left just like that. So it is important that this process is carried out. So everyone, all the liabilities are settled down, whatever surplus is there, if it is not a fraudulent surplus, then it is given to the shareholders who invested in the company, and then the company will be closed down. The ultimate intention is to close down the company, right? Because there is maybe fraud involved, or maybe the company is doing a default in filing financial statement or annual return. So this is also one of the ground. For continuous 5 years, if there is a default in filing financial statements or annual returns, or there are fraudulent affairs, or the formation of the company was whole fraud, promoter, board of director, they are involved in fraud, or there is an open last ground, winding up is just and equitable. That means this is the only fair option left. So in such cases, petition may be made. Now, who is entitled to make the petition? Company. The contributory. Now, who is called as a contributory? Contributories are no special people. They are only the members of the company. Just like when you incorporate a company, before incorporation, they are subscribers. Post incorporation, they become members. Like that, before winding up their members, post winding up, that is when winding up commences, they become the contributories. Many students have this confusion in their mind that contributory means someone who is liable. There can be three types of companies, my dear: a company limited by shares, a company limited by guarantee, and an unlimited company. If a company is limited by shares, that means the members are liable to contribute only up to the amount unpaid on shares held by them. That means if I have fully paid up shares of any company, I'm not liable in any case to contribute anything to the company, even if company demands in the case of winding up. I will still be called as a contributory. If I have partly paid shares, I can be liable for the amount unpaid. If I have taken guarantee, I will be liable for the amount of guarantee, right? But I will still be called as a contributory, whether I'm liable or I'm not liable. In cases, if I have partly paid shares and I have transferred this partly paid share to someone else, and within a few months the company goes into liquidation and this person is unable to give that call money, then I, being the past member of the company that is falling in list B contributories, can also be asked to make the payment. Okay, so that we will see what are the conditions later. Okay, right now this much information recalling is sufficient. After that, we also have a registrar. ROC can also make a petition that close down this company, because ROC is the one who has most knowledge about filing and all that. So ROC comes to know that there is a company which is continuously not filing financial statements or annual returns. So ROC will make an application to central government. Central government will give an opportunity to company that ROC wants to make a petition for winding up. Do you have anything to say? Whatever discussion is done, if CG approves, thereafter ROC can file a petition to NCLT. Official of central government and central or state government, if sovereignty of the nation and all that, that point is affected. Okay, so they are entitled to make a petition. These are the grounds on which petition may be made. Petition is made to whom? Petition is made to NCLT. See, they make petition to NCLT, but a copy is also sent to ROC. So ROC within 60 days has to submit views, that what are his views on this whole winding up. Should winding up happen or should winding up not happen? Okay, fine. Moving to the next section, section 273, order by tribunal. So once NCLT receives the petition by eligible petitioner on eligible grounds, next is what tribunal will decide. So tribunal within 90 days may pass an interim order. For the time being, this has to be done. May appoint a provisional liquidator after giving an opportunity of being heard to the company. Provisional liquidator means what, ma'am? See, there can be two instances. A provisional liquidator is appointed. Thereafter, winding up order, company liquidator is appointed. The same person can act as a company liquidator. Option number 2, provisional liquidator is not appointed. Directly, we have a company liquidator. Now, what is the difference between the two? Provisional liquidator also start doing the same things as company liquidator would have done. However, when we are very not sure about what is going to happen, we may restrict his powers. That means we may say that we want the winding up process to start quickly. That's why we have appointed you, but you don't have these powers. You cannot do this. You only can do this. So he will do that. And once company liquidator, maybe we now trust his abilities. So we now make him the company liquidator and he gets all the powers. Or maybe we replace him with someone else and then that person gets all the powers. Okay, so that is the only difference. Or any other order may be passed. So order of winding up, any interim order, liquidator may be appointed, or any other order may be passed. Right? Tribunal cannot refuse passing the order of winding up just on the ground because the company does not have much assets to sell. Even if company doesn't have many assets to sell, still the winding up order can be passed. Okay. Section 274 is about statement of affairs. See, when company itself is the petitioner, listen to me carefully. When company itself is the petitioner, company itself is saying that wind up. So company knows about its state of affairs. So company, when files a petition, also files statement of affairs. Company with statement of affairs. However, if there are other eligible petitioners, they do not know about the company's state of affairs, so they cannot file the state of affairs with tribunal. So then tribunal directs company that you file your statement of affairs. Now, supposedly ROC has given a petition to NCLT that wind up this company. I should be given an opportunity to at least oppose. I don't want to be closed down. So I should have an opportunity to be to oppose my winding up. So this is an opportunity. Tribunal directs us that give your SOA, statement of affairs, along with that also object. If you don't submit your SOA, you lose your right to object. Then you cannot oppose this petition. Plus, you will be penalized, right? So you have the time period of 30 days plus an extension of 30 days can also be given. If you file, great. If you don't file, you lose the right to oppose the petition, as well as penalty is imposed upon you. Penalty may be ranging from 25,000 to 5 lakh and imprisonment up to 6 months or both. Okay. Thereafter, we have some sections: appointment of liquidator, removal, replacement, constitution of winding up committee. A lot of sections have been clubbed in this chart. Now, as I told you, NCLT may appoint provisional liquidator or company liquidator. And I also told you the powers, and I also told you who can be appointed. What salary will they get? It depends upon what experience they have, what qualification they have, and the quantum of work. If it is a very huge company, of course, their remuneration will be high. If it is a very small company, their remuneration will not be so high. Fine, ma'am. And one more thing that I told you in the beginning, that this has to be someone who is independent, impartial. So when you're appointed within 7 days of appointment, you have to file a declaration. Disclosure of any conflict of interest or lack of independence. If you have any lack of independence, that means you have been appointed for a company in which some of your relative is a stakeholder, or you have some inclination, that means your independence is compromised on certain grounds, then you have to disclose that. Okay. And once you are appointed, NCLT intimates the liquidator as well as the registrar, and registrar thereafter puts it on MCA website, puts it in official gazette, notifies the stock exchange and all that, right? Now, once a liquidator is appointed, does not mean he's going to continue. He can be removed. He can resign also, and he can die also. On what grounds can he be removed? Misconduct, fraud. If he becomes professionally incompetent, or he is unable to act, or he lacks independence, or of course conflict of interest. So after giving a reasonable opportunity of being heard, he can be removed. And when he is removed, or he resigns, or he dies, then a new liquidator will be appointed and all the work will be transferred to the other liquidator. Because of the old liquidator, if we have suffered some loss, then the loss can be recovered from that person. Now, there are two different dates. One is winding up commencement date, that is the date of filing petition. And second is winding up order, that is when order is being passed. So within 3 weeks of passing this winding up order, we have to constitute, that is the company's liquidator has to constitute a winding up committee. Section 277. Okay, so company liquidator will make an application to tribunal to constitute winding up committee. Who will be a part of winding up committee? The nominee of secured creditor and official liquidator and professional, another professional by NCLT. Official liquidator, I've already told you who is the official liquidator. Fine. Then there is something called as reporting although we read about preliminary report, we read about monthly reports, we read about final reports. So there are different reportings throughout winding up. These reports are being made from liquidator to tribunal. Okay, so these reports will undoubtedly continue. Then comes your section 279. When winding up begins, all other suits are being put on hold. That means you cannot file a fresh case. The pending cases will be put on stay. They cannot be continued or proceeded with. However, the cases which are pending against High Court or Supreme Court, they have a authority higher or superior than NCLT, so their cases will continue. Okay, so their cases will continue. Now supposedly I think that this is a case which is just going to be disposed of in a very quick manner. So in such a situation, I can seek permission from tribunal to continue that case in the same forum. Maybe there is a case which is going on in the district court, so I can seek permission from tribunal, and tribunal may grant the same by imposing certain conditions. Whatever application I make to tribunal, that application is going to be disposed of within 60 days, right? Okay. Now we have some more reports. As I told you, we have about preliminary report also. But before that, just because we're talking about cases, we also have section 280. See, tribunal ideally deals with only corporate cases. However, if there is a suit which is pending in some other court and then winding up commences, then this suit can also be entertained by NCLT. So if you have any other claim, if you have any fast track merger application which is pending, any suits which are pending, all of that can also be dealt with by NCLT. Now, when winding up order is passed, liquidator has to prepare a report of three things: report of certain details, report of fraud if any, and report of viability of business, how viable the business is. Maybe we are closing down the company not because the business cannot be run, because there is some fraudulent motive, or maybe because the company is acting against the interest of the nation, right? So if you're closing down the business for that reason, or maybe the promoters are involved in fraud or something like that, maybe the business is fruitful, the business is intact, and there are a lot of employment opportunities in the business. So if we close down the whole business, the employees might suffer, and that's why the business as it is can be sold, which is selling as going concern. So that order may be passed if the business is viable, right? Secondly, if there is fraud which is involved, then of course an order of investigation may be passed. So these reports by liquidator are very essential, are very important, which must be made very carefully. Right? If there is involvement of fraud, then maybe further investigation is needed, because someone has committed a fraud and then we will close down the company, the person will be free. So these reports are important. So the contents of report, the basic details, that is what assets the company has, the liability, capital, legal cases, guarantees, what are the debts due to the company, subsidiary, holding, what are the pending contracts, etc., etc. Okay, this report can be inspected by the creditors or contributories. Now, after tribunal receives this preliminary report, they can take a lot of actions. They can do a lot of directions. What are the directions which may be taken by tribunal? First thing is fixing the time limit, because now tribunal knows these details. So tribunal can very well fix the time limit if they want to. Maybe can revise the time limit based on the monthly reports that they receive. Maybe can make a sale committee. It's again optional. Okay, the sale committee will also comprise of the promoters and all only. They can help facilitate the sale of assets. Okay. Protect assets of the company. what is protection of assets of the company? Maybe NCLT feels the need that these assets can make us realize 10 lakh rupees, but if they're not protected, then in the coming tenure, they will not even be able to realize 2 lakhs or 3 lakhs. So it's important that we provide protection to these assets, like insurance, right? So they can be protected, and they can also order investigation based on fraud. Okay. So I think this is clear. Fine. Now the promoters, directors, etc. have to cooperate with the company liquidator. Obviously, ma'am, they will cooperate, they will give whatever documents and etc. they are all needed. And if they don't cooperate, the tribunal can pass suitable order as they deem fit. Okay. Now we have an important section, that is contributories. I have already told you about the contributories. Now, who can be liable? It can be the present member. It can also be the past member. Now, past member will be liable only if the present member is not making the payment, and if I have transferred the shares 5 years ago, then I will not be liable. I can be liable only if I was a member in the preceding 1 year. Okay, then only I can be liable as a past member, as a contributory. Moreover, I will not be liable for any debts which the company has incurred after I ceased to be the member. So my membership had terminated. Thereafter, the company took a loan, and for making payment of that loan, you want money from me. Why? I will not be able to give you, right? So I will not be liable for that. Okay. Now, for what they can call for making the payment of debts, for even the cost of winding up, and for adjusting the rights of the members. What is adjusting the rights of the members? Well, there may be a situation that a member has paid rupees 2 and other member has paid rupees 4 on a share. So to bring them all in one line, call can be made to adjust the rights, right? So it is the duty of the tribunal to settle the list of contributories. Now sometimes the list of contributories is not needed, because we know that we have very limited assets. We know that we have very limited assets and all the shares are fully paid up, so no one will be able to contribute anything, and we will not be able to give anything surplus to them. So there is no need to prepare the list. So in certain cases, when the list is not needed to be prepared, then tribunal can dispense with the list. Otherwise, a list has to be prepared of all the contributories, so the members register will be rectified, will be updated, and a proper list will be prepared. Okay, fine, ma'am. Then we have advisory committee. Advisory committee is made by tribunal to advise. It comprises of the creditors and contributories, maximum 12 members. Company liquidator will chair the advisory committee, and it is made within 30 days of winding up order. How is it made? The company liquidator actually convenes the meeting of all the creditors and contributories to decide about the composition of advisory committee. Advisory committee will always be beneath all the creditors and contributories. So time and again, liquidator can call the meeting of creditors and contributories to ask what do they want, what is their wish and all that, and decide about the what is the next course of action. Okay, fine. Then comes your powers and duties of company liquidator. So company liquidator, what does it do? Carry on business if there be need, execute all the documents, sell the properties, sell undertaking, raise money if needed, institute or defend suit, whatever they are going on, invite and settle the claims of creditors, then make negotiable instruments, take out the letters of administration, obtain professional assistance. In fact, we have a section 291 for professional assistance. Then take all the actions which are necessary, and lastly apply to the tribunal for other orders, for like orders like dissolution and all that, right? As I told you, we also have a provision for professional assistance. What do we mean by that? A company liquidator can obtain professional assistance. Um, Professional assistance means what? CS, CA, CMA, legal practitioner. We can take assistance from that in discharging our functions. Then we have books and audit. So 293 and 294. First thing is liquidator has to maintain books of accounts of everything, that from where money is received, from where payment is being made, which can be inspected by the creditor or contributory, and you have to submit it to the tribunal twice a year. Winding up is a huge process. It does not end in a few months, right? It takes time. And the same is going to be also audited. So tribunal shall cause the accounts to be audited, and the copy will be filed to the registrar, to tribunal, to creditors, as well as to government if it relates to the government company. Okay, right? Tribunal has the power to order costs, tribunal has the power to make calls, tribunal has the power to adjust the rights of contributories, all that we have already discussed. Tribunal also has the power to summon the persons who are suspected of having any property. So if there is any person who has some information about a property of the company, or has that property, or has some books and papers, and we suspect that, we can apply to tribunal, and tribunal can give direction for the same. We can also examine promoters or directors. So tribunal also has the power to order the examination of promoters and directors. Plus, if someone has that custody of books, papers, or properties and is trying to leave India, abscond India, then tribunal also has the power to stop them and even seize the papers or property, whatever they have. So contributory or such person can be detained, he can be taken into custody, and that property can also be seized. After completion of winding up, liquidator makes an application to NCLT for dissolution. Dissolution order is passed, and within 30 days, tribunal forwards it to ROC and also directs the liquidator to forward it, copy to ROC. Now, what is going to be the sequence of payment? Supposedly, we realize the assets. Now we will make the payments. See, as and when we keep on realizing the assets, we keep on making the payments also. We don't wait till all the assets are being realized. First thing is the secured assets. Company has taken a loan and the bank had mortgaged. The bank had a land which was mortgaged by the company. So that land is a security which is available with the bank. However, the security, the secured asset will not be used only for payment of dues of bank, but also of workmen. Why so unfair? Because this is something which is written in law. So section 326 gives us two payments which are going to be overriding preferential payments. That means before anything which is paid, these two payments have to be paid. So they are going to be paid in full out of the security. Now, usually if bank has given a loan of 1 crore, it will have a security of around 3 crores. So it has a lot of buffer. However, even if the assets are being sold and it is not sufficient to pay the workman dues as well as the secured creditor, then in such situation, it is not so that the bank will be paid and workman dues will be left. No, they both rank equally and they will be paid in equal proportions. Supposedly, it is insufficient, so some portion will be left. For that portion, they will be treated as unsecured creditor, and if any amount is left, they will be paid in that hierarchy. So we have a hierarchy called as, when assets are realized, first is overriding preferential payments, then winding up cost, then preferential payments, then debentures and floating charge, and finally the unsecured creditors. Okay. So next is we have 7 payments which are called as preferential payments, but they will be paid after winding up and they will have a priority over debentures with floating charge. They all have equal rank. So these are the 7 payments: government taxes, employee salary. See, here workmen are covered and here other employees are covered. Holiday accrued remuneration, ESIC contribution, compensation on death, disablement, PF gratuity, any such fund, and investigation expenses. Fine. Okay. Another important section, I would say, fraudulent preference. It is giving preference to a creditor. Giving preference is incorrect or is punishable, I would say, if it is given with a fraudulent motive. What do you mean by giving preference? Maybe providing some security to the creditor, maybe making his payment, maybe giving some type of preference through any transaction. And after giving that preference, within 6 months, winding a petition is filed. That means some idea was there that this is going to happen. That's why you have given preference to a creditor, which is, if in the opinion of tribunal it is fraudulent preference, then the tribunal can declare that transaction, that preference, to be invalid and order to restore the earlier position. Sometimes the earlier position may not be restored because we have given him some security, or we have provided him the payment, and the payment is no. Sometimes if it is not, then the person preferred shall be labeled as surety. Okay. Now, disclaimer of onerous property. Onerous means burdensome property. So if there is some asset which is burdensome, means we also have a section of section 332, which is effective floating charge. That is, if a charge is created 12 months preceding winding up commencement, then that charge will be invalid. If the charge is created and the company is solvent after creation of charge, then the charge can be valid. Or if the charge is created for a fresh loan, right? For a fresh loan means the rate also has to be specified, not exceeding the rate of 5% per annum, or the rate which is specified by government. Supposedly you have taken some fresh loan, and for that fresh loan you have created a floating charge, then that is permissible. Otherwise, if you have created a floating charge before, it is also like this only, right? It is also like fraudulent preference. If you are creating a charge in someone's favor, that means you are putting that person in a position above unsecured creditors. So if you are putting someone in a position above unsecured creditors, that means you are giving him a preference. Why are you giving him preference? If you are obtaining something from him and then giving him a preference, it's okay. But then the interest rate should be within that limit specified. Or if you are creating a charge and the company is very well solvent, then also it's okay, because in the normal course you may create a charge in someone's favor. But if that indicates fraudulent preference or such type of case, then it will not be valid. Okay, then we have disclaimer of onerous property. So if there is any land with some burdensome condition, or there are shares on which a lot of liability is there are some unprofitable contracts or some property which is not saleable, then company liquidator has a tenure of 12 months. So within 12 months of commencement of winding up, or if they do not get to know within 1 month of commencement of winding up, then whenever they get to know about this burdensome property, within 12 months from that or any extended period, they have a time period to decide whether they want to disclaim the property or keep it with themselves. If they disclaim the property, so then what they can do is they have to make an application in writing to the tribunal and also send a notice to the affected party, right? So based on that, tribunal will decide that whether you may resign the contract, may order vesting of the property, or may order to pay damages, right? So all that will be paid. Then we also have some offences by officers of companies in liquidation. So if the officers do not disclose about all the property, or if they keep some property with them, or if they fraudulently remove some property or try to hide, conceal, or through false pretense they take some property on credit, or materially omit anything in their statement which they know. So in all such 9 type of offenses, they have penalty. They cannot obtain anything giving a false pretense that yes, the company is a going concern, and then obtain that property, or maybe pledge it and obtain money from that property. So all that is punishable, and we have specific penalty and punishment which is specified in that case. Apart from that, we have a section 347, which is also important, about disposal of your books and papers. You have to maintain it at least for 5 years and dispose the papers only on the instructions of tribunal. Okay. And we have another section 352 where we talk about company liquidation dividend and undistributed assets account. So if the company has undistributed assets which nobody is there to claim for 6 months, or the dividend which you have to pay to the creditors, but the person is not there to claim it for 6 months, then that will be transferred to the special account opened in a scheduled bank. If there also it remains unpaid for a period of 15 years, then it will be transferred to the general revenue account of government. Right? Okay. Tribunal also has the power to declare the dissolution void within 2 years on an application made. Okay, now the revision of companies incorporated outside India, chapter number 22. It contains sections starting from section 379 till section 393A. But before that, we have to understand a very important term which is used synonymously to companies incorporated outside India. However, it is different. We have the term of foreign companies in this particular chapter, which is defined in section 2, clause 42 of the Act, which states that what is foreign company? A company incorporated outside India. See, one thing is clear, that whatever company is incorporated in India is governed by Companies Act 2013 completely. So you have to follow each and every provision unless exempted of Companies Act 2013. If there is a company incorporated outside India, it's doing business outside India, it has absolutely no connection with India, we are not concerned about such type of companies. You stay at your own place, you do the business that way you want to. But if you are a company which is not governed by our laws, that means you are incorporated outside India, but you have established some connection in India, then we are concerned. And we are going to, that is the lawmakers, the government has made some rules for you also to be complied with. Because you have come to India, because you are doing business in India, then with respect to your Indian business, undoubtedly we want some compliances from your end. If there is non-compliance, then it also has the consequences, it also has the fines, it also has some losing of rights. Okay, so this chapter tells us all. The very first thing, section 2, clause 42, foreign company, a company incorporated outside India, which is having a place of business in India. Now, this place of business in India could be either by himself or through an agent, physical or electronic mode. Electronic mode has been specifically defined in the rules, and which is very, very, very important from examination perspective. But the second requirement, after we read the second requirement, then I'll come to electronic mode. So once again, company incorporated outside India, having a place of business in India and conducting business activity in India. So there are two requirements, that you must have a place of business in India. That place of business can be electronic also, and you also must carry out business activity in India. According to the rules, what is electronic mode? See, if you're entering into any B2B, B2C transactions, or you're entering in via data interchange, you are entering into digital supply, you are entering into offering of securities, right? You are entering into any telemarketing, any telecommuting, telemedicine, education. See, all these keywords are very important, and which you must keep in mind. Cloud computing, then any data communication services, data communications and sending and receiving through any mode. It could be electronic mode, it could be it has to be obviously electronic mode, it could be some voice transmission, anything. So all that part is included in the definition of electronic mode. Now, the very first section that we start with this chapter is section number 379. 379, which tells us about the application or applicability of the provisions to these foreign companies. As I told you, we have in total from 379 to 393A, we have these many sections. Section number 380 to 386, both inclusive, plus 392, 393. They apply to all foreign companies. Ma'am, what about other sections? Other sections apply to all the companies incorporated outside India, whether they are foreign companies or not. Okay, so these sections specifically are only for all foreign companies, and you know what is a foreign company now. Fine, ma'am. There is another applicability which comes in the in subsection 2. So section 379 subsection 2, the only important subsection of this particular chapter is 379(2). It states that if it is if your foreign company has its roots or origin as Indian, that means if there is a foreign company more than equal to 50% of its capital, capital could be preference, capital could be equity, capital could be partly preference, partly equity, doesn't matter, is held by Indian citizen, Indian company, Indian body corporate, or in combination of them, then such foreign company has to comply with the provisions of this chapter along with other provisions as prescribed as if it were an Indian company. So if the company is an Indian based company, Indian based company means if you satisfy the criteria of section 379(2). So if a foreign company is an Indian based company, then you have to comply with some additional requirements, additional provisions which may be prescribed for you. Okay. Now, once we know that you are a foreign company, that means you have a principal place of business in India. Whenever you establish a principal place of business in India, you have a time limit of 30 days. Within those 30 days, you have to file a form FC1 to which registrar to ROC New Delhi. So it doesn't matter where you establish place of business, it has to go to ROC New Delhi. Along with this FC1, you have to file certain other things also. What other things? A certified translated copy of your charter, MOA, whatever it is, your address of the office which is registered in that other company, the list of directors, list of secretary, along with their prescribed particulars, that is their name, their PAN, their DIN, etc., etc. Name and address of the person who is going to be the Indian authorized representative. That person necessarily need not be the citizen. He has to be the person resident in India. That is important. Then, principal place of business in India, the address. If you have ever opened a principal place of business in the past and you have closed it, so all the details of that principal place of business, you have to give a declaration that none of your director as well as the authorized representative is debarred or convicted in the formation and management of the company. Other prescribed information, plus there is one more thing, that whenever you establish a place of business in India, under FEMA, you have to obtain RBI's approval. So once you have obtained that approval also has to be attached over here. In case you're not required to obtain approval, then the declaration by authorized representative shall be attached that we are not required to obtain approval, and hence we have not obtained approval. There could be a situation that there are changes in these details. So if at all there is any change in the detail, it has to be intimated to ROC within 30 days. The form over here is FC2. See, in this whole chapter, we have 4 forms that we need to study and learn. FC1, which is for giving the information, FC2 for alteration, FC3 is your financial statement, principal place of business, list, etc., etc. FC4 is annual return. Okay. So I think this is clear. Now we come to section 381, which talks about accounts of foreign companies. See, while maintaining accounts of foreign companies, you have to follow section 128. This is given in section 384. Section 384 tells us about applicability of some of the provisions of Companies Act 2013 on the foreign companies. So it also tells that when a foreign company is maintaining accounts, it is bound to maintain accounts. It will maintain accounts in the same manner as given for our Indian companies under section 128. Moreover, under section 381, although the topic says accounts of foreign companies, we are concerned about financials of a foreign company. So every foreign company has to prepare balance sheet, P&L, attach all the annexures. Balance sheet, P&L also according to Schedule 3 as far as possible. Attach all the annexures which are needed, right? So they have to prepare all this and they have to file all this with ROC. Now the question is, what are going to be the attachments and what is going to be the time period of filing? Okay, because they are making these financials for their Indian business only, not the complete financials of the whole company. No, only the financials with respect to the Indian business. However, undoubtedly, you must have prepared some consolidated financial statements incorporating this branch as well. Right. Ultimately, foreign company is what? Foreign company is a kind of branch of some company incorporated outside India. Because if there is a company incorporated outside India and it has a principal place of business in India, by incorporating a new company, just like big MNCs do. If I talk about Apple INC, Apple INC has Apple India Private Limited. So when Apple India Private Limited is incorporated under Companies Act, it becomes an Indian company and that cannot be treated as a foreign company under this chapter, under this act. Okay, you might refer to as, no, Apple is a foreign company, but it is not. Apple Inc. is a company incorporated outside India, right? It has formed a company over here, which is an Indian company and has to comply with all Indian laws. So whatever, if you have if you remember, I discussed with you by how many ways can a foreign company come to India and invest, right? So if there is an office of a foreign company, that office is operating, the office has to prepare its financials. Now, these financials, what is going to be the annexures? Annexures, as given in the chapter of accounts of companies, then there is going to be related party transaction statement, statement of repatriation of profits, statement of transfer of funds, consolidated financial statements, as well as the audit report. So, all that has to be attached, and for each financial year it has to be given to ROC within 6 months from the close of financial year, and it will be delivered in every calendar year. ROC may grant you an extension of 3 more months if needed. Fine. Okay, now section number 382. Every foreign company has to exhibit. If you open a principal place of business over here, you have to exhibit a board outside every office, which is going to clearly state the name of the company incorporated outside India, the country in which the company is incorporated, and if at all that company's liability is limited. That means it is a limited liability company. The liability of the members of that company is limited. Then this fact also has to be stated. Ma'am, where will it be stated? These three things have to be stated. Where will it be stated? It has to be stated at two places. One is the board outside every office. When I'm talking about board, in the board, it will be written in two languages, English as well as the local language. And when I'm talking about the other part, that is bills, notices, letters, any official communication, in that only in English, in proper legible characters. Fine. Now, if any notice, any document has to be furnished, has to be served on this foreign company, how can you serve it? We have an authorized person resident in India. It can be given to such a person by hand delivery, sent by post, or by electronic mode. Address, the address which has been mentioned. See, under section 380, we file a lot of documents. We file a lot of documents with ROC. We tell them about our authorized representative. We tell them about our address. So the same address, the same person will be used for communicating, for sending of notices or documents to foreign company as and when needed. And it will be sufficient for any authority. Now, section number 387, 388, 389 and 391. They all talk about prospectus. They all talk about prospectus. 390 is about IDRs, but this is a series which talks about prospectus. These sections are for companies incorporated outside India, whether they are foreign companies or not, it doesn't matter. Companies to be incorporated outside India. So if you're not even incorporated yet, in future you are going to be incorporated, but you are giving the you want to issue prospectus, you want to make an offer first. Whatever you lost permit, however you want to do it, there may be these two situations. They may have a place of business in India. They may intend to have a place of business in India. They may not even have a place of business in India. It doesn't matter. Any company which is outside India or which is going to be outside India, if it wants to offer securities in India via IDR, via prospectus, not IDR, I will say, via prospectus, how can it do so? It can, but only when it comply with the conditions. Even for our Indian companies, we have very strict laws and provisions for prospectus chapter, right? Prospectus and allotment of securities. There is section 26, which clearly states out the matters which have to be there in the prospectus. The prospectus has to be dated, prospectus has to be signed, prospectus has to be delivered to registrar. So a lot of requirements are there in that chapter as well. The same requirements have been reproduced over here. So there is absolutely no change in the requirements. The same requirements with a slight of addition have been reproduced over here. In case you remember the provisions of prospectus, great, you will be able to get even better clarity. But otherwise also it doesn't matter. So company incorporated outside India offering securities via prospectus in India will not be allowed unless following conditions complied with. What conditions? The prospectus has to be dated, it has to be signed, it must contain certain informations. One thing is, all the matters which are to be specified under section 26 have to be specified here also. Apart from that, you also need your constitution, your governing act, your country of incorporation, your address, where the documents can be inspected. Okay, so all these details is also required. All the details are also required. So this is how you prepare prospectus. This is how you prepare prospectus. Now, after you have prepared prospectus, you cannot go out and issue the prospectus. Your prospectus must be delivered to registrar for registration. So how, ma'am? It has to be certified by chairperson and 2 directors and delivered to registrar for delivered to ROC for registration. Sometimes your prospectus has an expert statement, but you have to ensure that whenever your prospectus is going to contain a statement from expert, some conditions of that also has to be complied with. First, you cannot include expert statement without obtaining his consent. So you must obtain his consent. He must not have withdrawn the consent. His consent must have been filed with the ROC, and you have stated this fact on the face of prospectus. So first thing, prepare a proper prospectus with all the contents which must be included. If your expert statement is included, ensure that you have complied with the conditions. After that, on the face of prospectus, write 2 things: that you have delivered the prospectus for registration, and about the expert statement that it is included and has not withdrawn consent. Now, this prospectus has to be given to ROC for registration. It has to be certified and delivered to ROC for registration. After it is registered, then only the companies can go ahead and issue prospectus. Fine. If you do not comply with the conditions of prospectus, then 3 sections get attracted. Section 34, criminal liability, 35, civil liability, and 36, punishment for fraudulently inducing people to invest money. So these 3 sections get attracted and you will be liable for them. After this, We have section 390, which talks about IDR, Indian Depository Receipts. Any company incorporated outside India wants to raise funds from India through IDR, it can do so. Central government via section 390 has the power to make rules for IDR. What rules? How IDR will be issued, how IDR can be transferred, how can you sell IDR, right? What is the manner in which IDR will be dealt by the custodian, by the overseas, right? And etc. So all these powers have been conferred to central government. Central government using these powers have made a lot of rules for IDR, but fortunately you don't have to read those rules, so I'm not discussing that rules with you. Apart from this, if you fail to comply with the provisions of the chapter, you have fine. On foreign company, minimum 1 lakh, maximum 3 lakh 50,000 for continuing offense, and officer in default, minimum 25,000, maximum 5 lakh. If section 393, kind of important for examination perspective, if the company has failed to comply, if the foreign company has failed to comply with the provisions of this chapter, say for example, it had to file the form of alteration in changes, it did not file. It will be attracted to fine undoubtedly, but does it affect the validity of contracts? It has entered into a lot of contracts with the third parties. So do these contracts become invalid because I'm not complying with the conditions that I am supposed to? No. The contracts will remain valid. If I breach, they can also sue me. So the contracts and my liability that I can be sued remains valid. What is lost is my right to sue. So now I don't have the entitlement to sue. I am a foreign company. I have lost my entitlement to sue the other party, institute legal proceedings, claim set off, counterclaim. Why? Because I have not complied with the provisions of this chapter. If I comply with the provisions of this chapter, then only I can go ahead and sue the other party. Fine. So what are the consequences of non-compliance? Point number one, penalty, fine gets attracted. Point number two, the contracts remain valid. I can be sued, but I cannot sue, right? So these are the consequences of non-compliance. And then you have the very last section 393A, which only talks about exemption. Central government has the power to exempt foreign company or the company incorporated outside India from compliance of provisions of this chapter by notification. That notification will be laid in both houses of parliament, right? So that's it with the quick revision of foreign companies.
Let's now revise the chapter miscellaneous. If we look at the syllabus which has been assigned according to CA Final Institute, our institute, CA Final syllabus, then a lot of chapters have been merged into this chapter of miscellaneous, which are registered valuer, removal of name of company, government company, and then other contents that we actually have in the miscellaneous chapter under Companies Act. So likewise, we are going to compile everything and revise. The first thing that comes to the first thing that we have to read is registered valuers. Now for that we have just one section, section number 247, and of course companies registered valuer and valuation rules 2017. So if I talk about valuation or registered valuer, we have an authority, IBBI. We have RVOs, that is registered valuer organization. Under that RBI, we have a lot of RVOs like ICAI RVO, and under that we have registered valuers who eventually or ideally give exams as designed and as taken by IBBI, but they are a member of respective RBO who are entitled to do the valuation of a respective asset class. Valuation can be done of land and building, plant and machinery, and securities and financial asset. Every person who fulfills the eligible criteria, qualification, is entitled to make an application, register himself in this course, then
undergo 50 hours training, appear for the exam, fulfill other formalities, and then obtain a certificate of registration. He gets the certificate of registration certificate for that respective class only, and he can do the valuation in that respective class only. So we have an authority, IBBI, that is Insolvency and Bankruptcy Code of India, and as I told you, the person gets himself registered with any of the registered valuer organization, does the training, pass exam, and submit application for registration within 3 years. See, if he doesn't submit the application, these are the forms. If he doesn't submit the application, then he cannot obtain the certificate of registration. He makes the adequate payment. If IBBI seeks more information, they will give more information. If they permit, then certificate of registration is issued, and your respective registered valuer organization issues you certificate of practice. Now, this is one angle which we have discussed about registered valuer, that is, see, even if you want to do audit of a company, you must be a chartered accountant in practice. That means you should be a member, plus you should have certificate of practice. So how do you obtain that? You have a procedure for that. Now, if you want to do valuation, that is, if you want to undertake valuation assignment, then you must be the member, you must have that certificate of practice, then you can take up a valuation assignment, as simple as that, right? So you can be a registered valuer. Now, when we look at companies angle, because we are reading Companies Act, company at a lot of time where valuation is required to be made in respect of property or stocks or goodwill or any asset or even the liabilities, then it is going to be done by registered valuer. Who will be the registered valuer? The member of the of an organization which is recognized, right? How he is going to be appointed? Just like we appoint an auditor, we appointed our registered valuer also. So if there is audit committee will find out such person who is eligible and who gives consent that fine, we are ready to do your assignment. So such person will be appointed. If there's no audit committee, then the board of directors does that. Whoever is appointed as a valuer has to be impartial, has to exercise due diligence at all times, follow the rules which have been made, should not be interested. If there is contravention, then we have a penalty which is given in section 247(3), 50,000, and if the valuer has contravened, imprisonment up to 1 year and fine 1 lakh to 5 lakhs. Okay. If the valuer is found that he has contravened, if he is convicted, then he also has to refund whatever remuneration he took and also pay the damages. Right. So this is something which is written in section number 247. I have broadly explained you that, and undoubtedly we have some more rules. Now, moving to the next part, removal of name of a company. Removal of name of a company, it is also known as striking off. Right. Usually striking off is done of a defunct company. Any company which wants to exit or it wants to get itself legally dissolved, there is a huge process, there is a long process of winding up. That means you need to pay off your liabilities by selling off your assets, and then thereafter your name is removed or dissolved. But then this is a shortcut process. Now, a shortcut process, of course, this is ideally meant for the companies which are not carrying on any business, so they do not have adequate liabilities, or whatever they have that can be paid, right? So in such a situation, straight away the name can be struck off, right? So such type of companies usually do not have a lot of assets and of course the liabilities, and hence NCLT approval is not needed, and here ROC itself can do this striking off, right? After striking off, of course, the company is dissolved. Now, what happens and how it happens, let's see that. Registrar on 4 grounds. Okay, 1 ground is omitted. Ideally, we have A, B, C, D, E. Ground number B is omitted, so we have 4 grounds. On 4 grounds can strike off. How? What are the grounds? First of all, There is no business within 1 year of incorporation. See, in such a situation, you have an option that you can apply and become a dormant company, right? If you're not incorporated to do business, then you can make yourself a dormant company. If you don't, then of course ROC can remove the name. So if you do not come into business, then the next point, no business in last 2 years and no application also for dormant company, then you have not declared INC 20A. You know what INC 20A is? INC 20A, whenever a new company is incorporated, there are subscribers who have undertaken or who have said that they will subscribe to the shares of the company. So after incorporation of company, shares is issued to them and money is collected from them, right? This has to be declared by the directors that yes, this process has been done. This declaration has to be done within 180 days from incorporation. If this declaration is not filed, this is also one of the ground. Okay, and if ROC goes to inspect, sorry, if ROC goes to inspect, physically verify the place of business, and it is found that you are not carrying on any business, then that is also a valid ground for removing the name of the company. Okay, in such a situation, ROC, what does they do is they give a notice along with the reason by RPAD, that is Registered Post Acknowledgement Due or Speed Post, to company and all its directors at the available addresses. Within 30 days, they have to reply or send the representations. And it is also published in Official Gazette for inviting other objections. On the expiry of that period, the notice is issued in the Official Gazette and the name is struck off. Okay. Now we have another point. That is removal of name of company on receipt of application. This was by ROC suo motu. This is when you receive an application. Company, after on fulfillment of certain conditions, on the same grounds that it is not doing business, and of course all that, if they are regulated by some authority like ADA, they have to obtain the permission of that regulatory body and they have to extinguish all their liabilities. Plus members' approval with more than equal to 75% paid up capital consent or SR, right? So this has to be done. These are the preconditions. If these preconditions are fulfilled, then a company can make an application for removal of its name. There also registrar issues a public notice and thereafter notice in Official Gazette and the name is struck. Right. So we have this section number 248, which talks about the striking of name. Okay. Now, there are certain situations when you cannot make an application. That means there are restrictions. What are the restrictions? If at any time in the previous 3 months you have changed your name or you have shifted your registered office from one state to another, or you have disposed some property, or you have engaged in any activity, because it is important that you are not really doing any business, right? And or if you have made an application for any arrangement or a winding up order has been passed under IBC, then you cannot make an application for striking of name. If you violate that, then you have adequate punishment, right? You cannot also make fraudulent application for removal of names. If you do so, then of course the people who are involved will be jointly and severally liable. Now, if any person is aggrieved by the order of registrar or registrar suo motu, if registrar suo motu or on application with due procedure you have removed the name, the company stands dissolved. Now, if any person is aggrieved within 3 years, if registrar thinks that the removal was wrong within 3 years and the members, creditors, workmen within 20 years, they can apply to tribunal and the tribunal may pass the order to restore the name. If that order is passed, the same order has to be filed with ROC within 30 days. Okay, so ROC is going to restore the name and issue fresh certificate of incorporation. Right? Fine. Thereafter, we have something called as government companies. Government companies. Government company, again, a very small chapter. We ideally have the definition, which is given in section 2 clause 45, which states that if any company in which more than equal to 51% of capital is held either by central government or state government or jointly by both of them, then that company will be a government company. Any subsidiary of a government company is also a government company only. Now, in government company, we have two sections that we have to read, section number 394 and section number 395. Section number 394, where annual report on the working and affairs of a government company, in case central government is the member of government company. So we have only central government who is the member. In such a situation, the annual report is prepared within 3 months of AGM. Annual report plus audit report plus comments of CAG is laid before both houses of parliament, because only central government is involved, right? But where state government and central government both are involved, then what is going to happen? That whatever state government is involved, it is also laid before that state legislature, before houses of that state legislature as well as houses of parliament. If more than one state is involved, then of course it will be laid before each state legislature, right? So it is only that, right? So in government company, we ideally don't have any proper section. The definition stands important because we do not have any other section ideally, right?
Now, another topic for revision. Nidhis. What do we mean by nidhis? Nidhis are, what do you mean by nidhi? Nidhi means money, treasure, right? What are nidhi companies? Just like we have section 8 companies which are formed for charitable objects, we have nidhi companies which are formed for financing, for savings. So their objective, their purpose is slightly different. If I want to form a bank, if I want to incorporate a bank, I can start the business of financing, but that is something which is very difficult given the license that I need to obtain. Plus, I will be under the regulation of RBI. So the easy thing is form a nidhi company, but here financing activities are restricted to the members only. Non-members do not form part of any give and take. So what nidhi companies do, they take money in the form of deposit from their own members, and they also give loan to their members, right? They are formed with the intention to promote savings amongst their members. Fine, ma'am. We have chapter number 21A, which covers nidhis, and we have just one section, one beautiful and small section, section number 406. However, we have a lot of rules under for nidhis, right? So we have to read about rules. We don't have to basically read a lot in the section. Okay. So nidhis are also known as mutual benefit societies. They are formed as a public company. So what happens is, you form a public company, the process of incorporation is same just as of a public company. After you form your company, you have a time period of 60 days. Within that 60 days, you have to make an application to central government NDH4, and you have to get yourself declared as a nidhi company. Okay. That means it's not going to so happen that my object clause has this particular object, so I am a nidhi company. No, this is not going to happen. You have to get yourself declared as a nidhi company. So central government will, in the official notification, they will declare you to be a nidhi company. So now your name will be in the list of nidhi companies. That is what is needed now. Okay. Central government has the power. that through notification, they don't need to amend some act or they don't need to bring in some rules. Through notification only, they can say that this particular section is not going to apply to Nidhi companies, or this particular part of section is not going to apply, or this section is going to apply but with certain modification. So they have this power, and through the notification, central government has actually exempted a lot of provisions on Nidhi companies. So a lot of provisions don't apply to Nidhi companies. They have their own flexible freedom. Now, this notification has to be approved by Parliament, of course. When we come on to the rules part, Rule 1, you don't have anything. Rule 2. Rule 2 tells us the applicability, that Nidhi rules are going to be applied on the Nidhi companies which have been declared under the previous act, which have not applied for declaration yet under the previous act, which have been incorporated under the new act, and which have been declared as Nidhis under the new act, right? So all these type of Nidhi companies, they are going to be under the purview of these Nidhi rules. We have certain definitions which we must know for understanding Nidhi rules. See, Nidhis. What are assets for them? The loans that they give to their members. So they are assets. Now, if I am a member of Nidhi company and Nidhi company has given me a certain loan, I may not pay it. I may not repay it. That means this is an asset to a Nidhi company. This asset may be a standard one. That means constantly they are getting all installments being paid, or it may be substandard. Substandard, that means it is non-performing. Non-performing means for 12 months continuously, no repayment has come. If it extends for 2 years to 3 years, it becomes doubtful, and if it's more than 3 years, it becomes a loss asset. Right, so that is a classification of NPA, which you also know in the banking sector it happens. And Nidhis are like banks only, with limited functions and limited scope, right? So that's how they operate. Now, how a Nidhi company is incorporated, it is going to be a public company. There is a minimum paid up capital requirement. Unlike a public company, in normal public companies, you don't have any minimum paid up capital requirement, but here you have a paid up capital requirement of 5 lakhs, right? There is a restriction that Nidhi companies cannot issue preference shares. It can only have equity shares. That means because Nidhi companies are formed for the benefit of the members, so you cannot give an edge over the members to any other holders, right? So no preference, no debt, nothing allowed for Nidhi companies. Just like private companies have private limited at the end of their name, public companies have limited at the end of their name, Nidhi companies have Nidhi limited as a suffix. It may also include mutual benefit in their name, right? Declaration of Nidhi, as I told you, the companies which are now incorporated, they have a time period of within 60 days from the incorporation, they have to get themselves declared as a Nidhi company. This time period may be extended by regional director. So within that extended time period. Other types of companies, that means which are already existing ones, they have to apply to central government, and central government will notify them as a Nidhi company. When? What is the time limit? Time limit we read in the rules 23A and B, right? So we read it later. If you don't do it, you cannot file these forms. Next is now, although Nidhi companies are formed as a public company with just 7 members, fine ma'am, do you think with 7 members, because they are a public company, they can be formed with just 7 members. With 7 members, you can do a banking business kind of thing. You can do a financing business. No, you need more people. So within 1 year, there are certain requirements which must be accomplished. There should be at least 200 members. The net owned funds of the company should be at least 10 lakhs. What are net owned funds? Paid up capital plus free reserves minus accumulated losses and minus intangible assets. So that is net owned funds. That should reach at least 10 lakhs. Okay. Unencumbered deposits, that means deposits which are definitely not, does not have a charge on it. They should be at least 10% of the total deposits of company plus. The ratio of net owned funds to deposits should not be more than 1:20. What does it mean? Net owned funds, you know, And deposits? What are deposits? See, a member of a Nidhi company may give money to Nidhi company in the form of shares. That is a part of net owned funds. It may also give money in the form of savings account, fixed deposit, RD, right? So these are what? These are called as deposits. Fine. So these deposits should not be more than 20 times of what is net owned funds. Why? Because these deposits may be withdrawn by the members, and if they are withdrawn by the members, the Nidhi company will run into crisis. Okay. Now, this is the requirement that you have to complete within 1 year. So once you complete this requirement, you have to file a form of statutory compliance in form NDH1. It may so happen that within 1 year, you are unable to achieve these requirements. So such time period can be extended by regional director if you make an application. And obviously you will not even be in a position to file this return of statutory compliances if you have not complied with the same. So in that case, you file the statutory compliance return in the next year. Okay, ma'am. Rule number 6. Rule number 6, we have general prohibition. Nidhi companies cannot enter into chit fund, hire purchase, leasing finance, insurance. Why? I have told you in the main class, right? It cannot open current account with its members. Why? Because the reason is to promote savings, right? And current account has nothing to do with savings. Now, it cannot acquire securities of other body corporate. In fact, it cannot acquire that controlling interest. If it wants to make some other company or control its board composition, it has to seek permission from regional director. Otherwise, it cannot do that, right? It can deal only with its members, none other than its members. If the members have taken loan from the company and the members have given gold, maybe against the loan as a security, this gold cannot be pledged somewhere else. Okay, it cannot take deposits or lend money to any body corporate. It cannot issue advertisements for accepting deposits or pay any brokerage on the same, right? So that is something, these are the parts, something which are not allowed. It cannot carry on business other than borrowing or lending in its own name, right? Now, there is one thing which is important. Nidhi companies can provide locker facilities to its members. Nidhi companies can provide locker facilities to its members, but whatever income you are generating, that is the locker rent you will collect, that should not exceed 20% of the gross income. That cannot exceed. Then you can provide locker facilities to your members. Otherwise, you're not allowed to, right? So that is about general restrictions. Every Nidhi is going to issue shares and the nominal value 10 rupees at least. You cannot admit body corporate or trust as a member, not even a minor as a member, but a person can open FD in the name of minor, that's allowed. Net owned funds at least 10 lakh, I have already told you. Now as the Nidhi company grows, see, if I'm running into losses, I will not open another branch. So if I have continuously 3 years profit, then I can open another branch. And Nidhis operate in such a manner that they are for your known people, right? Not just unknown. You will not go out to invest in just any Nidhi company. You should have some background. It belongs to your area or something like that, right? So you can open up to 3 branches. If you have 3 continuous year profits, you can open up to 3 branches within the district. Beyond that, you need permission from regional director, right? I'm trying to tell you all the logic even in the revision class. I just cannot refrain myself from doing that. Anyways, now deposits. This is the part which is not relevant, so I'm not discussing this. Apart from this, your application form for deposits should have certain things. That if Nidhi company does not repay your deposits, where do you go? You can go to ROC. If you have any other complaint, you can go to redressal forum. Okay. The directors will give a declaration that they have complied with all the rules, and they will also state that government does not take any responsibility It often happens that people come up to Nidhi company and they feel that, okay, I'm depositing my money over here, it's going to be safe, government is there. No, government is not there over Nidhi company. Government does not insure your deposits. It does not take any responsibility how sound the Nidhi company is. It may run into losses. So government is not involved. And a verification that whoever is making deposits is giving deposits to the Nidhi company at its own risk. Fine. We have a tenure. FD minimum 6 months, maximum 60 months. RD minimum 12 months, maximum 60 months. And in savings bank, you cannot, you will not get interest beyond 1 lakh amount. See, if people put all the money in savings bank, supposedly they have deposited 50 lakh in a savings bank account, Nidhi company might think that, okay, I can give away loan out of that 60 lakhs, but out of that 50 lakhs, but if I demand it back, Nidhi company will be shaken, right? So just like PPF, here also there is a rule that beyond 1 lakh you will not get any interest on savings. Now you put your money, who will put, right? Okay, so if I want to close my FD, I can. But FD matures. Supposedly I have opened an FD for 5 years and I want to close it at 2 years only. Can I? Yes, you can. Within 3 months you just cannot. Up to 6 months you will not get interest. Plus, if you want to close it at 2 years, you will get interest at the rate for 2 years only. Minus 2% penalty. So if my rate of FD for 5 years was 7%, and my rate of FD for 2 years was 5%, I will get 5% minus 2%, that is 3% only, right? But supposedly I died, then I'll get 5%, because that's not my fault of breaking the FD. Okay, unencumbered deposits, I've already told you, the loans can be given to the members only, but there is again a limit of the loan that can be given to a member. Okay, that means to one member you will not give loan beyond this particular amount. See, if your deposit is less than 2 crores, you will not give more than 2 lakhs. If it's 2 crores but less than 20 crores, not more than 7,50,000. If it's 2 crores but less than 50 crores, not more than 12 lakhs. And if it's beyond 50 crores, not more than 15 lakh rupees. That is the limit which has been given. Members can be given loan against security of gold also, against security of immovable property, and against security of FD, NSCs, other government securities and insurance policies also. You have different conditions and limits, small ones, associated with all these type of securities. Now, what rate of interest do you charge on your loan? Supposedly on FD, the maximum rate that you are giving is 7%. So 7 plus 7.5%, that is 14.5% is the maximum rate that you can charge on your loans. The director of a Nidhi company has to be a member. He will be appointed for 10 years. There will be 2 years cooling period and then he can again be appointed. But he should be qualified to become a director according to section 164 only. Then he will be appointed here also. Nidhi company cannot declare dividend more than 25% or such rate as approved by regional director. But whatever rate be, if a Nidhi company wants to give dividend, it has to comply with 3 conditions. Compliance with rules, transfer to general reserves, and no default in repayment of deposits. Auditor, if an individual auditor is going to be appointed 5 years, firm 2 terms of 5 years, again 2 years cooling period, again you can be appointed. Every Nidhi company has to furnish half yearly return in NDH3, and that is certified by CA or CMA in practice or CS in practice, right? Every auditor that is appointed also has to give a compliance certificate about rules. Now we have this rule number 23A and 23B, which talks about declaration as Nidhi. So if you are a company which is incorporated under the old act, you have a time period of 1 year from your incorporation or 6 months from the new rules, whichever is later, to get yourself declared. and if it's otherwise, you have a time period of 6 months, right? That is something that I've already told you. Otherwise, you have a penalty for contravention if you don't comply with it, right? So I think I've told you all about nidhis.
Okay, now the next section. Section number 447, first of all, we have, which is a section on fraud. So anywhere if anyone does fraud under Companies Act, then this particular section gets invoked. Now this section is divided into two parts. We have heavy quantum punishment and lower quantum punishment. Heavy quantum, if someone is found to be guilty of fraud of an offense involving at least 10 lakhs or 1% of turnover, whichever is lower. So if that is the case, or it involves public interest, and the other case lesser than that, right? Lesser than that. Okay. So these are the two cases, and accordingly we have the punishment: imprisonment minimum 6 months, maximum 10 years, and penalty amount involved in the fraud or 3 times. And if the fraud amount is lesser than that, and it does not involve public interest, then imprisonment maximum up to 5 years, fine maximum up to 50 lakhs, or both, right? So a quick recall on that. Then we have section number 450. I have not written it over here because undoubtedly there are penalties and punishments which you have to learn. So we have another section called as section number 450, which is again something called as penalty only. What is it? Throughout Companies Act, wherever no specific punishment has been given, then this section will invoke, and it has been given that on company 10,000 to 2 lakh penalty can be imposed on any officer in default, 10,000 to 50,000 can be invoked. Then we have section number 454, which talks about adjudication, how the penalties will be adjudged. So central government can appoint as many as they deem fit as the adjudicating officer. The adjudicating officer, of course, looks into the case and makes inquiries and thereafter impose penalties. Okay. They will pass order if you're aggrieved by it. Within 60 days, you can appeal to regional director who can confirm, modify, or set aside your order. You have to comply the order within 90 days. If you fail to do so, then further fine will be imposed. Company fine minimum 25,000, maximum 1 lakh, officer in default, imprisonment and or fine, and the fine is same as per company, right? Adjudicating officer will obviously give an opportunity of being heard before imposing penalty, and so is the case by the regional director. If you appeal, they will also give an opportunity of being heard. Then we have something called as section number 455, which is dormant company, or it is also known as an inactive company. So if a company is being formed for some future project or just to hold some asset, or it is an inactive company, then in such a situation, they can make an application in form MSC1 to ROC and obtain the status of dormant company. ROC issues you a certificate, and ROC also maintains a register on the MCA website which has the list of the dormant companies. Okay. Now, what is an inactive company? That is the question. An inactive company which does not has any business in last 2 financial years, no significant accounting transaction in last 2 financial years, or not filing of financial statement and annual return in last 2 financial years. What do you mean by significant accounting transaction? Significant accounting transaction means other than. If you're making payment to registrar, that is not significant accounting transaction. If you're purchasing raw material, that is. Right. If you are just allotting shares because you have to fulfill the requirement of the act, that is not significant accounting transaction. If you're maintaining records because you have to, that is not significant accounting transaction. Okay. And of course, if you're doing anything to comply the requirements of act, that will not be significant accounting transaction. Other than that, if you do anything, that will be significant accounting transaction. Okay. So if you do that, then you are an active company. Otherwise, you are an inactive company. Right, so such companies are required to obtain the status of dormant company. Now, the dormant companies are also required to comply with the requirements of the section, if you do not comply, then your name will be struck off by the registrar, as we read in the chapter of removal of name of companies. Okay. Then of course, even when you become the dormant company, you must have that minimum number of directors, you must pay the annual fees, you must file certain documents which are required. If you do not do that, your name will be struck off, right? Okay.
The chapter of special codes, it covers sections 435 to 446b. But before we go on to the main sections and the core sections, we have some concepts which we must revise, and these are offenses and penalties. What do you mean by offenses? There are three types of offenses basically. The offenses are bailable, non-bailable, cognizable, non-cognizable, as well as compoundable and non-compoundable offenses. Firstly, if I talk about cognizable and non-cognizable offenses, cognizable offenses are more serious ones. And in that, one thing that you have to remember is that the arrest is possible even without any permission or warrant. However, in case of non-cognizable offenses, which are less serious, an arrest without warrant is not permitted. These offenses could be bailable. These offenses could be non-bailable. Non-bailable doesn't mean that you never have the opportunity to get bail. No. Bailable means that bail is your right and you will get it easily. However, in a non-bailable offense, there are strict conditions of bail which must be fulfilled. Only then a bail can be granted after arrest, of course. What are the conditions? I'm telling you one of the condition, that if you want bail, then the prosecutor shall be given an opportunity to oppose the bail. Only then bail can be granted. So this is the difference between bailable and non-bailable offenses. However, when we talk about compoundable and non-compoundable offenses, the offenses wherein you can get away with the court trial by paying a certain amount, right? Like you enter into an arrangement or a kind of composition, that is known as a compoundable offenses. And other than that, are non-compoundable offenses. Of course, all the offenses which you commit under law are not compoundable. Example, there are 5 types of penalties which are given under Companies Act. What are the 5 types of penalties which are given under Companies Act? Fine only, imprisonment only, imprisonment or fine, imprisonment and fine, and imprisonment or fine or both. So these are the 5 types of penalties which are covered under Companies Act 2013. However, all these type of offenses cannot be compounded. Wherever there is a probability that court can end up in passing an order of just imposing fine, only those offenses are compoundable. That means out of this, I can say that there are 2 offenses which are non-compoundable. There is never an option to compound that offense. They are imprisonment and fine, and imprisonment only. So these 2 offenses can never be compounded. Other than these offenses are compoundable. If at all you want to compound an offense under Companies Act 2013, what is the process of compounding? If I talk about the process of compounding, that is given under Companies Act 2013, which states that when the proceedings have begun or they have not yet begun, if you want to go for compounding, you can make an application to registrar. That is ROC. Registrar, along with his comments on the same, will forward your application to Tribunal, Central Government Officer or Regional Director, whatever the case be. Central Government Officer and Regional Director have a restriction that they cannot compound an offence involving of more than 25 lakhs amount. For that, only Tribunal has the power. Now, they will either compound the offence or they will not compound the offence. If at all they compound the offence, they will inform the ROC within 7 days. There are 2 options. Either the proceedings have already started. If the proceedings have started, they will be stopped. So the ROC will inform the court and the person shall be discharged. He will be free from the proceedings. If no prosecution was yet initiated, of course, there will be no court trial, no proceedings that will be started against the person. There are 3 important points that you must note even in compounding beyond that. One is that compounding is not permissible where investigation is being carried out. So if investigation has started, compounding is not allowed. Secondly, if you have committed an offense for which you have got the compounding done and within 3 years, again, you want to compound a similar offense, that is something which is not allowed. And thirdly, there may be some additional directions which are given to you by the courts before compounding, and those directions must be complied with, otherwise the compounding amount will be doubled. Okay, so after we have read about this, we come to the main and core provisions of special code. The very first one, section number 435, which talks about the establishment of special code. So here CG has the power to establish special code. How many special code? As many as it thinks fit. What is going to be the special code? The old codes, the old session codes can be designated as special codes, or new codes may also be established. Why are they established? They are established for the speedy trial of offences under this act. So all the offences under Companies Act are now going to be dealt only in the special codes, except for section 452. What does section 452 tell us? Section 452 talks about the wrong withholding of property by an employee or officer, the property which belongs to a company. So if you are wrongfully holding the property of the company may bring a suit, and that is not going to be in the special code, that is going to be in some other code, right? Now, what is going to be the special code? The composition or the constitution of special court. I have explained you this before also, that special court does not mean a courtroom. It actually comprises of a judge, right? So who is going to be the one? For the offenses which are more serious and involve an imprisonment of more than equal to 2 years, it is going to be a sessions judge or additional sessions judge. However, for other lesser quantum offenses, it can be metropolitan magistrate or the judicial magistrate of first class. How the offences are going to be tried? If there is any offense under Companies Act except for section 452, it has to go to special court only. Which special court? The special court which comes under the jurisdiction where the registered office of the company is situated. It may so happen that in such area there are two special courts. In such a case, this problem will be resolved by the High Court. So relevant High Court shall specify which special court to approach. What is the process of trial? Whenever a person or an accused is arrested, he has to be presented either before magistrate or special court. Supposedly he is presented before magistrate, the magistrate can pass two orders. It thinks that, okay, fine, some more custody is needed for better inquiry, so it can order detention, extend the detention. And what is the power of granting detention? If it is executive magistrate, maximum detention that he can grant is 7 days, and if it is judicial magistrate, 15 days. However, if he thinks that the detention is not necessary, then he is going to forward it to special court as it is. The same powers are given to special court if the accused is presented before special court. Now, special court will try the offense, and special court can take cognizance of offense on submission of a police report as well. Special court also has been given the power that if during the trial you come to know that the person accused has committed an offense not just under Companies Act but also under some other act, you can continue the trial of that other act also. As well as you can also try the case summarily. That means you can also go for summary trial. There are two types of trial, regular trial and summary trial. What do you mean by summary trial? A regular trial takes a lot of time, but summary trial, there are some situations wherein you believe and you think that this is a case which does not involve much of time and effort, so we can dispose it off in a quick manner. But for not all cases, the summary trial is available. It is available for the offenses which involve punishment with less than equal to 3 years imprisonment. However, it also has a limitation that a judge cannot award a sentence of imprisonment of more than 1 year. So there are two limitations. Now, during summary trial also, if the judge finds that no, I will have to give a punishment of more than 1 year imprisonment, so he will shift the case to regular trial. Or if he thinks that it is not very fit to try the case summarily, then also he can shift the case to a regular trial. So special court after hearing will record and rehear the case. All the offences under Companies Act are non-cognizable except for the offence which is given in section 2126, which is all about fraud. So all other offences are non-cognizable. When shall court register the complaint and initiate the proceedings? When it receives a complaint in writing by registrar, shareholder, person authorized by CG, liquidator, and if it is a case of complaint of transfer or dividend, transfer of securities or dividend and like things, then SEBI can also be the complainant. If the complainant is registrar or the person authorized by CG, their physical presence during trial is not needed. Presence during trial is not needed. Now, after this, we have some small points as well. Section 441, I've already told you. Since special courts are considered as equivalent to the sessions court, if you are aggrieved by the order of special court, you may prefer an appeal to High Court. Moreover, Code of Criminal Procedure is applicable to all the special courts. Section 440, we don't have to read, it is transitional provision. And then we come to section 442, which talks about mediation and conciliation panel. There is not much difference between mediation and conciliation. However, I have made you note the different points. However, if we read the section, the provisions are same for both the things. Mediation and conciliation, there are two aspects which are given in section 442. One aspect is that who can become a mediator or conciliator. So any person who wants to become the mediator or conciliator has to check whether he possesses the requisite qualification or not. If yes, then he can make an application in MDC 1 to the regional director. Regional director may either accept or reject your application. If regional director accepts the application, your name will be included in the panel of experts which is maintained by central government and is updated every year. Now, if you want to withdraw your name from that panel, you may. If you want to, if the government wants to remove your name, they can also remove your name by giving you an opportunity of being heard. The second question comes that if we want to go for mediation and conciliation, how should we approach? That is, how is going to be the process of mediation and conciliation. So when we talk about the process, the proceedings are pending before NCLT, central government or NCLAT, and the parties want to go for mediation, then they have to file a form MDC2 along with the requisite fee and request that the matter be referred to mediation and conciliation cell. If the authorities find the need, then they can also refer the matter suo motu. Once the matter is referred, mediator from that expert panel is appointed and that mediator disposes of the matter in 3 months. Of course, he's a mediator or a conciliator, so he does not have the power of a judge. He can only recommend things. He cannot impose a decision. So he forwards the recommendation to NCLT, NCLAT or central government, whatever the case be. The parties may not be happy with the decision, so they have the option to raise objections. They follow the procedure which is prescribed. That is, they can discuss with the parties, they can fix the time, they can fix the place, they can fix the meetings, they will meet, they will decide, they can have joint meetings, they can have separate meetings, they will collect all the evidences, all the information and give recommendations accordingly. After that, we have some very small sections that a central government can appoint prosecutors as it thinks fit. Central government can also authorize the company prosecutor to prefer an appeal against the acquittal. There can be compensation which can be claimed from the person who has unnecessarily tried to waste the time of the court by filing a by imposing wrong acquisitions against anyone. Whatever fine is collected by the court is applied firstly towards the cost of the proceedings and then for making payment to the other party. Then comes your two amended sections. One is section 446A, which talks about the factors for determining punishment. So whenever court has to give a punishment, it will see and take care of certain factors. What are the factors? What is the size of the company? What is the nature of business? Was there any public interest involved? What is the nature of default? How many times the default has been repeated? So repetition, all these factors will be taken in mind, and then only the punishment will be granted by the court. And we have another amended section, lesser penalties for certain companies, which is an important one, 446B. It says that if penalty has to be imposed, throughout Companies Act, a lot of penalties have been imposed on the company. So if a penalty is, let's say, a company defaults, this company will be liable to a penalty of 2 lakhs. All the companies will be liable to a penalty of 2 lakhs except for one person company, small company, startup company, producer company, its officer in default, or a person connected with such company. So these will be subjected to straight away half penalty. So if the penalty for normal companies is 2 lakh, it will be 1 lakh for this company. If the penalty for normal officer in default is 5 lakh, it will be 2.5 lakh. However, it cannot be 2.5 lakh because therein also a maximum capping has been done. So despite saying that the penalty shall be reduced to half, still there is a maximum upper limit which has been given, 2 lakh in case of company and 1 lakh in case of officer in default. So once again, if I give you an example, the penalty for a normal company is 5 lakhs. Half of it comes out to be 2.5 lakh, but that cannot be imposed even on a small company. So the maximum penalty that can be imposed is 2 lakh, and that only will be imposed. Okay, so I think that's clear. Okay, now the chapter of NCLT and NCLAT. It comprises of sections 407 to section 434, although in the beginning or the initial sections, you don't have much content. We talk about the composition, we talk about the power of CG to constitute these authorities, that is NCLT and NCLAT, and what will be its composition. If I talk about NCLT, it comprises of the president, judicial member, and technical member. Now, who can become the president? Only someone who has been a judge court for at least 5 years can become the president of NCLT. If I talk about judicial member, someone who has been the judge of high court or the judge of a district court for 5 years, or an advocate for 10 years can become a judicial member. If I talk about technical member, practicing CA 15 years, practicing CS 15 years, practicing CMA 15 years, then someone who has experience and knowledge in specified fields for at least 15 years, someone who has been a presiding officer in the labor court or the tribunal established under Industrial Disputes Act for at least 5 years, or someone who has served as a secretary or joint secretary to Indian government in the Indian Corporate Law Service or Indian Legal Service for at least 15 years can become the technical member. If I talk about NCLAT, it comprises of chairperson, judicial member, and technical member. Chairperson, who can become the chairperson, only a judge of Supreme Court or the Chief Justice of High Court. Judicial member, someone who has been a judge of High Court or the judicial member of Tribunal for at least 5 years. Then a technical member, someone who has the experience of 25 years. And of course, proven integrity, ability, specialized knowledge, experience in the specified fields. They will be appointed in consultation with the Chief Justice, and they can be removed also. There are certain grounds of removal. That is, if you become insolvent, if you do an offense involving moral turpitude, if your interest is involved, if you abuse your position. So these are kind of the grounds on which you can be removed. The minimum age is 50 years. However, the maximum age for president is 67. For chairperson, it is 70. For members of NCLT, it's 65. And for the members of NCLAT, it's 67. Their appointment is going to be made for one term of 5 years. Of course, they can be reappointed. So these are all the small points which I have made you recall. Now we come to the main sections. The very first section, that is section number 420. It is opposite of its section number because it talks about rectification. See, whatever application, whatever petition has been given to NCLT, NCLT will hear the case. NCLT will give an opportunity to both the parties to say whatever they have to, collect evidences and all of that, and then pass orders as it deems fit. Whatever order is passed by NCLT, a copy of that order will be sent to the parties. Now, sometimes it may so happen that in the order there's a prima facie mistake. That is a mistake which is apparent from the record. That mistake can be rectified. How it can be rectified? Maybe the parties identify the mistake and they give an application, or the tribunal itself identifies the mistake. So when an application is received, they identify the mistake and give an application to NCLT to rectify the mistake within 2 years from the date of order. NCLT will do so. However, in a certain case, rectification is not allowed. Which case? Where the party has preferred an appeal. So if you have preferred an appeal under section 421 to NCLAT, you cannot go for rectification order now. Section 421 talks about the appeal from the orders of NCLT. So whatever order has been filed by NCLT, you might not be happy and satisfied with the order. So you have a time period of 45 days, which may be extended by another 45 days if sufficient cause is shown and NCLAT is satisfied. So within that time period, you can file an appeal in prescribed form with prescribed fees to NCLAT. What will NCLAT do? It will again call the parties, hear the parties, give an opportunity of being heard to both the parties, listen to them, hear the case, and then either confirm the order of tribunal. That means it can say and stand and abide by what tribunal has done, or it can modify, make some changes in the order of NCLT, or it can set aside the order of NCLT. Whatever decision NCLAT takes, a copy of that order is also given to the parties and also to the tribunal, because tribunal is also one such party, right? Thereafter, if you want to appeal, you have to take help of section 423, where you can file an appeal within 60 days to Supreme Court. Supreme Court can again give you an extension of maximum 60 days. So 60 plus 60, you can file an appeal to Supreme Court using section 423. But one thing that you have to ensure is that you can file an appeal to Supreme Court only on a question of law and never on a question of fact. But there is one more point in section 421. What is it? You can file an appeal to NCLAT, that's not a problem. You have the time period also given. But you can file an appeal only if there wasn't consent involved. That means if NCLT has passed an order to which the parties have consented, when you have given consent, how can you again withdraw the consent and then file an appeal? No, once you've agreed, how can you disagree the very next moment? Right? So you don't have the option to appeal if the order passed is with the consent of parties. Right? Now, whatever appeal, whatever application, whatever petition is received by NCLT or NCLAT, they have to dispose it off expeditiously. That is the whole intent and purpose of forming NCLT and NCLAT. So their endeavor, their effort should be to dispose of the application within 3 months. However, if it cannot be done, then you have to record the reasons why you could not dispose of within the above time limit, and the president or chairperson, whoever your head is. If you're NCLT, then the head is president. If you're NCLAT, then there is a chairperson. So they will grant you extension maximum 90 days. Maximum 90 days. Appeal to Supreme Court, I've already told you. To carry out this whole procedure of inquiry or investigation, whatever they are doing and trying to find out or resolve the issue, they need some powers and they need some guidelines also. So one thing, they will not be guided by Code of Civil Procedure. They have to keep in mind Companies Act, they have to keep in mind IBC, and they have to keep in mind principles of natural justice. So they are guided and governed by these three and not by the Code of Civil Procedure. However, they have the powers as are given to a civil court while trying their suit. That means they can call people, they can enforce their attendance, they can issue commissions to them, they can ask for documents, they can even take affidavits, they can call for any public record or document, they can pass ex parte orders, they can set aside ex parte orders, they can dismiss the representations in case of default, they can even set aside the representations in case of default or any other matter. So these are the similar powers which a civil court has while they try their suit, and the same powers will be given to NCLT and NCLAT also while they are trying a suit. Fine, ma'am. Apart from this, sometimes to enforce or execute your order, you need to take the help of the local court jurisdiction or the local jurisdiction. So, how do you do that? A company is registered over here, you take the local district court or you take their help. So you give a request to that particular court, and they will get the order executed in the same manner as if it were their order, right? So this is the way that you can get your order enforced. You may take assistance or execution of orders from the court where the registered office of the company is situated if the order is against the company, or where the person ordinarily resides where the order is against a particular person, right? Now, after this, if I talk, then if you do not follow the orders of the court, of course, that is contempt of court. And NCLT and NCLAT also has been conferred the power that if someone does the contempt of court, you have the power to punish them in the same manner as High Court has the power. You can delegate your powers to the officers, employees, and your officers, employees, president, members, they all will be called as public servants and will be guided by the rules thereof. You will get a protection just like every judge gets. If a judge makes a judgment, it may not even be very correct and appropriate, but a suit cannot be filed against the judge, right? In the same manner, you also get that protection that if you have discharged your duties in good faith, then no suit can be filed against you that you did this, you did that. No, whatever evidences, whatever facts and circumstances were produced before me, I took decision based on that, and that is my duty. I discharged my duty in good faith, so you cannot question me. Then we have section 429, which talks about seeking assistance. So during winding up or during any IBC proceedings, NCLT wants to take into their custody some papers or some documents or some property. It needs the help of local people out there. So local administration, who is involved in the local administration, it is the magistrates. So you request in writing, Chief Metropolitan Magistrate, Judicial Magistrate, or District Collector, they will help you. So they will take whatever steps they have to, they will use police force, they will use whatever force is required, they will take that property into their possession and hand it over to NCLT. The civil courts are not allowed to intervene. No, absolutely not. Even you cannot go to any court and obtain any stay order against the proceedings of NCLT or NCLAT. That is something which is not allowed. At the same time, sometimes in the constitution of NCLT and NCLAT, there might be some defect, but that defect is not going to invalidate the proceedings which have been done so far. Okay, so whatever cases have been heard, whatever decisions have been taken, they all will remain valid. Apart from that, you also have an important section 432, which gives you a right of legal representation. So whenever you have to present yourself in front of NCLT, NCLAT, or any authority, what you can do is you can either go in person or you can authorize someone else like chartered accountant, someone else like company secretary, someone else like a legal practitioner, or any other person. So they can also represent you in legal proceedings. So you have a right to legal representation. And lastly, the Limitation Act is going to apply. You also have the section 434, which is irrelevant and not at all material now. That is a transitional provision which only tells us that whatever pending proceedings are there in front of CLB, they will be transferred to NCLT. So that is something which you don't need to read. Okay. Okay, let's now revise SEBI and SEBI loader, the two chapters which are interconnected to each other. First of all, we are going to discuss about the SEBI Act. In SEBI Act, the first thing that comes into our mind that what is SEBI? So Securities and Exchange Board of India is a body and authority which was established even before the act came into force, but it got powers in 1992. So it was established in 1988. However, it got powers, it became the autonomous body, it got legal character, all in 1992. The objective of the act was simple. Two objectives, two prima facie objectives. One is to protect investors' interest, and second is to promote and regulate securities market. So which authority became the regulator of the securities market? It is SEBI. SEBI is a statutory body as it got its powers from the statute. It is a body corporate according to section number 3, which means it has all the powers, all the features of a body corporate. It has the capacity to sue and be sued in its own name. It is artificial person, perpetual succession, and all of that. Now, the basics, the initial sections talk about only the basics of SEBI, that is constitution or composition, which comprises of chairman, a member from Ministry of Finance, and a member from Corporate Affairs, a member from official of RBI, 5 other members, of which at least 3 shall be whole time. So in total, you have 9 members. They all are going to be the persons of ability, integrity, and knowledge or expertise in the field of law, finance, eco, accounts, and administration. They're going to hold office for 5 years, and part-time members for 3 years at once. They can be reappointed once their tenure expires, but they have a retiring age of 65 years in both these cases and no age specified for part-time members. However, even before their tenure, that means if a member is appointed for 5 years, even before their tenure, it may be removed by central government. When central government removes them, central government will give them 3 months notice, or it can straight away give 3 months salary and ask them to leave. If you want to resign, that you also have to give 3 months notice to central government, and you can resign from the position of member or chairmanship. However, on certain grounds, central government has the power to remove them without any notice when they become insolvent, or they become of unsound mind, or they are convicted of an offense involving moral turpitude, or they abused their position. So in such a situation, central government will just give them an opportunity of being heard and remove them. SEBI will have, of course, a lot of officers and employees as it may deem fit, but SEBI is going to meet at such place and such time as prescribed. However, all the meetings will be presided over by the chairman. So chairman shall preside over the meeting, and chairman will also have a casting vote. If chairman cannot be present in any of the meeting, then the members who are present, they amongst themselves will choose a person who is going to preside and have a casting vote. There is a section 7A, which tells that the members cannot participate, the interested members. Now, when I am going to be interested, if I am also a director of some company and I have some financial interest in the matter which is being discussed before SEBI, then in such a meeting, I will disclose my interest and refrain myself that I am not going to participate. I cannot participate, and in fact, I cannot even vote. I cannot be even part of deliberations. Fine. Then there is a small section number 8, which clarifies one thing. Supposedly there was some defect in the constitution, or maybe some position of the board was vacant, or maybe some procedure was not followed appropriately. Despite that, all the proceedings of Securities and Exchange Board shall remain valid. Nothing of these sort is going to invalidate the proceedings. SEBI. It is the duty of the SEBI to promote, protect investors' interest and promote and regulate securities market, just like the objective of the act. However, there are certain more functions which SEBI discharges, or certain more powers which SEBI has. You can consider them either way. The power or the function or the duty to regulate stock exchange. Then there are certain intermediaries. Intermediaries are the ones which connect the investors and the stock exchange, like the brokers, the share transfer agents, registrar to an issue, bankers to an issue, merchant bankers, then underwriters, portfolio managers. Then we also have depositories, depository participants, custodians, all of them. Apart from this, we also have some pooled investment vehicles like collective investment scheme, venture capital funds, mutual funds, all of these. All of these have to be registered with SEBI under Section 12. Section 12 talks about the registration certificate which each of these intermediaries or these funds must obtain from SEBI. So they will obtain registration, they will be under SEBI, and SEBI is going to regulate all of them. Apart from this, SEBI also regulates the self-regulatory organizations. Fraudulent or unfair trade practices are completely prohibited by SEBI. Promoting investors' education, prohibiting insider trading, the whole thing from where it actually started. Insider trading means what? It means you have some unpublished price sensitive information which is not available to public. So you have some information which can affect the prices of the stock, but that is available only to you and not to general public, and that's why you can use this information to your advantage to buy shares or sell shares and make profit thereafter. So this is insider trading, which is going to be prohibited by SEBI and also regulated. Some big takeovers, some substantial acquisition of shares, that is also going to be regulated. And SEBI shall also have the power to call for information. Information from whom? Information for doing some inspections under the Act, and also information from banks, officials, and all that. Now, after this, SEBI has the power to carry out inquiry or carry out investigation. And after this inquiry and investigation, SEBI has the power to impose penalty because of the contravention and collect the disgorged amount, whatever amount you have unfairly earned, not really earned, but whatever amount you have unfairly taken. That disgorged amount shall be transferred to IPEF, which is going to be established by SEBI. Now, there are two sections which have been combined over here. One is section 11C, and in fact after this 11AA we have power of search and seizure. This is also a part of section 11C only, so we will read all this, we will revise all this collectively. See, if first of all, there is any transaction which is detrimental to the interest of investors, or if there is non-compliance with any of the provisions by any intermediary or by any connected person, then SEBI has the power to investigate. How will SEBI investigate? SEBI will appoint an investigating authority, and that investigating authority will investigate and report to SEBI. During that investigation, investigating authority has the power to examine on oath, take notes on examination, in fact, retain books, and also the power of search and seizure. How? For obtaining the power of search and seizure, investigating authority during investigation first makes an application to the magistrate or judge who will authorize them that yes, you can. Right? It is like obtaining a warrant, right, for search. So they get the authorization, they enter with assistance, search and seize whatever documents they have to, keep the book still investigation, place identification marks, and during inquiry or investigation, they can also, SEBI can also suspend trading, that this security will not be traded as of now. Restrain some person that you cannot enter into any security transaction on stock exchange. If some office bearer is involved, that is some official from stock exchange is involved, then they can suspend that office bearer. And they can also retain the proceeds or attach some property which they suspect to be any disgorged property or amount, right? So that can also be done. Apart from this, if the company is indulged in unfair, fraudulent trade practices or insider trading, then SEBI undoubtedly can impose penalty post inquiry. Fine. So SEBI has the power to inquire, investigate, search and seizure and all of that through different modes. Now we come back. SEBI has the power to issue directions. SEBI has the power to levy penalties. SEBI has the power to make regulations. After this, we have a section CIS, which is about one of the pooled investment vehicle. What is CIS? Collective Investment Scheme. That is, there are a lot of investors who collectively invest to earn profit, but they don't manage this fund. It is being managed by some other person. They don't have any control, like mutual fund. But obviously, cooperative society, NBFC, insurance, pension, nidhi, chit fund, deposit, mutual fund, or any other notified scheme is not CIS. Other than that, if you follow this criteria, if you fall under this criteria, you are a CIS, and then you have separate CIS regulations to be followed. Right? Okay. After that, we also have a very small section called as cease and desist proceedings, that is section 11D, which tells if a company is involved in insider trading or market manipulation, then cease and desist order can also be passed by SEBI. Section 12 talks about obtaining registration certificate, which I've already told you. So every intermediary and all the pooled investment vehicles, they all have to obtain a registration certificate. Board also has the power to cancel or suspend their certificate of registration. Section 12A talks that you cannot have manipulative and deceptive devices. There is complete prohibition on the same. Then we have something called as penalties. Now there are a lot of sections to HB, right? So we have a lot of section. We have a series of 15 number sections. But then I'm not discussing the penalties for revision over here because undoubtedly it's just going to waste your time. If I say the penalty, that's not going to help you to retain the penalty. It is you who can help yourself to learn the penalty. So for that, we have a penalty summary, penalty chart, which has been shared with you in the main book. You have to review that constantly to learn penalty. So ask yourself, how much penalty have you remembered? There are some penalties which have been clubbed, that for all these contraventions, the penalty remains the same. So you have to learn that penalty and don't ignore it, considering it not important or because it seems difficult for you to learn, because in this chapter, penalty part is very important and relevant, so that you are going to revise right away through that summarized chart and ask yourself what is the, even if you don't have the summarized version, doesn't matter. What matters is that you must learn it. So it's only you who can recall it 10 times, 20 times and learn it. So you have to see whether you know it or you don't. If you don't know it, if you don't if you cannot recall it, then hold on for a moment and revise it twice, thrice, 4 times, and then try to learn it. Okay. After that, we also have another important part left in the chapter. After that, we don't have much relevant things. Power to adjudicate, or adjudication and appeals part. What is power to adjudicate? Who has the power to adjudicate? Of course, board. How will the board impose penalty? We have read that SEBI has the power to impose penalty, but SEBI must ensure that there is contravention, first of all, and then how much penalty should be imposed. So for that, they have adjudicating officer. So not below the rank of division chief can be appointed as an adjudicating officer who shall hold an inquiry. Then they can ask people, they can ask for documents. If they find the contravention, then they will also have the power to impose penalty. But whenever they impose penalty, they have to take care of 3 factors. Factor number 1, how much have you gained? Factor number 2, how much the other person has suffered the loss? And factor number 3, what is your nature of default? Is it repetitive or is it one time, the first time you have done? Right? So considering that, they will impose the penalty. Whatever penalty order has been passed, you have to pay that penalty. In fact, SEBI has the power to enhance the penalty after giving an opportunity of being heard within 3 months. However, in between that comes SAT. What is SAT, Securities Appellate Tribunal, which is established by central government. It has a presiding officer, it has some judicial members and technical members. They work through benches. So every bench shall have one judicial member and one technical member. Judicial member, or first of all, presiding officer, he can be the judge of Supreme Court or the Chief Justice of High Court, or if someone has been the judge of High Court for 7 years, then they can also become the presiding officer. Judicial member, judge of High Court for at least 5 years. Technical member, secretary, additional secretary in the ministry or any equivalent post in the government. They are appointed for 5 years. They can be again reappointed, but their retiring age is 70 years. Their retiring age is 70 years. Now comes an important section, which is 15T, where you make an appeal to Securities Appellate Tribunal. When can you make an appeal? If you are aggrieved by the order of SEBI, if you're aggrieved by the order of adjudicating officer, if you're aggrieved by the order of ADA and PFRDA. So under ADA and PFRDA also the same Securities Appellate Tribunal goes. So if you are aggrieved, within 45 days you can appeal. They will try and dispose of, that means either confirm, set aside or modify the order and dispose of your appeal within 6 months. So their endeavor will be to dispose of it as expeditiously as possible within 6 months. But if you're still aggrieved, then you can appeal on a question of law within 60 days to Supreme Court. Right? Okay. After this, we have SEBI LODR. SEBI LODR is applicable to all listed entities. By listed entities, I mean not just the listed companies, but also the body corporates which are listed. Listed means what? Listed means they are any of the securities, debt, preference, equity, idea, securitized debt instruments, units of MF, that is mutual fund, security receipts, any. They are listed on whether main board, SME or ITP. So they will be listed entity and they have to comply with SEBI LODR. If they don't comply, it amounts to contravention of SEBI Act. Now, what are SEBI LODR regulations? First of all, we deal with there are so many regulations, there are 6 schedules also, but we will read whatever regulations are there in our syllabus and which is asked in examination. So first of all, some common obligations. Common obligations like what, ma'am? The KMP, director and the promoter and any person who is dealing with the listed entity must comply with the obligation. So if you're a listed entity or if you're dealing with listed entity, you must comply with these obligations. And you must have a compliance officer. Who will become the compliance officer? Only a qualified company secretary can become the compliance officer, who shall be responsible for prima facie 4 duties. Duty number 1, compliance. Duty number 2, coordination with board, stock exchange, depositories, everyone, and reporting to board and all that. Duty number 3, monitoring the email address of grievance redressal division. And duty number 4, following correct procedures. Apart from that, listed entity shall also have a share transfer agent or manage this facility in-house. Then we come to a list of regulations made for board of directors. What are these? The composition of board. The board of every listed entity shall have at least 50% directors to be non-executive. At least 50% directors to be non-executive and at least 1 woman director will be there, which is the same requirement as under Companies Act. However, if you fall in the category of top 1000 companies, then your woman director must be independent. So you must have 1 independent woman director. It can be either the same woman director or you appoint some other woman director who is independent, who fulfills the criteria of independence. Fine. As far as independent directors are concerned, if the chairperson is non-executive, 1/3 of board has to be independent. If the chairperson is also executive, then half of the board has to be independent. If you fall in the criteria of top 2000 companies, then you must have minimum 6 directors. In Companies Act, we have just basic things 1, 2, and 3, minimum number of directors for OPC, private, and public. Here we have 6 directors if you fall in the top 2000. Okay. The retirement age of non-executive directors, 75 years unless SR is passed. As regards meeting, they will meet for at least 4 times. The gaps will not exceed 120 days. If you fall in the top 2000 companies, then the quorum higher of 1/3 of strength or 3 directors with at least 1 independent director. Now there is incorporation of something more, that whatever independent directors are on the board, their performance and their criteria of independence must also be evaluated by the board from time to time. Okay, so that will also be done. There is something more, some limit on directorship as well as on membership of committees, the committee like audit committee, SRC. On directorships, you cannot be a director in more than 7 listed entities. If you are MD or WTD in any listed entity, you cannot be an independent director in more than 3 listed entities. You cannot be an independent director in more than 7 listed entities. Simple 3 things. If you are member of committee, you cannot be a member of more than 10 committees of all the companies. You cannot be a chairman of more than 5 committees. Okay. Now we have something called as corporate governance with respect to material subsidiary. What is material subsidiary? We all know subsidiary. Material subsidiary means whose income or net worth exceeds 20% of the consolidated net worth or income. That means if I combine the income of all the subsidiaries along with the listed entity, it's 20%. The income of that subsidiary is more than that amount, then that subsidiary becomes my material subsidiary. And if that is the case, I have to identify all the material subsidiaries, and every material subsidiary must have at least 1 independent director of this listed entity on the board of that company. All the significant accounting transactions shall be periodically brought to the notice of the board of directors of listed entity by that material subsidiary. Before disposing of shares of that material subsidiary in such a manner as it results in a non-subsidiary. That means if I hold 60% shares of that material subsidiary, I am trying to sell 15% shares. That means my shareholding will become less than 50%. So it will no more be my subsidiary. If I want to dispose of shares in such a manner, then before doing this, I must obtain SR. In general meeting of this listed entity, then only I can dispose of shares. Now we have some quarterly compliances like what? Investor complaint statement. Complaints at the beginning of the quarter, complaints received, complaints solved or disposed of, and complaints at the end. Within 21 days from the end of quarter. Compliance report as we read in Schedule 5. Within 21 days. Shareholding pattern. 1 day prior to listing, 21 days from end of quarter, and 10 days of capital restructuring, that is change in more than 2% of paid up share capital. If that comes within 10 days, it has to be reported. All this is going to be reported to stock exchange. Whenever we come up with any public issue, rights issue, preferential issue, whatever we have issued, we have raised funds. Till we utilize this funds, we have to continue to report on quarterly basis our proceeds, our utilization, and our deviation. That means this was the projection and this is what we have actually utilized. So whatever deviation or variation is there, that has to be reported till the proceeds are completely utilized. Financial results within 45 days from end of each quarter. Then, in certain cases, we have to intimate about our board meetings to stock exchange. In what cases, ma'am? If in the board meeting we are going to discuss about buyback, delisting, raising of funds, dividend declaration, or giving away of bonus, if in the board meeting we are going to discuss any of these agendas, then at least 2 clear working days prior of board meeting, we must intimate the same to stock exchange. Likewise, if we are going to discuss about the financial results, quarterly, half yearly, annual, at least 5 days prior to board meeting, intimate to stock exchange. If we are to discuss about changing or altering the rights of the securities holder, or we have some debentures issued and we want to change the repayment date, then at least 11 working days prior to board meeting we have to intimate to stock exchange. We also have to intimate the record date at least 7 working days prior. Then we have some annual compliances. Annual compliances. Annual compliances like what? Financial result, the most important one and the only one that you have to read. Financial result has to be reported within 60 days of end of financial year. Apart from that, you have your annual report. Financial results means your audit report as well as your balance sheet, P&L, your financials, right? Annual report includes the whole set. So annual report is given 21 days before AGM to all the shareholders for circulation. It is circulated and thereafter at AGM they can adopt the same, right? So it is sent. Now, when it is sent to shareholders before or on the same day, not later than when it is sent to shareholders, before or on the same day, the annual report, the notice of general meeting has also to be sent to stock exchange as well as placed on the website of the company. So that is also an annual compliance which must be done. Apart from this, we have some board of directors committees. We have 4 committees in this chapter: audit committee, stakeholders relationship committee, nomination and remuneration committee, as well as RMC, that is risk management committee. All these 4 committees are required and they are very important from examination perspective also. But then again, you have to learn all that content. How many number of directors, number of independent directors. In fact, in RMC, you can have senior executives also as the members. However, for quorum, you must have at least 1 director present in the RMC meeting. Right, so these are just the crisp contents that you must learn, which can be revised through the summary table. Okay. Okay, so now the revision of Foreign Exchange Management Act 1996. Now, let's come straight to the point. That is the first relevant topic, residential status. But before we read residential status, before we revise it, we also need to know who a person is. So a person is an individual, HF, company, partnership firm, LLP, any body of individuals, association of persons, all of that. Apart from that, a person, any branch, office or agency is also a person. So they are also separately distinguished as persons and their residential statuses also need to be determined. Fine. But why do we need to determine the residential status? Because we have to make rules for entering into foreign exchange transactions. Ma'am, what is foreign exchange transactions? First thing you have to understand is what is foreign exchange. Foreign exchange includes foreign currency. What is foreign currency? Foreign currency means any currency other than Indian currency, that is INR. What is Indian currency? INR, of course. But what is currency? Currency does not necessarily mean the currency notes, but it includes the letters of credit, the checks, travelers' checks, postal orders, money orders, everything, right? So a lot of part is included in currency. Indian currency, anything other than Indian currency is foreign currency, and foreign exchange is beyond foreign currency because it also includes the deposits, etc., which are payable in foreign currency and some other things. So ultimately, foreign exchange is something for which rules are made. Why? Because the government is regulating the same. Okay. So first thing is to determine the residential status. You can be a person resident in India or you can be a person resident outside India. Who a person is, that you already know. Now, this residential status, when we have to determine for an individual, how do we determine that? if I have to check, if I have to enter into any foreign exchange transaction, I want foreign exchange, I want dollars, will I get it or will I not get it? That depends upon my residential status, that whether I am a PRI or whether I am a PRY, right? So if I reside for more than 182 days in previous year, that is the first condition which must be fulfilled for me to become a PRI. If that condition is not fulfilled, straight away I am a PRY. That means even if I have come for employment from some other country, but then I do not fulfill this first condition, I will be a PRY. If I fulfill this condition, then still some things need to be checked. That is, condition number 2 needs to be checked. Why have I come out? Why have I come to India? I have come to India, and in the previous year, I was in India for more than 182 days. Supposedly, I am not residing permanently in India. I have come to India. So why have you come to India? If I have come to India for business, for vocation, for employment, or for an uncertain period, then they'll consider me as PRI, because now I'm here to permanently settle down. But if I've just come to India for some visit or anything like that, and I've stayed for some longer tenure, they will not consider me as PRI. So I will be a PROI. I hope you can find and trace it in the chart. Now, if I have gone out of India, so why I have gone out of India? Have I gone out of India? I was there in the previous year for more than 182 days. If I've gone out of India for employment, business, vocation, or uncertain period, then I am a PROI. From the same day when I go out of India, I cease to be the PRI and I become PROI. But if I've just gone out for some visit and all, I will still be a PRI. Now we come to persons other than individual. Persons other than individual. That means a company, LLP, anything like that. So if they are incorporated in India, PRI, not incorporated in India, PROI. But the branch, office or agency, they're not incorporated anywhere. They are located. So if they are located in India, undoubtedly PRI. But if not located in India, that means located outside India, then in all the cases, they are not PROI. Sometimes, if there is a branch, supposedly a company is here, but branch is somewhere else, that branch is controlled by this Indian company, so that branch will also be a PRI. So any branch, office, agency which is controlled by or owned by PRI, then that will also be a PRI, otherwise it will be a PROI. Now after we have known the residential status, the question is, how can you get foreign exchange? So no person can deal in foreign exchange according to section 3 on its own. You need someone who is authorized to do so. We have someone called as authorized person, about which we read in section number 10, though I will tell you. There are 3 basic authorized person: authorized dealer, which is the banks, money changer, and offshore banking unit. So only they are authorized person to deal in foreign exchange. So if we want foreign exchange for any purpose, supposedly my relative stays abroad or I am going out of India, then I will need some money undoubtedly. So I need dollars. Where will I get dollars from? From these authorized person only. I cannot get dollar from anywhere else. I cannot make any payment outside India. I cannot receive any payment from outside India just like that. I cannot acquire any asset outside India. But we all have that, right? There are people who have that, right? So this whole section 3 is written like except as otherwise provided in the act. So if any act, provision of act, if any rule, if any regulation, if any master direction, circular, anything permits, then that can be done. So it's not that these transactions are prohibited, these things are prohibited. No, generally this is the instruction which is given except as otherwise provided under the act. Then come to section number 4, which talks about holding of foreign exchange. So I cannot hold dollars. I cannot acquire, I cannot hold, I cannot own, possess, transfer anything, not foreign exchange, not foreign security, not immovable property. However, there are provisions which permit the same. So according to those provisions, I can hold, I can transfer, I can possess, I can do those things. Clear? Fine. There are 2 types of transactions, and the 2 most important things that we have in this chapter. current account transactions and capital account transactions. Both are defined in section number 2. Capital account transaction, any transaction which alters that is assets, foreign assets and liabilities of PRI or Indian assets and liabilities of PROI. What is current account transaction? Anything other than that. But current account transactions definition specifically includes 4 things. If you are making payment for trade, that is import export, it is current account transaction. If there is short-term credit, as we have discussed, buyer's credit, supplier's credit, they all are current account transactions. Interest on loans, income from investment, living expenses for your children, parents, spouse, travel expenses, education expenses, medical expenses for your children, parents, spouse, right, along with your own self. So they are all current account transactions. Now, 2 things we have read so far: residential status and the transactions. That means, ma'am, if I want to travel abroad, it is a current account transaction. Is it permitted? I mean, we have made the classification, but how do we come to know that we can enter into such transaction or not? So current account transactions are all freely permissible unless they are prohibited, they require approval of CG, of RBI. Okay, so we read current account transaction, section 5, read with Foreign Exchange Management Current Account Transaction Rules 2000. All these are freely permissible unless. So we read these with these rules, and rule number 3, 4 and 5 are important, and schedule 1, 2 and 3 of this is important, right? So in schedule 1, we have a list of prohibited current account transactions for which you cannot get foreign exchange. Let's have a look at that list. See, they are all permissible unless they fall in the list of rule 3, schedule 1, prohibited transaction. Role of foreign exchanges not allowed. If you are traveling to Nepal and Bhutan, obviously their Indian rupees freely convertible, freely acceptable, so you don't need foreign exchange for travel to that places, and you'll not get foreign exchange for the same. And then there is a list which is given in schedule 1. If you have earned a lottery and you want to remit that lottery money out of India, you'll not get foreign exchange for that. If you want to get foreign exchange for purchasing some lottery ticket or some magazine which is banned, no. If you want to pay commission on exports, you will get foreign exchange, but not to joint venture or wholly owned subsidiaries. If you want to pay commission on exports under rupee state credit route, no. Rupee state credit route is a kind of arrangement between 2 governments, okay, wherein government is giving you a platform that you export. So why do you need to pay commission? Dividend balancing. Sometimes dividend is required to be balanced with an equivalent amount of inflows. Only then outflows are allowed. So it has going to be balanced. So ultimately foreign exchange is not required. Callback services. That means you are not using Indian telecom operators. Instead, you are using a telecom operator of some other country. That is, person is calling you back and is connecting you to some other country. So this is ideally which has been stopped also, and for this you will not get foreign exchange. Likewise, NRSR account has also been discontinued, but the interest of it will not give you foreign exchange. Okay, so this is a huge list, I know, but then you have to learn it. In fact, it is being dealt in classes in such a manner that I don't think any student anywhere, it doesn't matter where you are studying, how you're studying, but you take it repeatedly. So ultimately you end up learning it, I am sure. Okay, then we have schedule 2. The transactions given in schedule 2 require central government approval. Now here central government means through respective ministries. So central government works through its respective ministries, and those ministries will give you permission. So drawl allowed if approval obtained. First thing, cultural tours, Ministry of HRD. So if you want to go for any cultural tour and you want foreign exchange for that, you have to get approval from Ministry of Human Resource Development. In fact, there is a proper Department of Education and Culture, from where you get permission. Then these coming 3 points are for PSUs specifically. If they want to get advertisement done in print media, which the amount of which exceeds 10,000 USD, they will not get foreign exchange unless they get approval from the Ministry of Finance, Department of Economic Affairs. However, in 3 cases, they can get foreign exchange without CG's approval. When they want to advertise their tourism or for international bidding or for investments. Freight of vessel by PSU. So if PSU has to pay freight for hiring a vessel, then foreign exchange will be given only when you obtain the permission from Ministry of Surface Transport. If PSU or government department is making imports on CIF basis, that is cost, insurance, freight, everything they are bearing, then also they need approval. Same, Ministry of Surface Transport. Multimodal transport operators, who are they? The operators who get the goods transferred from one place to another, but they are using different modes of transport, not just one mode. That is not just by truck, but maybe by truck, sea truck, something like that, right? So in such a situation, the facility that they use abroad, that is their agent, they collect money in INR, but they have to pay their agent in foreign exchange. So for this payment, you need to obtain a registration certificate from the Director General of Shipping. Hiring charges of transponders. If you want some of your show to be telecasted somewhere else, then you have to pay for that, right? So you need to obtain permission from Ministry of Information and Broadcasting. Container detention charges, the huge containers wherein the goods are being filled and they are being exported, they are being shipped, right? So those containers are being hired and you have to pay charges from them. If you detain it for long, then you have to pay more charges, right? In such a situation, there is a rate which is prescribed by the Director General of Shipping, and if you exceed that rate, that means you need more funds to pay for that, then you need to obtain the permission, and thereafter you can pay it. Prize money. Sometimes there are a lot of activities which happen abroad. So international, national and state level sports bodies can sponsor any amount. But if we want to sponsor any amount, then 1 lakh USD is the upper caping. After that, we need to obtain the permission from Ministry of HRD, again, Department of Youth Affairs and Sport. Then membership of P&I Club, Protection and Indemnity Club. This is again for a kind of ship insurance. But for that, you need CG's approval. Okay. Insurance Division of Ministry of Finance. Fine. Now, first schedule, prohibited. Second schedule, CG's approval. Third schedule, this is like freely permissible kind of transactions. They have a caping. They have given you a limit. If you do the transaction within this limit, no approval. Beyond this limit, RBI's approval is needed. What is the limit? There's a huge limit which has been given, 250,000 USD per financial year per person, right? So a huge limit has been given. So if within the limit, within prescribed limit, withdrawal without RBI's approval, it exceeds the prescribed limit, then approval is needed. For what transactions, ma'am? Private visits. There are some specified transactions and then there is a buffer. All kind of capital account transactions are covered here unless they are prohibited in others. Private visit. If you go on a private visit to any country other than Nepal and Bhutan, because for there you don't need foreign exchange. So if you visit any country, then you can get up to 250,000 USD without any approval. If you want to gift, if you want to donate. If you are going out for employment, if you are immigrating, you're shifting to another country, maintenance of your close relatives abroad, for your business travel, for your medical treatment, for your studies, and all other types of capital account transactions are covered here. There are 3 stars which I have made, 4 stars, some people might say: immigration, medical treatment, and studies. Now, these are 3 expenses for which 250,000 USD might not suffice, because if medical treatment is very huge and expensive, then every time obtaining RBI's approval will be a little difficult, and even RBI will be occupied with so many applications. So for them, it is written that it is permissible up to your actual expenditure. So even if your actual expenditure is more than 2,50,000 USD, then also it is allowed, it is permitted. Fine, ma'am. So these for individuals. Now we have some permissible things for other than individuals also. So they also have a limit. If it exceeds that limit, you need RBI approval. If it is within the limit, you don't need RBI's approval. But what is the limit? The limit is separately given for each type of transaction. The first thing, supposedly there is a company who wants to donate for creation of chair, or contribution to any educational institute or to any technical institute which is working in the same field. Up to this amount, what amount? This amount has to be calculated. This amount will be lower of 1% of your exchange earnings of 3 years or 50 lakh USD. So whatever amount comes, up to this amount you can donate without RBI's approval. More than this amount, you need RBI's approval. If you want to pay commission, you have a flat in India, you have sold it to some foreign person who was brought by an agent abroad. So you have to pay commission to that agent, for which you need foreign exchange. The maximum amount that you can get without approval is the amount calculated, which is higher of 25,000 USD or 5% of inward remittance. Next, you are paying for consultancy services. Consultancy services have a huge capping. If it is infrastructure consultancy up to 1 crore USD, you don't need RBI's approval. And for others, 10 lakh USD. If you have to pay for pre-incorporation expenses for that, then higher of 5% of investment which has come, or USD 1 lakh. Right? Okay, fine, ma'am. Of course, all those transactions you have to learn, because a lot of questions are being asked from current account transactions and capital account transactions. So this is the summarized version. Section 5, they're freely permissible unless these three. So there are three things that we have to learn. Coming to capital account transactions. Now, unlike current account transactions, their nature is kind of reverse. They say that current account transaction allowed only if permitted. So they have a list of permitted things. They don't have the list of general things that everything is permitted except this prohibited. Of course, they have a list of prohibited transactions as well. However, they also have a list of permissible transactions. So some permissible transactions. Here, one important difference that you must keep in mind, Section 6 read with Foreign Exchange Management, Capital Account Transaction Regulations 2000. There we had rules prescribed by central government. Here we have regulations specified by RBI. Okay, so in that regulation, we have Schedule 1, we have Schedule 2. Okay, so there is some permissible transactions. For PRI, it is given in Schedule 1. For PROI, it is given in Schedule 2. Then we also have some prohibited transactions, and we have certain types of transactions on which restriction cannot be imposed. Okay. First thing, the transactions on which never CG or RBI, no one is going to impose restriction. That is amortization of loan, that is repayment of loan, depreciation of direct investment. Direct investment means investment in equity. If that depreciates, you have to pay more. That is, if it is in a loss, then you have to pay more. Then that transaction, no prohibition, no restriction will be ever imposed. Okay, fine, ma'am. There are some transactions on which prohibition is there. Like, a person resident outside India cannot come to India and invest in chit fund, nidhi companies, or agriculture and plantation activities, or real estate, including the construction of farmhouse. But real estate does not include the development of townships, residential commercial premises, roads, bridge, investment trust, and everything. And TDR. TDR is transferable development right. Now, this is a kind of certificate which is issued by government to us if we want to compulsorily acquire a particular, if government compulsorily acquires a particular property, then it issues us a certificate which is transferable. So we can give this development right to someone else as well. Now, what are the permissible transactions for PRI? They are given in Schedule 1. So PRI, that is, I am a person resident in India, I can invest in foreign securities subject to all the regulations. Okay, I can take loans from outside India. I can get immovable property from outside India. Not get it, but acquire. I can give a guarantee in favor of PROI. Although it is a contingent liability, if PROI doesn't pay, I will pay. So I am creating a kind of my contingent liability, but it is permitted. Now, import or export, although is a matter of current account transaction, yet import export of currency is a matter of capital account transaction. Then even if I am getting loans in Indian rupee by PROI, that is also a capital account transaction. Maintaining a foreign currency account is also capital account transaction, because there also everything, I have a constant liability created. I have a constant foreign reserve created. Now, foreign currency account, I have told you, we can have RFC account, we can have EEFC account. A person who comes back to India brings a lot of foreign exchange, he can hold it in his RFC account, he can take back whenever he want to. EEFC account, the exchange earners, I am an exporter, I earn a lot of foreign exchange, I'll keep it in my account. I get saved from all that foreign exchange fluctuations, I can use it as and when needed. So these are the foreign currency accounts, which maintaining means capital account transaction. I can get an insurance policy from outside India. I can give loan to PROI. I can remit out of capital assets, or I can enter into derivative contracts like depository receipts. So these are permissible transactions for PRI. Now the same thing, permissible transactions for PRI. They can get securities in India, they can invest in India, they can acquire or transfer movable property, they can give guarantee in our favor, they can export import currency, they can give deposits, they can hold bank account, foreign currency account in India, they can remit capital assets out of, they can enter into derivatives contract. So everything is exactly the same for PRY also. Okay. Now, after this, we have a section called as Section 8, which tells us which gives us or imposes a duty on us. If I am an exporter, I have exported goods worth rupees 50,000 USD, then it's my duty that I realize that payment and bring it to India. Right? Government is promoting so much exports, or government is helping so that more foreign exchange reserves come here. So it is my duty that I realize and repatriate. Now, what do you mean by repatriation? Repatriation does not simply mean that bringing into India. You have to bring it into India. You can either sell it to the authorized person, so it gets injected into the system, or you can hold it in your permitted currency account, that is EEFC. So if you hold it in that, that is also meaning repatriation. So you have no non-compliance. Or if I have taken a foreign loan, I collect some payment and I repay that foreign loan, so that government here does not has to extract foreign exchange for repayment of loan. That means government saved its foreign exchange. Any saving is inflow. So inflow as good as repatriation. So these three conditions are all repatriation, and it is the duty to repatriate. Then comes your authorized person. Although I have already told you, they are known as authorized person. If anyone wants to become an authorized person, they have to make an application to RBI, comply with all the conditions, and a written authorization is given to them. But then they have to comply with the provisions, rules, regulations, everything. They also have to comply with the directions of RBI. If they do not comply with the directions or provisions of the Act, or rules or regulations, or in public interest also, their authorization may be revoked. Their authorization may be revoked. Then we have two sections, 11 and 12. RBI has the power to give directions to authorized persons. If you do not comply, penalty 10,000 plus 2,000 per day of default. RBI also has the power to authorize some officer for inspection. So that officer, what will he do? He can go inspect and verify that Authorized person is giving us the information, whether it's correct or not. Some information they are hiding, so to obtain more information, or just to secure that yes, they are complying with the act's provisions and everything. So this is a very small section. Then we have section number 7, export of goods and services. Now, export does not mean sale. It means taking or sending out of India. It could be goods, it could be services also. Now, whenever you are exporting, or as of that matter, whenever you are importing also, government wants full information, because government wants to ensure how much exports are there, how much imports are there, what is the balance of payments, whether exports, the foreign exchange is being realized or not, if you're making imports, whether the payment has been made or not, everything. So how much payment made, how much foreign exchange realized, governments want to reconcile, because ultimately foreign exchange reserves is not our property, it is government's property. We don't have the right to hold it just like that. Okay. So for that, government has made import regulations also and export regulations also. In exports, we means an exporter has to file a declaration, which tells us all our particulars about export of goods, about export of services also. For export of goods, we have a form, EDF and Softex. Softex in case of software and EDF in all other cases. But for services, we don't have any form, so we don't file declaration. But then it's still our duty to realize and repatriate payment. Now, when we file declaration, we have to give all the details, including export value. Sometimes we can ascertain this export value, that this is our value and this is what we will realize when everything is finalized pre-hand. But sometimes it is not ascertainable and subject to certain conditions. So what is something that you expect to receive? So that expected value has to be given in the declaration, right? So that is about exports. Now you have further things. What is further? The regulations. In case of software, there is form Softex. In case of other goods, there is form EDF. EDF has to be made in duplicate and is sent to Commissioner of Customs. They will verify and authenticate, return one copy to exporter and send the original one to RBI. Exporter has to within 21 days give it to authorized dealer, who will after realizing payment give it back to RBI. The same thing goes for Softex form also, although it is prepared in triplicate and submitted to Department of Electronics. One copy is retained by the authority and everything else goes the same. For services, we don't have any form specified, we don't have to give declaration. Other than this, some exports do not require any declaration. Like if we are sending some gift, the value of which is less than 5 lakhs, less than or equal to 5 lakhs, some trade samples, some repairs, testing, personal effects, if you're re-exporting the leased aircraft, for all these purposes, you do not require any declaration. Now, whenever you have done an export, it is your duty to realize and repatriate, and that should be done within a span of 9 months from the date of export. 15 months if you have exported to a warehouse. This period may be extended for genuine reasons, of course. For SEZ, STP, BTP, the time limit is only 9 months. Now, whenever there is a delay in repatriating or delay in bringing that money, then RBI can issue us directions. Directions like what? To realize the payment if the sale is not being executed, to make sales, and if nothing can be done to bring the goods back to India, so to re-import. Such directions can be made by RBI to us. There is also a concept of advance receipts against exports. So we have got some advance. Whenever we receive advance, it is our duty to make shipment within 1 year. However, if we have an agreement that we can make a delayed shipment, then it is permitted. But otherwise, you have to make shipment within 1 year. If you fail to make shipment, then no refund will happen without RBI's approval. And whenever you accept that advance receipts, it may be accompanied with interest, it may not be accompanied with interest. If it is accompanied with interest, then maximum rate of interest, LIBOR plus 100 basis point. Now we have some other provisions also under FEMA Act, and all of them can be summed up in this chart broadly, all the important ones. Adjudication, penalty, compounding and appeals. Central government on complaint appoints some officer who acts as an adjudicating authority, who eventually sends a show cause notice to the accused, that is the person against whom a complaint is received, that he has contravened the provisions of FEMA. He can give these two things. He can give a satisfactory reply which satisfies the adjudicating authority, or he can give an unsatisfactory reply or no reply at all. In that case, the adjudication proceedings shall commence. But accused can do one more thing in the meanwhile. He can request for compounding. So if he knows that, yes, I have committed an offense and the trial will go on, he can request that I want to compound this offense, that in place of that trial and proceedings, I am ready to pay the requisite penalty, whatever you decide, and please, I don't want this adjudication proceedings to go on. So he can make an application to RBI and it will be done in 180 days if payment is made. But if you have already filed an appeal, compounding is not allowed, or if similar compounding has been done in previous 3 years, then again compounding is not allowed. Okay. So if adjudication proceedings commence, they have to be disposed of within 1 year. If it is not possible, the reasons have to be recorded. What happens in adjudication proceedings? The hearing starts. Adjudicating authority passes the order. Order could be that yes, there is contravention, no, there is no contravention. So if there is contravention, undoubtedly penalty will be imposed. Sometimes the contravention amount is quantifiable. That means I had exported this much amount, but I did not give declaration. So what amount? Maybe 1 crore. So up to 3 crores, the penalty can be levied. So up to 3 crores, up to 3 times of sum involved if the amount is quantifiable. But sometimes maybe I had to give an information, I did not. So when the amount is not quantifiable, up to 2 lakhs. Plus 5,000 per day in case of continuing default. Now there is something more, something called as section number 37A, which tells us ideally the limit, that if you want to hold property and everything, there is a threshold. If we hold it beyond that, we have a penalty. Section 13(1)(a) and 1C. It tells us that we can be sent to imprisonment also, or we have to bring back whatever is taken, and we cannot go and confiscate the property abroad, but we can confiscate an equivalent property in India. So that things can also be done. Now, you might not be happy with the order of adjudicating authority. If aggrieved, then you can appeal. But it depends who was your adjudicating authority. If it was director, then you can directly appeal to Appellate Tribunal. But if it was deputy director or assistant director of enforcement, then you have to first go to special director appeals. And if still aggrieved, then you can go to Appellate Tribunal. If still aggrieved by Appellate Tribunal, then within 60 days, you can appeal to High Court only on a question of law. The penalty, whatever is adjudged, has to be paid within 90 days. If it is not paid, then civil imprisonment can also be attracted. And if the penalty amount is more than 1 crore, then up to 3 years imprisonment can be there. And if the penalty amount is a little less, then up to 6 months, right?
Now the revision of PMLA. Now the very first section that we have to read in PMLA is ideally section number 3, which talks about the offense of money laundering, who is deemed to have committed an offense under money laundering. So for that, we first need to understand what do we mean by a scheduled offense. Scheduled offense ideally is the offense which is specified in Schedule 1 of the Act, which is divided into 3 parts: Part A, Part B, and Part C. Part A, all offenses. Part B, offenses of value 1 crore or more, and Part C, all offenses. So these are the offenses which are specified in Schedule 1, which are considered to be scheduled offense. If you do any of this offense and you derive something out of that offense, it could be your intangible asset, it could be your tangible asset, movable, any money, anything, that is known as proceeds of crime. Now that proceeds of crime, if you hold it, if you try to conceal it, if you try to possess it, if you try to use it, that is involvement in any activity relating to proceeds of crime. And if you involve in any activity relating to proceeds of crime and you're trying to project it or use it as an untainted property, then that is offense of money laundering. Even if you attempt to do so, then also it is an offense. If you indulge, then of course it is. If you assist someone, it is. If you are a party to that, it is an offense. Whether directly or indirectly, you are directly doing it or you're getting it done through someone. In both the cases, it will be an offense of money laundering. Now, the process of money laundering, ideally, you can say money laundering is an act through which black money is converted into white money. Of course, black money can be obtained through different sources, like by evasion of taxes or by indulging yourself into some illegal activities. The offense, the money obtained from only those offenses which are specified in scheduled offense, and conversion of it is money laundering. So if I am a criminal and I'm trying to wash off my money, that is actually money laundering. There are various methods through which you can do money laundering, like you can do smuggling of cash, structuring, then entering into real estate transactions, stock market scams, bogus companies. Of course, here we are not trying to teach you how to do money laundering. This act is all about prevention of money laundering. So the act hereby intends to prevent money laundering. That is how people should not at all enter into this process of money laundering. That is the main focus. The two authorities under the act are Directorate of Enforcement and FIU, that is Financial Intelligence Unit of India. Okay. Now, there are 3 stages of money laundering: placement, luring, integration. Placement is when you place the proceeds of crime into the system. Luring is to make it far away from the source, and by entering into a series of transactions from here to here, here to here, here to here. And integration is finally returning the money as if it was a legitimate source. Whenever anyone enters into this process of money laundering or attempts to do this money laundering, he is deemed to have committed an offense under money laundering. And when he does an offense of money laundering, he is liable for punishment. The punishment is given in section number 4. Now, before we go on to section number 4, we remember that schedule 1 is divided into 3 parts. Part A, paragraph 2, the most important one, is relating to the offenses under Narcotics, Drugs and Psychotropic Substances Act, which is very important for you to learn, because if you indulge into the proceeds of crime of that particular act, then you have a little serious punishment. The punishment of offense of money laundering involves rigorous imprisonment and fine. Rigorous imprisonment, minimum 3 years, but the maximum differs in both cases. If it is an offense of drugs, then maximum imprisonment 10 years. But if it is other than that, maximum imprisonment only 7 years. Okay, so that is the only difference in both these type of punishments, which you must remember and must learn. Okay. Now we have different definitions, and first let's talk about the reporting entities. Who are the reporting entities? That is the first question. Reporting entities: banking companies, financial institutions, intermediaries, and even, I would say, the persons who are designating certain types of business or profession, who can be the persons who are dealers in precious metals, real estate agents, registrar, and casino, and all that. These are the places through which money laundering actually takes place. Because if I want to convert my black money into white money, how do I convert this? How do I enter into this financial system? The choices that I have are these reporting entities only. Right, that is the banking company, financial institution, intermediary, and the person who are carrying on designated business or profession. So through them only I can inject money into the system. So obviously they will be exposed to the proceeds of crime. They have to be cautious, they have to maintain proper records, and they have to do proper reporting. So government has imposed an obligation on them only, that you take care of all these things. What you have to do is you have to maintain your record about the identity of your client. And when the client
ends the relationship with you. That means I have closed the account. Despite that fact, you will still maintain my record for next 5 years. So after closure also, you have to maintain account for 5 years. You have to maintain the transactions record, the transactions as may be prescribed. So whatever high value transactions have been prescribed, you have to maintain a separate record for that also. And when the transaction takes place after 5 years, you have to keep on maintaining that record. After that, you can discard. And the same thing has to be reported also in such manner and time as prescribed. Reported to whom? Reported to the Director of Financial Intelligence Unit of India. Okay, so it has to be reported to that. Whatever information you're obtaining from the client, that has to be maintained as confidential. Apart from that, we have some more sections. We have section number 11A. What is 11A? Verification. Verification of identity by the reporting entity. Supposedly, I am a bank. If anyone comes to me to open a bank account, what I have to do? I have to verify his identity. How can I do that? I can do Aadhaar online authentication, Aadhaar offline verification, then passport verification, or any other document proof, right? So banks take that. Aadhaar is not compulsory. You have a choice. You can provide any of this document to verify your identity. It is your choice. The banks cannot compel you that you have to give Aadhaar only. Even if you don't have Aadhaar, very well the relationship can be established. Earlier, government had authorized only the banks to do this online Aadhaar verification. Like if you go to a bank, I hope you know that online Aadhaar authentication can also be done. Now this has been also allowed for NPCI. Okay, so National Payments Corporation of India are also permitted to do so. Then we also have a section called as 12AA. 12AA is about enhanced due diligence. That means some more cautious of the specified transactions. If a person comes and wants to deposit or withdraw a huge chunk of cash, why? If you want to enter into any foreign exchange transaction exceeding a specific amount, why? High value imports, why? Or any transaction which involves high risk, why? So in such cases, you must verify the identity of clients, verify their ownership, verify the financial position, verify to whom it is going, right? And if the client fails to give you information about the same specified transaction will not take place. And you have to maintain this information, maintain this record again for a period of 5 years. So we have 3 sections wherein reporting entity has to verify something and maintain records. Section 11A, Section 12, and Section 12AA. These records have to be maintained. These records can be called by the Director of Enforcement anytime, and it is the duty of reporting entity that you must furnish information within the prescribed time and manner. Apart from this, some additional information also like cash transaction reports, suspicious transaction reports can also be asked. Whatever information the director obtains through this course has also be required to be maintained as confidential by the director himself. Now, the director has the power to impose fine. Before I tell you this section, I must recall the hierarchy. Director of Rate of Enforcement, Adjudicating Authority, Appellate Tribunal, Special Court, and then High Court. That is how the hierarchy moves when we are talking about this particular act, right? So Directorate of Enforcement has director, it has additional director, joint director, deputy director, assistant director, other officers. So these are the hierarchy which they have. Now, supposedly the director himself thought so, or it gets an application by some authority, officer, or person that this reporting entity is not fulfilling its obligation. Reporting entity is bank. Bank is not doing what it has to. So director after inquiry can pass certain orders. But during inquiry, it sometimes happens that the accounts are all complex. You are unable to identify what is happening. So in such a case, the director can direct the reporting entity that this is a panel of chartered accountants maintained, select one and get the audit done.
right? We will bear the cost. So the audit will be done and the report will be in our hand. Now we can come to a conclusion that whether they have complied with the obligations or non-compliance is there. If non-compliance is there, then we can issue further orders. And if the case is not so complex, the director himself may carry out the inquiry and come to a conclusion that yes, there is a failure to comply with the obligations. In such a case, there can be 4 directions, 4 orders which may be passed: issuing of written warning, then giving a direction to comply with specific requirement, giving a direction to do some more reporting, sending submission of some more reports, and imposing some monetary penalties. Okay, whatever order is passed, the copy will be forwarded to the parties. Then we have section number 5, which talks about the attachment of property. What do you mean by that? Till now, we were talking all the sections of reporting entities. Now we're talking about the normal situations, normal people who actually contravene the provisions of money laundering. Supposedly, I have committed an offense and I have a land, which is my proceeds of crime. Someone comes to know that I have this. So what will happen? The director, not below deputy director, if he has reasons to believe that yes, whatever I have is the proceeds of crime, and if they don't take action, then I might sell it, I might try to conceal it, I might try to transfer it. So they can provisionally attach this land, they can provisionally attach the property. Attachment means restricting my rights. Now I cannot transfer this land, I cannot dispose of this land, I can use it, but I cannot, I don't have these rights against the land. Now, of course, for how long can they attach my property? For maximum 180 days. But as soon as they attach my property, within 30 days, they file a complaint to adjudicating authority and forward everything in a sealed envelope to them. Right. Now, adjudicating authority, on receipt of this complaint, if they believe that yes, this is an offense of money laundering, then they will send a show cause notice within giving me a time of 30 days. What I have to do, what I'm asked, what are my sources of income? From where have I got this land? Other relevant information, and why my property should not be confiscated. So I have to give an adequate reply now, not to the director, but to this adjudicating authority, who is an adjudicating authority, which is constituted by CG under the Act. Now, whatever reply I give, based on that reply, after hearing the parties, after hearing me, after hearing the director, and on the basis of all that relevant material, they will confirm the attachment. The attachment is confirmed. They haven't yet confiscated my property, although they will take into possession, but the actual confiscation, the order of confiscation can be passed only by the special court. So special court, now it will be redirected to the special court where the actual trial will take place, and special court can either release the property and confiscate the property. If they confiscate the property now belongs to central government. It will be free from all encumbrances, and if there is someone who is actually claiming to be interested in the property, he has acted in good faith, he has genuinely suffered loss, and he's not involved in money laundering, then central government can give the direction to give property to them. And otherwise, if it is discovered that the charge was created only to defeat the provisions of the Act, then the charge will be declared as void and no one will have any right against the property. It is only the government which will have the right against the property. Right. After that, if you are dissatisfied, supposedly director or the person who is aggrieved by the order of adjudicating authority, or maybe director imposed fine on reporting authority and the reporting authority is aggrieved, so they all can make an appeal to Appellate Tribunal. Appellate Tribunal is as under the Smugglers Act. So Appellate Tribunal within 45 days, of course extension can be given to you. Appellate Tribunal will have the same powers as are vested in a civil court while trying a suit. The decision is taken on majority. That means if there is a two-member bench and they do have different opinions, they will refer to the chairperson, and thereafter whatever he tells, or if it is referred to some third party, whatever they tell, that the decision will be taken ultimately by majority only. So appellate tribunal, after hearing the parties, after giving an opportunity of being heard, can confirm the order, set aside or modify the order. If you're still aggrieved, then you have a further chance of appeal under section 42 of the act to High Court. High Court can entertain appeals on both matters of question of law as well as question of fact. Within how many days, ma'am? Within 60 days plus an extended time period of 60 days, right? Okay, so that is it about all the important provisions.
Let's now revise the chapter of FCRA, that is Foreign Contribution Regulation Act 2010. Now, this act is, of course, meant to regulate the acceptance and utilization of foreign contribution or the foreign hospitality. So, it regulates two things: foreign contribution as well as foreign hospitality, something that you receive from the foreign source. The question is, what do you mean by foreign contribution? Any donation, any delivery, any transfer which is made from a foreign source. Foreign source means government of any foreign country, any international agency, a foreign company, any corporation which is incorporated outside, any MNC, or any trade union, any foreign trust, any citizen of a foreign country, any society club, they're all called as foreign sources. So any donation, delivery or transfer from a foreign source of what? Of any article, of any currency, of any security. That is called as foreign contribution. Now in article, you have an exception that if you receive it as a gift for your personal use and the value does not exceed 1 lakh, then that will not amount to foreign contribution. Okay, that will not amount to foreign contribution. Now, what is foreign hospitality? Now, foreign hospitality is something which is made in cash or in kind from a foreign source, like providing a person the cost of travel to any foreign country, boarding, lodging, transport, medical treatment, all that is a part of foreign hospitality. Fine. Now, this particular act is meant to regulate that who can accept this foreign contribution and foreign hospitality, who can keep it, who can, how, where it is prohibited, the cases, and the connected matters, right? So we have in total 9 chapters and a lot of sections in this act. It extends to whole of India, citizens of India, even outside India, and also the associate branches and all, right? Now, the first section that we read in this particular chapter is section number 3, which talks about the prohibition on acceptance of foreign contribution. So there are certain category of people who are not allowed to accept any type of foreign contribution. Who are these people? We have the people who are the candidates for election, the political party or office bearer. We also have correspondent, editor, publisher, judge, government servant, member of legislature, political party, office bearer, I already told you, organization of political nature, or company engaged in the broadcast of news. So these are the people who are prohibited to accept the same. They cannot receive foreign contribution, and foreign contribution I have already explained you. Foreign source also I have already explained you, right? Now, there is no prohibition if it is in the ordinary course of business, salary, scholarship, stipend, or of course the ordinary course of business, or as agent of government, or as a gift if you're a part of Indian delegation, or from relative. If you give the, see, if it is under 1 lakh, it is not foreign contribution. If it is in excess of 1 lakh also, then if you furnish form FC1 within 30 days from the date of receipt of contribution, then from your relative, it is not going to be prohibited. It is not going to be prohibited. Okay. Then we talk about foreign hospitality. Foreign hospitality. Now, foreign hospitality is not completely prohibited, it is restricted. We have certain specified category of people who are the members of legislature, office bearers, judges, government servants, or the employees which are owned and controlled by the government. They are being restricted if they want to avail any foreign hospitality, 2 weeks before their journey, they have to make an application in FC2 to central government to obtain the permission of foreign hospitality. Now, supposedly, along with the invitation letter and apartment clearance and everything, supposedly, you go out somewhere and suddenly the person falls ill. So, in case of sudden illness, if you receive any medical treatment, that is also foreign hospitality, right? But for this, you cannot have a pre-hand permission because it is a sudden illness. So, in this case, you can receive foreign hospitality without prior permission. If your bill comes only up to 1 lakh, no intimation is also needed. But if it is more than 1 lakh, then after you take this hospitality, post aid, intimation has to be made. So within 1 month of receipt of hospitality, you have to intimate. Okay, so emergent medical aid in the form of foreign hospitality may be taken, but that has to be specified. That has to be intimated. Okay. Now, we have certain sections that you cannot transfer foreign contribution to some other person. If you receive foreign contribution, you cannot transfer it to someone else. But all that provisions, before reading that, we have to read something which is called as registration. So we have certain category of people, that is person having definite culture, economic, educational, religious, social program. They are not going to accept foreign contribution unless you have a certificate of registration or specific permission for that purpose, for that particular contribution. Okay, so you can get two-way things. Either you can get a certificate of registration and thereafter you can receive foreign contribution as and when permitted. And secondly, you can have a specific permission for receipt of just one foreign contribution. So both things are possible. How do you obtain registration? So whoever is specified in section 11, they can make an application in FC3 to central government along with your documents and a signed application. If that is accepted and you comply with the conditions specified in section number 12.4, that means you are not someone who is fictitious, you have not been convicted for creating any disharmony, you have not been found guilty for misutilization of funds, you are not going to use it for your personal gain, you have not contravened other provisions and like things. So if you comply with these conditions, then within 90 days, certificate will be granted. Otherwise, it will be rejected. So if it is not in the prescribed form, or you do not comply with the conditions, or it does not contain the prescribed particulars, then in this situation, central government will record reasons that why they are rejecting your application and will reject the application by furnishing the same reasons, right? Whatever certificate is granted to you, it is valid for 5 years. Now, instead of obtaining a certificate of registration, you can also obtain a permission just for that specific purpose. So permission will be only for that specific purpose, right? Now, if you have foreign contribution, then you cannot transfer it to no person who is registered and has been granted certificate or has obtained prior permission, receives some foreign contribution. You are not going to transfer it to any person. You're not going to transfer it to any person. Simple. Remember that. Okay. Forget about what all things are written over here. Right. Now, when it comes to utilization, so there is restriction on utilization also. Whatever foreign contribution you have received, we are talking about the persons who need to obtain certificate or prior permission. So they have certificate or they have prior permission and they receive the foreign contribution. They cannot ideally use it for speculative business, right? If I talk about administrative expenses, then up to 50% it is allowed, more than 50% requires approval. Okay. Ideally, I would say now this has been made to 20%. So administrative expenses, 20% of foreign contribution is allowed, more than that is not allowed. Okay. Fine. Do it 20%. Do it 20%. So for spending more than 20%, you need prior approval of central government. You need prior approval of central government. Right? Now, central government has the power to prohibit the receipt of foreign contribution. Central government, if it does the inquiry and is satisfied that any person is in custody or control of articles or currency or security, and it is likely to going to affect the sovereignty or public interest or the freedom or the friendly relations or harmony, then it can give a written notice to the person or the authorized agent and prohibit that person to pay or deliver or transfer. Okay. So ideally, I have told you 2 sections in one. Now comes your part of suspension. Can certificate be suspended? Yes, not exceeding 180 days. So where central government is satisfied that pending consideration of the question of cancelling the certificate, see, government is considering whether to cancel the certificate or not. The certificate can be cancelled if you had submitted some incorrect information, or if you have violated the terms, or if it is necessary in the public interest, or if you have not engaged in any reasonable activity in 2 years. So on these grounds, your certificate can be cancelled also. But till the time government decides about cancellation, for the time being, they can also suspend if it is needed to immediately suspend the same, but maximum days suspension can be 180 days. During that tenure, you are not allowed to receive any foreign contribution. Now, whatever foreign contribution has already been received by you, up to 25% you can spend with approval of central government, and the remaining 75% can be spent only after your suspension is revoked. Once your certificate of registration gets expired, not actually gets expired, 6 months before expiry, you can make an application for renewal. If you fail to do so, then 4 months after expiry, within 4 months after expiry, central government grants, the renewal is done within 90 days, and again, you get your certificate renewed for 5 more years. Central government can also refuse, then of course you cannot do anything. Okay. Now there are some intimations which have to be made according to section number 18. Even before that, we have certain things that you have to deposit your foreign contribution in a scheduled bank and report it to authority also. Now, any person who has certificate or has got the prior permission, if you receive foreign contribution, undoubtedly you have to prepare an annual report also, which is going to be signed. There will be enclosures, there will be FC4. Within 9 months of close of financial year, you have to get it certified by CA and give it to central government. So you have to maintain the accounts. You also have to get your books audited. And of course, you have to submit adequate returns and information to government, right? Then we have something called as appeals or adjudication. If any contravention takes place, or rather I would say, there is also a section that we have for confiscation. So any article or currency or security which may be seized under the act is also going to be liable for confiscation, right? So adjudication of confiscation takes place by court of sessions, or it can also take by sessions judge, subject to the limits. So court of session has a limit. Within that limit, they can exercise the power, and further the other limit is there, right? So they can decide upon confiscation. If they pass the order of confiscation and you are dissatisfied with the same, you are aggrieved. If it was decided by court of session, then you can appeal to High Court within 1 month. If it was decided by officer of CG, then you can appeal to Court of Session within 1 month, right? I hope this is clear. Appellate court can allow you further time period of 1 month. And so we have covered the broad provisions of FCRA, I believe, then of course there are some offenses and penalties which also you have to review under this particular chapter. Okay, hi everyone. Arbitration and Conciliation Act. Let's discuss the revision of the same. What is Arbitration and Conciliation Act? Now here we are talking about the disputes. If there is any dispute, it can be either referred to the judiciary, that means we can file a legal suit, or we can resort to some out of court methods, settlement methods, which is alternate dispute resolution, which involves arbitration, conciliation, mediation, and other things. Right. So arbitration is one of the methods of alternate dispute resolution, which means the parties are not going to go to the court, but they are going to settle the dispute out of the court. How do they do that? Because they are unable to coordinate, then only there is the dispute. Since they are unable to coordinate, or since they are unable to come to a consensus, we have a third party which acts as a judge. So he is someone who is known as arbitrator or arbitral tribunal, right? He can be one person, he can be more than one person, right? So that is going to be arbitral tribunal. Now they discuss, they hear the parties, they collect evidences, and on the basis of that, they pass a judgment which is known as arbitral award. So arbitration proceedings take place and an arbitral award is being given. Arbitral award is enforceable like a decree of court. That is the best part. So it becomes binding on the parties and they have to comply with the same. We have part 1 in this chapter which deals with arbitration. We have part 2 which deals with international or foreign awards. We have part 3 which deals with conciliation, and part 4 is all supplementary things. Okay. There are undoubtedly a lot of advantages of doing ADR. At the same time, there is some disadvantage also. Advantages are more important because they provide better flexibility, lower cost. Then you have your choice of judge, you have your choice of forum, you have higher confidentiality and all of that. But then sometimes it becomes difficult to cooperate with the parties, and it sometimes becomes difficult to bring the outcome also. Now, there are certain disputes where alternate dispute resolution cannot at all work, or the disputes or the matters which are not arbitrable. Okay, supposedly someone kills a person and they resort to arbitration. They say, I am not going to go to a court. I will rather go to arbitration. So we'll have some third person who will settle the matter. And he settles the matter that, okay, fine, pay 20 lakhs and you're free. So, of course, this matter cannot be submitted to arbitration. This is a matter of judiciary and will go to judiciary only. So, matrimonial, criminal, testamentary, insolvency, guardianship, lunacy, charity, and revenue matters are not something on which arbitration can take place. Basically, if I talk, arbitration is all about the commercial disputes. That means we enter into a contract and the business disputes are being referred to arbitration. Now, when do you decide that you do not want to go to court, but rather you want to go to arbitration? You can decide it before the dispute has occurred, because maybe you think that in future dispute can occur. Or you can also decide after the dispute has occurred, right? So we have two types of arbitration agreements, which is arbitration clause and submission agreement. Arbitration cannot happen without the consent of parties, so there has to be proper consent, and undoubtedly this process of arbitration is also governed by our legal laws only. Which legal laws? The legal laws of the area where you are, right? So that is also known as seat of arbitration. Seat of arbitration means the legal system which is going to supervise the whole process of arbitration. Right. Now, there are, as I said, two types of agreement. Arbitration clause, it may be a part of principal contract or it may be a contract altogether in separate. Here the parties have decided pre-hand that if any future dispute comes, then we are going to refer to arbitration. So this is decided pre-hand. We also have something called a submission agreement. Now, this happens once the dispute has occurred. Now the parties agree to at least this thing that they are going to refer the matter to arbitration. Okay, so arbitration cannot happen unless both the parties have consented that they want to submit the dispute to arbitration, right? Now, what is arbitration agreement, ma'am? Ideally, it is an agreement entered into by the parties that they want to submit the matter or the dispute to arbitration. There are two types of arbitration agreement, and they have to be in writing. Even if you refer the arbitration agreement to some other document, see, reference to other document can also be made. There has to be clarity of consent between both the parties. There has to be substance over form, a legal relationship. Whatever it is will be final and binding. There has to be signed in writing. Arbitrability, that means you cannot submit the matters which are not arbitrable, and there has to be dispute. Okay, so these are some general points. When I talk about legal relationship, it means that the disputes which are illegal or it concerns some illegal activity, we have consented, we have an illegal relationship that, okay, fine, we are going to kidnap and we're going to share the ransom money, that cannot be submitted to arbitration. Okay, don't consider arbitration as something which is illegal. No, it is also a very much legal process out of the court, right? Dispute can be present, it can be future dispute also, and arbitrability, of course, I have told you. Now we come to termination of arbitration agreement. Arbitration agreement may be terminated by mutual consent, so jointly both the parties can put an end to it. It can be terminated if the principal contract has been terminated. So whatever contract you entered into, that has been terminated, so automatically the arbitration clause also comes to an end. Death of parties. Ideally, arbitration agreement is not discharged by the death of any party. Okay, but that means it can be enforced by the legal representative. But of course, if it brings an end to other things, it brings an end to this also. Operation of law. Example, if any party becomes insolvent, then you cannot continue this. You cannot go to arbitration and do that, right? So it is terminated or it is extinguished in that case. Arbitral tribunal. Arbitrator or arbitral tribunal is one and the same thing. Even if there is one arbitrator, you can still call him as an arbitral tribunal. Of course, he has to be a person who is capable of contracting, but there is absolutely no qualification which has been prescribed for him. Okay, so he can be any person who is sensible, who is capable of contracting, so you can select that person. We believe that he should be someone who has some expert opinion and he works exactly like a judge, but you can select anyone, right? If parties go out to select their own arbitrator, they get more confidence. Okay, he is someone whom I have always looked upon, so he is someone who will give a clear judgment only. Right, so maybe that way it happens. He can be of any nationality also, but he has to be someone who's going to be neutral and unbiased. Now, arbitrator can be one person or it can be more than one person, but it is not going to be even. Okay, because in case of even, there might not be a consensus which is reached. So they have to maintain confidentiality, they have to be impartial. They have to always communicate with both the parties, avoid unilateral communication unless needed, and exchange information and pass an unbiased award or judgment, right? How are they going to be appointed? See, the parties jointly appoint the arbitrator if there is just one arbitrator. Or otherwise, if there are three, so each party will appoint one arbitrator and the arbitrators will appoint jointly the third arbitrator. You can appoint the person of any nationality, and you can even follow any procedure. Sometimes there is non-appointment, right? In that case, request can be made to Supreme Court or the High Court or any person or institution designated by such court, and that court or the person who is designated, the institution who is designated, they will appoint the arbitrator, right? Clear? Okay. Now, termination of arbitrator. If arbitrator withdraws, if it is mutual consent of the parties that we want to change the arbitrator, if he is unable to perform, or by operation of law, maybe the time limit has exceeded, or lack of independence. So if there is bias, then also that can be terminated. Now, there are certain grounds of challenge. Certain grounds of challenge. Challenging the appointment. So if the circumstances of section 12 exist, that means there is any indirect or direct or any past relationship or any direct or indirect interest, or which is likely to affect his ability to sufficiently devote time and all that, and one party comes to know of this, within 15 days, the party is going to send written notice to the other party as well as arbitrator. Arbitrator, on receiving that notice, may resign, and the other party might also agree. If the other party disagree, then the challenge is unsuccessful. You have a basic time limit which has been given, that within 12 months from the receipt of notice of appointment of arbitrator plus maximum 6 months extension, arbitral award should be released. Arbitral award should be released, right? Arbitral award is a decision which is taken by the arbitrator on the basis of majority, of course. And what are the different types of award that we have? Final award, which is on all the issues. We have interim award, where only some rights or some issues have been settled and in between an award has been passed. Settlement award, which is settlement instead of adjudication. So we do not judge what is right and what is wrong. Instead, on the recommendation of parties or on the agreement of parties, we have entered into a settlement agreement, and that has been recorded in the form of an award. Additional award, when additional award we have actually later on. Correction award, if there is just any error, computation or clerical error, it can be rectified. Then we have additional award. See, once final award is released, then if there is any claim or issue which has been left unaddressed, then party can give a notice to other party as well as request arbitral tribunal or arbitrator within 30 days or within 60 days or extended time period. They will give the additional award. Okay. Right. Now, what are the requirements of an arbitral award? Arbitral award necessarily be in writing. An oral judgment is not going to be valid. It has to be signed and by the majority. Supposedly, there are 5 arbitrators, out of which only 4 agree. So, undoubtedly, only 4 arbitrators will sign and the 5th person will not sign. We need a decision by majority. So, we need a signature also by majority. Right, so it is going to be signed, it is going to be by majority, it is going to be dated, the place will be mentioned. The reason will also be mentioned, that how and why they have taken this particular decision, so that we get some idea about how they have applied their minds to the situation. It has to be clear, it has to be enforceable, it should not contain something which is illegal or which conflicts the public policy, and undoubtedly delivery is very important. An award has to be delivered as soon as it is signed. Okay. Now, any party can challenge an arbitral award on certain grounds, which are: a party was under some incapacity, or maybe the arbitration agreement that you entered into is not valid, or you have not been given a proper notice of appointment of arbitrator, or the dispute which you have submitted for arbitration is not arbitrable, or the arbitration proceeding was not according to the agreement. So on these grounds, a party can challenge. a party can challenge, right? If the court finds that you submit a dispute which is not arbitrable or which is against public policy, then court can challenge. Okay, so this is how challenge can be made. So you submit this to adjudicating authority, and within 3 months of receipt of award plus 30 days to court, they dispose it off within 1 year. They can confirm the order, modify it, or set aside. Right. So first 5 grounds that I have told you, they are raised by the party, and the other ground court can look on its own motion. Right. They can also remand back to the arbitral tribunal. Then we have something called as conciliation. Conciliation is not something which decides that who is right or who is wrong. Here, the whole intention is to reconcile the dispute. That means somehow it is a win-win situation for both the parties because something good is going to happen for both the parties. So it is an amicable settlement that happens. There can be one conciliator, there can be two conciliator, there can be three conciliator, maximum three. So here we can have even conciliator as well. Okay, because here they are going to take efforts in resolving the dispute. Okay, or in somehow coming to a consensus. Right. Now, what happens? A conciliator is appointed. Parties submit their document, statement. It is sent to the other party. The discussion takes place. The conciliator takes a proactive role in making proposals that this is how you can settle down. So it encourages the parties, makes proposal, even sent the same to parties for suggestion. And once they come to an agreement, the same is signed by the parties, and then it is enforceable. Right? Conciliation is also somehow governed by CPC, right? That is the Code of Civil Procedure, right? Okay.
Hello everyone. This class is all about revision of IBC 2016. It's going to be in as fast manner as possible, of course, without compromising on the concept, so that you actually find it an effective revision. Without wasting any more time, let me begin with the revision. I have my handwritten charts of this chapter with me. If you want the same, they are available, of course, free of cost for all of you. Just to ease in your preparation, how can you get them? That you will find in the description, right? Okay, so let's start with the chapter. Insolvency and Bankruptcy Code 2016. First of all, it involves two terms, that is insolvency and bankruptcy. What do we mean by these two terms and why at all code is used? See, it has a wide application, and it includes a lot of content. A lot of acts were repealed, a lot of acts were amended. Okay, and after that, this particular one unified law has been made with respect to insolvency and bankruptcy. Okay, so that's why the use of code instead of acts, as it involves a lot of aspects in one unified law. Now, what do we mean by these two terms, insolvency and bankruptcy? Right, because it is a code about the two terms involved over here. So, to understand that, insolvency is a state. Okay, insolvency is a state. We all know, we have been as commerce students preparing balance sheet for years, right? And every time we prepare balance sheet, we know that we have certain set of assets and certain set of liabilities. That is for any entity that we are making the financials of, as in a normal common parlance, that for each one of us, like if I talk about me as a person, I might have certain assets and I also might have certain liabilities. Say for example, I have a house and I have a bank loan. Okay, so supposedly I bought a house at 2 crore rupees and my loan is somewhere around 1 crore rupees. Now slowly what happened, that the house price, maybe for certain reasons it declined and came up to 50 lakh. I have no bank balance and I have to repay a loan of 1 crore still. That means my assets can realize only 50 lakh, whereas I have to pay an amount of 1 crore to the bank. So my liabilities exceed my assets. So this is a state, this is a position where I am in right now. I am in a position where my liabilities are more, whereas my assets are less. Right? So this is called as a state of insolvency. This may be for a company, for a non-company, for a partnership firm, for an individual, for any entity, any person. Right? So this is applicable in everyone. Now, I know this particular state of mind. Nobody else knows it. Supposedly, I defaulted in the repayment of my loan to bank. I had to make the payment of an EMI and I did not pay that. Now the bank knows that there is some issue why Shivangi is not paying our installments in time. So now the bank gets concerned and bank comes up to me. We have discussions like things. Now instead of constant repetition, reminders, I am still not being able to repay bank loan because I don't have money. Right? So what bank can do now? What can bank do now? What can bank do now? Now bank can initiate some proceeding against me. So bank can go to some person and bank can say that Shivangi is not in a very well state. She is in a state of insolvency. What we should do is we should bring her out of this insolvency. How? Maybe there is some way, maybe her business is not going so well, so we can provide her ways, we can talk to her creditors, like to provide some credit, etc., and we can bring her out of that insolvency state so that she comes back in the normal position and repay my loan. And what if she cannot come out of that insolvency state? Then we should sell her house, whatever assets are available with her, and whatever loan amount can be repaid, I want my money back because I cannot take further risk. So bank wants someone to listen to this situation. Earlier also there were rules, there were authorities, there were laws, but not so uniform and not so well defined. IBC has made this process absolutely clear and utmost ease has been provided in this regard. So one by one we will try to understand that. Okay, so insolvency is a state, is a position, and now what happens is the person goes to some authority, the person tries to resolve my insolvency. If it cannot be resolved, then the court will declare me as bankrupt and all my assets will be sold and my liabilities will be paid off because I am an individual. I am an individual. Right? I have a chart over here which is going to help us realize. Please mark my words and keep this in mind. This is just a revision lecture, so I'm not going to explain you every step by step. This is just an introduction. I'm trying to give you the brief idea, not of course in the most in-depth manner that I take up in the classes. Okay, so this is just a revision class and you are only going to get an overview of the same. So insolvency, my dear, is a state where your assets are lesser than your liabilities. If you go ahead and treat the state of insolvency, that means you can resolve this insolvency, nothing better than that. And this particular code endeavors to do that only. Liquidation is a very trivial or a very small part of this particular code because its emphasis is to revive the person from the state of insolvency. Okay, so insolvency, if it is treated, nothing better than that. If it is untreated, then if you leave it like that or it cannot be treated for some reason, then it may lead to bankruptcy for non-corporates that I spoke to you about and for liquidation for corporates. Now, what do we mean by liquidation? Insolvency is a separate term, bankruptcy is a separate term, and what do you mean by liquidation? These three terms are separate, different terms. Liquidation is nothing but the process of winding up. And what is winding up? See, winding up, liquidation, dissolution, again, so many terms. So, dissolution and liquidation are different terms. Liquidation means winding up. And what is winding up? Winding up means sale of assets to pay off liabilities. only that particular process is. Now, when you want to remove the existence of the company, say company was incorporated, then there is a register of companies in which the name of company is mentioned. That means company has a separate legal entity, company has its own existence. We dissolve this existence pursuant to liquidation. Clear? I hope you have got this basic idea. Now listen to me very carefully. Listen to me very carefully. Let's take an example. Let's take an example before I make you understand anything else. There is a company. A company means a corporate. Of course, I hope you all know what is corporate and what is non-corporate, right? So corporate, LLP, company, they all will come under corporates only. So there is a company that is a corporate. The company has taken a loan from a bank. The company has taken a loan from a bank. Now supposedly the company defaults in payment, in repayment of this loan. Company defaults in repayment of this loan. This bank will realize that there is something wrong. So bank can move an application to the appropriate authority, and appropriate authority will initiate the insolvency resolution process. That means they will try to resolve the state of insolvency of the company. If that cannot be done, then the relevant authority will pass the order of liquidation. That means they will say that sell off all the assets of the company and pay off its liabilities. So wind up this company. The company cannot no more function, cannot function anymore. Wind up this company and dissolve its name. You get my point? You get my point? So first endeavor is to resolve the state of insolvency. If that cannot be done, then liquidation happens. We have two set of people in this particular code. One is corporates and other is individuals, partnership firms and like, right? So we have to read about corporates only. So we will read corporate insolvency resolution process. Corporate insolvency resolution process, for which we need to know three basic terms: corporate debtor, financial creditor and operational creditor. Company or LLP, whatever the case may be, this is a corporate and it's a corporate debtor because it has taken some money. If it has taken a loan from a bank, that means bank has helped in its finances. The bank has helped the company in its finances. So of course it is a financial creditor. If a person has supplied goods to the company and the company is unable to make payment for that, company has taken some goods on credit, the company is unable to make payment for that, the person has helped in the company's operations. It is an operational credit. If the company is unable to pay the salary of employees are operational creditor or financial creditor. They will be considered as operational creditor. Why? Because they have helped in the operations of the company. Okay. If supposedly company has taken loan from some employee, now that employee has helped in the finances of the company, so that employee in that particular capacity will be treated as financial. You get my point, right? You should know all these. We are just revising. So these are basic parties that you must have an idea of. Okay. Now if we talk about this particular code, it has repealed 2 acts and amended many laws. It came into force on 28 May 2016. If you talk about it, was introduced in December 2015 in Lok Sabha. Then of course in May 2016 in Rajya Sabha. It was first passed in Lok Sabha, then passed in Rajya Sabha. It got assent on 28 May 2016 and was notified on the same day. Now, under this particular code, we have an authority. or you can say we have a board, which is Insolvency and Bankruptcy Board of India. It is IBBI, which is commonly known as board. So throughout the act, wherever board is written, it does not mean your board of directors of a company. It means IBBI. Clear? Now, this IBBI, who has established IBBI? Central government has established IBBI to oversee the whole proceedings under IBC. So it is the authority which is governing everything under IBC. Okay, that means, ma'am, if supposedly a company has taken loan from a bank and the company is unable to repay the loan, the bank is going to move to IBBI and make an application? No, my dear. Under IBBI also we have authorities. We have read about National Company Law Tribunal under Companies Act, NCLT. That is going to be the adjudicating authority for the corporates under IBC. For the corporates under IBC, that is relevant for you. That is something that you must know. IBBI, of course, is a board which is going to oversee whole thing. Its head office is at New Delhi. But that is not the adjudicating authority. That is the supreme authority, you can say. Okay. So, adjudicating authority is NCLT. So, I might say NCLT, I might say adjudicating authority. Whatever I am saying, they both mean the same for corporates under IBC. Okay. Now, this particular code is divided into 5 parts. It has 12 schedules and of course, all the chapters are divided, all the parts are divided into different sections. What is relevant for us? Listen to me very carefully. Part 2. Part 2 is for corporates. So part 2 talks about treating the insolvency state of corporates, and if it cannot be treated, then going for liquidation. That is what is covered under part 2 of the code. Okay, so part 2 has its own definitions also. It has the whole process. CIRP stands for Corporate Insolvency Resolution Process. Liquidation, fast track CIRP, voluntary liquidation. That means there is no one who has made an application. The corporate debtor himself wants to liquidate on certain grounds, so they can go for voluntary liquidation. Then about adjudicating authority, offences and penalties. So all this is covered under part 2. All this is covered under part 2. Clear? Part 1 is preliminary, which tells us about the title, application and certain definition. Now the definitions which are given under part 2 apply to the whole IBC, but the definitions which are given under part 2 will apply to only part 2. This is very obvious. I hope you all know that, right? Okay, so these are the basic structure, you can say. One important thing, the provisions for insolvency and liquidation of corporate debtors shall apply only when the minimum amount of default is 1 lakh. The government can go up and prescribe this amount up to 1 crore, and the government has actually prescribed the amount to 1 crore. So supposedly company has taken a loan of 20 lakh rupees and company has not repaid that loan. Can bank go and make an application under this code for recovery of money? No. The minimum default amount has to be 1 crore. The minimum default amount has to be 1 crore, only then. Otherwise, IBC will be flooded with applications, right? And it will be very difficult for them to manage the same, right? So, the amount, earlier it was 1 lakh only. So, 1 lakh, what the authorities realized that they have a lot of applications flowing. So it became difficult for them to manage. So now the amount has been increased to 1 crore. Clear? Now, let's talk about the whole overview of CIRP. A basic structure, idea we'll get, and then we will start one by one. So basic thing is commitment of default, and that too minimum amount default has to be 1 crore. If there is existence of default, then application may be filed with adjudicating authority. Who is the adjudicating authority? NCLT for corporates. So either our financial creditor can go and file the application, or the operational creditor can go and file the application, or the company itself, that is the corporate debtor itself, can go and file the application. So any of them can file an application with adjudicating authority that we want to resolve the state of insolvency. See, we cannot directly go for liquidation, because attempt will be not to suppress the business houses. The attempt will be to revive the business houses. If at all they cannot be revived, then to liquidate them, right? So existence of default, at least compliance with the minimum amount of default, and application with adjudicating authority. Now what happens? There has to be someone who is going to undertake the whole process of revival, who is going to try and resolve the state of insolvency. That person is selected from a panel of professionals who are qualified and registered, of course. So one such person will be selected from the list of insolvency professionals. Insolvency professionals, out of that, one person will be selected, and that person, if he gives his consent, just like we appoint auditors, we have so many members, so many chartered accountants who are in practice, who are eligible to carry out the audit. So we select one CA in practice. If he gives his consent that, okay, I'm ready to do your take up your audit work or assignment, so we appoint that person as an auditor. Likewise, the same is going to happen here also. Okay, who does it, who doesn't, I'm going to tell you everything. So in the same manner, out of that list of person who are eligible, who are qualified, who are registered, that list of IPs, from that one person will be selected. He will be appointed as interim resolution professional for the time being, not the final one, but for the time being. Then what happens is a committee of creditors is formed. A committee of creditors, because if I'm talking about resolving the state of insolvency of a company, who are the persons I have to take care of? Of course, the creditor. Because company has to make payment to the creditors. Supposedly, there is a bank who has to take 2 crore from this company. And I, as some resolution professional, I am a professional who is going to resolve everything. I come and I say that bank, I am going to pay you 50 paise in a rupee. The bank might get upset. The bank might not be happy with the decision. So do you think banks should have a say in the decisions that I make? Because it is the ultimate, who is the ultimate beneficiary? It is the creditors. So creditors must be involved in this decision making about how you are going to treat the insolvency of a company. Right? So for that matter, a committee of creditors is being formed, and they appoint the final resolution professional. After that, who prepares information memorandum, then they invite plans from prospective resolution applicant, that how the state of insolvency can be resolved. The plan is submitted to committee of creditors. Do you agree? Do you disagree? If you agree, then we will submit the same plan to adjudicating authority, and if adjudicating authority also agrees, then we will implement the plan and we will resolve the state of insolvency. If you don't agree, then we don't have a choice. Or if you agree and we submit the plan to adjudicating authority and adjudicating authority doesn't exist, we don't have a choice. So in that situation, we will go for liquidation of the company, because ultimately, if anyone has made an application under this IBC code, he must get some resolution. he must get some relief. That is important, right? So these are some short forms that have been used in the charts and they might help you. Okay, so now we begin with the actual thing, why this particular code has been or why this particular framework has been made is to handle the conflicts between the creditors and the debtors in a more efficient manner, because earlier also you had disputes, there were court cases, one company has millions of court cases running, not millions, it's too high, hundreds of court cases maybe against them. Now it becomes difficult for the judicial systems to handle as well as for the company to handle. So here what happens is somebody has initiated CIRP, it's going to serve all the creditors. So it becomes better for them, right? It prevents a lot of business failure, because ultimately if the situation is not resolved, the company will run into liquidation. So if attempt can be made to resolve and revive the business, nothing better than that, right? So of course the code helps in a lot of manner, and wherever an enterprise defaults, the control of the enterprise is not going to stay with them. It is going to shift to basically the committee of creditors who assess all the proposals and everything. Who assess the proposals and everything and try to revive the enterprise. If it cannot be revived, they are going to take it for liquidation. Okay, so my dear, we begin with our code. It is applicable to all the entities, that is the company which is registered under Companies Act, LLP, then any other body corporate, even the guarantors to the corporate debtors, right? Partnership firms, proprietorship firms, individuals also I spoke about, right? But we have to read about the corporates, which is given under part 2. We have some important definitions which I'm not going to discuss in this revision class, but I have told you the basic meaning of the terms as and when needed. I have already told you about the financial creditor, operational creditor, insolvency professional, the person who is enrolled as a professional. Okay, so let's begin our CIRP. The first step is filing of an application. Of course, after the existence or commission of default, after that only application is going to be made. So if the corporate debtor has defaulted in payment, owed to applicant or owed to any other financial creditor. That means maybe company has taken loan from a bank and company has also taken loan from other people. The company has repaid this loan, has not repaid that loan. So collectively, if it has defaulted in the payment of amount to any financial creditor, then this application can be made either by itself or jointly with other financial creditors. See, one amazing thing I would say which has been established under IBBI, or you can say under this particular code, is information utility. Information utility under IBC. Earlier there wasn't any information utility. Now we have India's first information utility, which is NESL. Okay, it is registered under IBBI. If you want to check out, you can check out its website. I was trying to quote that exact website for you. Yes, it is nesl.co.in. Okay, so if you want, you can check it. National E-Governance Services Limited. You will get that information utility. Now, what is information utility? Of course, it has some information which is stored. See, if you talk about income tax portal, whenever you have AIS. I hope you all know about AIS, Annual Information System. Just like we had 26 AS when we were filing returns previously, we now also have AIS. AIS is what it is doing. It is tracing all the information from all the available sources and presenting it at one place, right? In the same manner, information utility is nothing but it stores information from different sources and brings it at one place, right? So a lot of people register their the banks are going to provide information, and that information is going to be stored. So financial creditors definitely have this information under IU, that is information utility. So if let me try to explain you with an example. Supposedly I tell you that my TDS for financial year 2021 has been deducted 20,000. The amount deducted as TDS is 20,000. Will you believe me? Well, the answer is you might believe me, you might not believe me. But if I present to you a copy of 26 AS wherein financial year 2021 is clearly mentioned and the TDS deducted comes out to be 20,000, you will definitely believe me. Why? Because it is an extract which has been made available from a government source. Likewise, if a financial creditor makes an application to IBBI stating that somebody has defaulted in repayment, the adjudicating authority might not believe it, but if they attach that extract from information utility, they have to believe it, right? So they file an application along with the record of default. They suggest the name of resolution professional. So out of that list, they can select one resolution professional and any other information which is specified by board. Board here means IBBI. Okay, so they file an application to adjudicating authority. What adjudicating authority is going to do is within 14 days, they are going to either admit the application if they are satisfied that yes, there is default, the application is complete, and the name of IP that they have suggested to act as RP is clean. That means there is no disciplinary proceeding which is pending against that particular person. There is no proceeding which is carrying out, right? So he has not been involved in any such thing, right? So if they are satisfied, they are going to admit the application, and the date of admission of application is going to be treated as the commencement of CIRP, right? So this can be an objective question asked to you. What is the commencement of CIRP? Now, adjudicating authority can also reject application. When can it reject application? If it is satisfied that the default is not there, or the application is incomplete, or there is some disciplinary proceeding which is pending against the proposed RP. So they will give a notice to the applicant to rectify the defect within 7 days, and if rectified, then the application will again be admitted. If the application is admitted within 7 days, it is going to be communicated to the financial creditor as well as the corporate debtor. Corporate debtor might not even know that such application has been admitted by financial creditor, right? If it is rejected, then you don't need to intimate to corporate debtor, right? Financial creditor made an application. Directly you have rejected it, you intimate to financial creditor. But if you admit the application, now the process of insolvency is going to start. So you have to tell that company, you have to tell that corporate debtor that now we are going to start the insolvency resolution of your company. So you must inform them over here. Your information to them is not required. And if no order is passed within 14 days, you have to record reasons in writing for the same, that why is there a delay? Why is there a delay? Here, right? So shall we move further? Okay. Now, this was about financial creditor. See, the important section numbers to remember. Financial creditor can initiate CIRP under section 7. Operational creditor can initiate CIRP under section 9. However, section 8 and section 9 both are for operational creditor. We are going to read them now. And corporate debtor himself can initiate CIRP under section 10. Okay, so these are three you can say important sections. And then we have under section 11 certain persons who are not entitled to make an application for CIRP. That means in certain cases you cannot go for CIRP. Okay, so about financial creditor we have already read. Now we are going to read about the operational creditor. Now operational creditor record will not be there in information utility. And I am a company, I have taken some goods from a supplier, from a vendor. I have not repaid their amount. In these operational transactions, there can be existence of dispute a lot of times. I wanted certain goods, you provided the goods of a lower quality, so I have not made your payment. You're not ready to take back the goods. You have provided me defective goods. You have provided me delayed goods for which I suffered losses. So a lot of problems can exist in such type of cases. And that's why maybe delay in the payment. So supposedly the vendor gave me goods which are not up to the mark or of the quality that I agreed to, and that's why I'm not making payment. Now the operational creditor goes to the adjudicating authority and tells that he's not making my payment. You initiate CIRP against him. It will be a waste of time. It will be a waste of time because it's not so that I'm not ready to make the payment, that I'm not making payment because there is existence of dispute, right? So in such situation, the case is slightly different. What happens is the code requires operational creditor to send a notice, a demand notice plus the invoice, demanding payment from the corporate debtor, and corporate debtor within 10 days has to either pay the amount or intimate about dispute, has to do either of the two things. If it does not do any of the things, then application for initiating CIRP can be filed. If there is a dispute which is in existence, that dispute has to be resolved. You cannot initiate CIRP over here, right? If the person has already made payment, you cannot initiate CIRP. If the person is not doing any of these, then you can initiate CIRP and you can file an application. You will attach the copy of invoice, demand notice, affidavit that there is no dispute, proposed IRP. Here it is not mandatory to propose the name of IRP. The financial creditors know about IRP, they are in touch of IRP, but a vendor, we cannot expect him to propose some IRP or knows the name of any IRP. So here it is optional. You may propose. If you don't propose, the board, the IBBI is going to appoint one for you. Record with IU, if available, certificate from financial institution that the debt is not, that is your bank records, other proof or any prescribed information. So you file an application for initiating CIRP against corporate debtor, and within 14 days, if the adjudicating authority is satisfied that the application is complete, you gave the demand notice. These are prerequisites. Under section 8, you read about the prerequisites. That means an operational creditor has to satisfy these things. Only then he can make an application under section 9 for CIRP against the corporate debt. So if adjudicating authority is satisfied that yes, demand notice has been given to corporate debtor, because that is a prerequisite which is given under section 8, so it has to be given first. And what will be the effect of the demand notice? That either the debt will be paid or the dispute will be given, or none of that happens, right? So if debt is not paid, then only you can make an application and there should be no dispute of notice. So if AA, that is NCLT, is satisfied of that, and of course the proceedings, if any proposed IRP is there, there should be no pending proceedings against him, only then the application will be admitted. And the date of admission of application is the date of commencement of CIRP. However, if NCLT thinks that maybe application is not complete, or maybe you have not complied with the prerequisite under section 8, that means you have not served the demand notice to corporate debtor, or if you have served the demand notice, maybe the debt has already been paid off, or there is some notice of dispute which has been received, or there are some pending disciplinary proceedings against the proposed IRP. In that case, NCLT will provide an opportunity to rectify the default within 7 days, and if rectified, application will be admitted. If not rectified, the application will be rejected. Clear? Now comes section number 10, initiation of CIRP by corporate applicant. The corporate applicant himself can also make an application for CIRP. Supposedly it thinks that maybe if we don't treat our insolvency now, we might run into liquidation or we might incur some heavy losses. So it's better to revive our situation, and that a professional can do certainly better. So we want some professional to take over the management and try to resolve with a beautiful resolution plan. So corporate debtor himself makes an application to adjudicating authority. The same thing happens within 14 days if the adjudicating authority is satisfied that whatever name of IRP you have proposed, there is no pending proceedings against that person, the application will be admitted. If there are pending proceedings, you will be given an opportunity to rectify the default or defect within 7 days and resubmit your application. If rectified, application will be admitted. If not, application will be rejected. Clear? Okay. Once you have made an application under section 7, 9 or 10, 7 by financial creditor, 9 by operational creditor and 10 by corporate debtor himself, corporate applicant. If you have made an application, can that application be withdrawn? See, if you make an application and the application is not yet accepted by the adjudicating authority, so you give the permission, no, I want to take back my, you request for the permission, I want to take back my application, you can. If it has already been accepted, that means somehow the proceedings have moved to a next stage. Quite possible, till now you have not constituted that committee of creditors, so you don't need their approval. Only IRP can make an application and do it. If you have constituted COC or thereafter you have invited plans or all, then you require approval from COC of at least 90%. Okay, so then once you obtain the approval, within 3 days you will make an application to adjudicating authority, and adjudicating authority is going to pass an order for approval that yes, you may withdraw your application. So this can be a question which may be asked to you, that whether an application once submitted for CIRP can be withdrawn or it cannot be withdrawn, right? So it can be withdrawn. There are certain cases where an application cannot be made for CIRP, which is given in this section number 11. See, some corporate debtor is already undergoing CIRP, some operational creditor again wants to make an application. Arey Baba, the CIRP process is already going against that corporate debtor, so how another application? That will be multiplicity, na? How can we initiate CIRP against one corporate debtor by two different people? No. So that is not allowed. If supposedly CIRP was completed 6 months before only, and again you want to initiate CIRP, no. That is not possible. So give it some time, right? So if it was completed within preceding 12 months, if there was some CIRP plan which was approved, but the company could not implement and execute the same and violated it within preceding 12 months, then again you cannot initiate CIRP. And lastly, if already liquidation order is being passed for the corporate debtor, so you cannot initiate CIRP. Right? So my dear, what is the flow? application is being filed by either financial creditor, operational creditor, or the corporate debtor himself. Once an application is filed, it is either admitted or rejected. If it is admitted, that comes out to be the admission, or that comes out to be the commencement date, and from that commencement date, within 180 days, CIRP has to be completed. CIRP has to be completed. A one-time extension of 90 days may be granted subject to approval. So, COC is going to by 66% votes in value, they are going to approve that yes, we want extension. Then RP will apply for extension to adjudicating authority, and adjudicating authority will grant an extension, but that extension cannot be granted more than once, and that too of 90 days only. Clear? Now, once your application is admitted, it marks the date of initiation of CIRP, and that has to be completed within 180 days. As soon as the application is admitted, there are three things which happen. Firstly, declaration of moratorium. Secondly, appointment of IRP. And thirdly, public announcement. What do we mean by moratorium? Moratorium means suspension of certain things. Supposedly, I am trying to resolve certain things, and at the same time, more issues are popping up. It will be difficult to resolve. Likewise, if I'm trying to settle down the disputes between the creditors and the debtors, but some creditors are again filing cases against these people, it will be difficult, it will be impossible to resolve. So that is suspension of these things, which is moratorium covered under section 14, which tells us that on insolvency commencement date, AA, that is adjudicating authority, or NCLT, is going to prohibit that no new suit is going to be filed, no old suit is going to be continued for hearing during moratorium. So these all things or activities are going to be suspended. You cannot transfer any asset, you cannot dispose of any asset, you cannot create any new charge on that assets, you cannot let someone else recover the property which is in your possession at right now. Supposedly, the company is functioning in a building. That building is taken on lease from someone else. So he cannot take back the property right now, which is in possession of corporate debtor. Of course, if lease has expired, other terms are prevalent, right? So that cannot be recovered during moratorium. You cannot execute any order of court, and you cannot even enforce the action under SEBI Act. But there are two things which will not be affected. One is supply of essential goods and services. So like electricity and all. So supply of essential goods and services will not be affected. And if the company had a telecom license, that license will not be revoked, because if that license is revoked, the company will not be able to function anymore. Right, and when the company is not able to function anymore, how will the insolvency be revived? Right, so that will be become difficult. So the license will not be revoked or suspended, and the supply of essential goods will not be terminated. Moratorium comes to the end once CIRP comes to the end. So during whole process of CIRP, there will be moratorium. Supposedly CIRP could not happen properly, and the company had to turn into liquidation. So when it starts the liquidation, then also moratorium will come to end. Clear? So what is happening? Applications are being filed, application is admitted, then moratorium is declared, then IRP will be appointed, and after IRP is appointed, within 3 days, IRP will make a public announcement. So first of all, I'm going to deal with IRP. Who do you think should be appointed as IRP? When applications for CIRP were filed by financial creditor or the corporate debtor, they proposed a name. And when the application was filed by operational creditor, they also could propose a name. It was not mandatory for them to propose a name, but they can propose a name, right? So if they had proposed the name and no disciplinary proceeding is pending against that person, he will be appointed as IRP. Supposedly operational creditor files an application and does not propose any name, then the matter will be referred to the IBBI, and IBBI within 10 days will suggest a name who will be appointed as IRP, right? So likewise the appointment of IRP is going to take place. Once IRP is appointed, within 3 days I hope it's clear, right? So within 3 days he is going to appoint, he is going to make a public announcement. What will be written in public announcement? In public announcement, he is going to invite the claims. He is going to tell about the corporate debtor, that what is the name, what is the address, under which authority is this registered, I am the IRP, what is the last date by when you can submit the claims. If you submit a false claim, there will be a penalty, and by when CIRP will end. Okay. So he makes a public announcement with respect to that. Now, IRP is appointed, he has certain powers and he also has certain duties. What type of powers? He is going to take all the powers of board. He is going to supersede the board. All the officers, all the employees will now report to IRP. So he is going to take over the whole management of corporate debtor. He can execute deeds and documents, he can sign, he can take actions, he will have access to all the books of accounts, to all the records, all the, of course he has to comply with law, right, and protect all the property of the company. At the same time, he also has certain duties. What are the duties? He has to collect information about the asset. And as I told you, when he makes a public announcement, he is making public announcement for invitation of claims. So he also collects and collates all the claims, he verifies all the claims. The most important function is to constitute the committee of creditors. See, IRP has a very short tenure. From the insolvency commencement date till the appointment of RP, he might be appointed as RP also, and somebody else can also be appointed as RP. So in the capacity of IRP, he has a very short tenure. In that tenure, he has to perform these duties. He has to take care of the assets. He has to file the information with the utility so that it's updated. He has to monitor the assets and he has to perform the duties as specified. Manner of submission of claims, not so important, but you can remember the forms, that if you're a financial creditor, you have submit in form C. If operational creditors, submit in form B, and the employees and workmen have to submit in form D, right? So they submit all the claims, IRP verifies the claims, makes a report and provides it to adjudicating authority, right? Now, application is filed, application is admitted, moratorium is declared, IRP is appointed, public announcement is made, then claims are collected and committee of creditors is formed. Committee of creditors, my dear, under section number 21. So, after collation of claims, before collation of claims, you cannot constitute a committee of creditors. Why? Because you need to know who are the financial creditors. In the committee of creditors, we have financial creditors. We don't have operational creditors. Okay, but if supposedly there are no financial creditors, then we might have to include operational creditors only. Now listen to me. If you have these doubts that ma'am, their interest will be hampered, no such their interest will be hampered. I'm telling you. If financial creditors exist, then all the financial creditors will be the part of that committee of creditors. But if there are any related party, they will not have a right to say, they will not have a right to vote. Okay. If all the financial creditors are related party, then operational creditors will be the part of committee of creditors. And if there is no financial creditor, then also operational creditors will be the part of committee of creditors. In both these situations, the 18 largest operational creditors by value, one representative of workman and one representative of employee, they are going to be the financial creditors. Supposedly we don't have 18 operational creditors, we only have 10 operational creditors, then all the 10 operational creditors will be the part of committee of creditors. So IRP constitutes a committee of creditors. If there are 2 or more financial creditors as a part of consortium, that means they have collectively advanced the money, then they both are going to be part of COC, and their voting will be in proportion to the amount that they have advanced. If a person is financial as well as an operational creditor, then his voting share will be determined accordingly in proportion to his debt as a financial creditor, right? And if he assigns his debt to a financial creditor, then again the voting will be accordingly proportionate. Now, once the committee of creditors has been constituted, within 7 days you have to conduct the first meeting of COC. Just like we have read about general meetings of shareholders or the board meetings, like that we also have the meetings of the committee of creditors, wherein a notice has to be sent. 5 days notice to every participant. 5 days notice to every participant. It may be reduced by COC to not less than 24 or 48 hours. Quorum has to be 33% in value. Then voting, all the votes have to be approved by 66% in value. If the quorum is not present, the meeting is going to be adjourned to just the next day, right? If it's a holiday, the succeeding day, right? If the quorum is not present even in the adjourned meeting, the members present shall constitute the quorum, right? In board meeting, if you remember, in general meeting, if you remember, you have read about that the board may decide about the adjournment. Here nobody decides about the adjournment because everything has to be quick. The process cannot wait, right? Okay. This point I have dealt in later also, so I'm going to tell you later. Now, what happened is, application was filed, application was admitted, then public announcement, moratorium was declared, IRP was appointed, public announcement was made, claims were collected, they were verified, they were collated. Committee of creditors was formed by the financial creditor, comprising of the financial creditor or operational creditor, whatever the case be. After committee of creditors is formed, their first meeting takes place within 7 days, and after that, in the first meeting of COC, RP is appointed. Resolution professional is appointed, that is by 66% votes. Either you appoint the same IRP as RP if his consent is obtained, or you can also replace IRP. If you do that, you are going to send this application to adjudicating authority, who is going to forward to the board, and board confirms within 10 days whether to appoint or not to appoint, right? So RP is appointed. Now what IRP does? What IRP does? Okay. IRP has to conduct the whole CIRP process, that is, RP has to conduct the whole CIRP process. Whatever documents were available with IRP is going to hand over the documents to RP. RP also has the same rights and duties and powers as IRP. It has to manage the operations till CIRP ends or the liquidation order is passed. He has to conduct the meetings of COC. In the first meeting he is appointed, so subsequent meetings he of course conducts in the manner specified by board, and he also has certain duties as are given in section number 25, and he also prepares information memorandum. See, information memorandum contains that relevant information. What happens is we have certain eligible resolution applicants. What is the main motive? We are conducting CIRP. So we want someone to come up with a beautiful resolution plan how this company can resolve. But unless we have the details we require to formulate a plan, we cannot provide a plan. So information memorandum basically contains the relevant information which is needed by every resolution applicant to make a plan, which also contains the details about the compliance of law and like things, right? So these are their duties. During CIRP, if at any point of time COC finds that no, we don't want to continue with this RP, they can by 66% votes resolve and propose a new RP, obtain its consent, forward the name to AA. It is going to forward the name to IBBI, and IBBI is going to confirm that no disciplinary proceeding is pending, so he shall be appointed. If it is pending, then board recommends a name. Okay, and he shall be appointed. There are certain duties or actions which are subject to approval also under section 28. Certain actions which are subject to approval. But I'll not deal in detail, but once you start, once you just go with the flow. See, resolution professional undertakes all the duties, it has all the powers, but there are certain things for which it requires the approval of committee of creditors. Just like when we read about a company, the board has powers, but the powers of board, section 179, they're also restricted. Certain powers require approval of shareholders, right? So the same happens over here also. If you want to raise any, I don't think I have included that section 28 in the chart. So you read it on your own. Anyways, if you want to raise any interim finance, that means already you have so much of loan, now you want more loan. You want to raise some interim finance, you cannot raise it on your own, you need to go and take the permission from committee of creditors. If you want to create any security interest, if you want to delegate any authority, if you want to undertake any related party transactions, right, if you want to make some changes in some contracts. So there are certain things which are given in section number 28 for which you require approval. Otherwise, you have to protect the assets, you have to take control of the assets, you have to exercise right for corporate debtors. You have to file application for avoidance of transactions, chapter 3. You have to maintain an updated list of claims. If you are unable to understand this, I'm going to tell you later, don't worry. You can appoint if any professional you need. You have to represent in corporate debtor in third party dealings, and you have to perform other actions as specified by board. So these are all theoretical things, right? Now, what happens? The next important step is that inviting resolution plans. You have prepared information memorandum, right? And that includes all the details that are needed to formulate a plan. So there are certain resolution applicants who are the persons who are not eligible, are given under section 29A. Of course, it doesn't have to be someone who is related or someone who is not competent. A person who is disqualified to become a director cannot be a resolution applicant. Someone who has been prohibited that you cannot trade, he cannot be a resolution applicant. Someone who is convicted on offense, or someone who is disabled under some foreign law, or some connected person, or someone who is insolvent, right, or promoter. So all these people are not going to be eligible to be the resolution applicant. Other than that, if you are eligible, then you can submit a plan. You can prepare, you can formulate a resolution plan and you can submit the same. So resolution applicant, on the basis of information memorandum, they submit a resolution plan plus affidavit of eligibility that yes, I'm not disqualified to be a resolution applicant. They submit the plan to resolution professional who examines the plan, because all the plans has to conform to section number 31. They have to conform to certain standards. Same, the whole CIRP process involves a lot of cost. Maybe you have to spend 5 lakh rupees in this cost, paying the fees of RP, paying the fees of IRP, other administrative type of expenses. So whatever plan you are formulating, that should ensure that these costs are also met. It should ensure that you are not contravening any law, right? Now, so resolution process cost should be provided. How you are going to manage the affairs of the company after this plan is approved? How are you going to implement the plan? There should be no contravention of law and it should conform to the guidelines of IBBA. Now, this point will clear a lot of air. Ma'am, when we were constituting committee of creditors who is going to be involved in all the decision making, you said that the operational creditors will not be included unless we have to necessarily include them in the absence of financial creditors. Otherwise, financial creditors will be the part of committee of creditors. So, supposedly 5 financial creditors form the part of committee of creditors. Now, a resolution plan is presented before them which says that all their debts will be paid off, but the operational creditors will have to make compromises. They will immediately sanction the plan. They will say, yes, let them compromise and we are going to get our money. So wouldn't it be harsh on part of operational creditors? Yes. Why operational creditors are not included in the committee of creditors is because they do not have that adequate sense and knowledge about the finances. Point number 1. But that doesn't mean that their rights will be compromised. So whenever a plan is being made, resolution professional at its first place ensures that that plan should provide for their debts first. Ma'am, if all their debts will be provided, it will again be very difficult, right? So their debts have to be provided for. Supposedly I say that, okay, their debts have to be provided for. So maybe the financial creditor will say that, okay, if we have to pay them 10 crore of rupees, let's pay them 1 crore only. And the resolution plan conforms to the standard that we have also provided for operational debts. You get my point? So this is also not going to be work and this might also be harsh on them. So what the code says, what IBC tells us is that it is mandatory, it is necessary that whatever resolution plan is being presented, it should provide for the debts of operational creditor at least to that amount that they would get if the company goes into liquidation. So today if we wind up the company, we sell all the assets and we pay off the liabilities, what will they get? At least they will get 4 crores. So at least 4 crores should be there in that resolution plan, so that there should not be any injustice to operational creditors also. So if all these things exist in the plan, then that plan is going to be presented before the committee of creditors. They can either approve the plan or they can reject the plan. Supposedly they approve the plan, then just a second. This does not happen. There is adjudicating authority. supposedly they approve the plan, then it is submitted to adjudicating authority. Submitted to adjudicating authority. Adjudicating authority might approve or reject the plan. Okay, it might reject the plan or it might approve the plan. If it approves the plan, right, now it's good to go. So the plan is presented to committee of creditors. Committee of creditors can approve the plan or they can reject the plan, right? If they approve the plan is going to be approved by at least 66% in value vote. So if they approve it, then the plan is submitted to adjudicating authority, and if they also approve it, then the moratorium comes to the end. You have to now implement the plan, and the plan is going to be applicable to the company, to government, everyone. You cannot say that the plan is not going to be applicable to this person or that person, right? Yes, of course, the person who is not satisfied can appeal on certain grounds to the adjudicating authority. Now, if supposedly COC rejects the plan, then we don't have a choice. It is going to run into liquidation. If supposedly COC approves the plan but AA rejects the plan, then also it's going to run into liquidation, right? So we don't have time. What can be the other grounds on which liquidation may start? If the plan is not submitted within the time limit, if the COC resolved that no, COC at any point of time found out that it is futile that we are undertaking the CIRP process, nothing is going to happen, it's better that we wind up the company. So CIRP passed a resolution by 66% votes that let's liquidate the company. So it will go for liquidation. If corporate debtor contravenes the plans and someone appeals that they are not following the plan, then it will come to an end and the liquidation order will be passed if the resolution plan is rejected, as I already told you, right? Rejection of resolution plan, that is something that I've already told you. So in all these cases, the process of liquidation, my dear, starts. The process of liquidation starts. So the plan, if approved, is going to be applicable to the corporate debtor, its employees, the members, creditors, guarantors, all the stakeholders, and even government or any local authority which is involved. The moratorium comes to the end, and the resolution plan is going to be implemented. Clear? Clear? I think so far the things are clear. If anyone wants to appeal, they can appeal if the approved plan is in contravention of law, or RP has not been regular in his exercise of powers or has misused his powers, the operational creditor's debts has not been provided for, CIRP cost has not been provided for, or the plan doesn't comply with any criteria which is mentioned by IBPI. So on these grounds, appeal can be made. Then comes the process of liquidation. The process of liquidation. See, the main motive of the code is to resolve. That is why it is known as CIRP, that is Corporate Insolvency Resolution Process. However, if the attempt to resolve the insolvency of a corporate debtor fails, then only the liquidation process is triggered, and as soon as the liquidation process is triggered, you have to first appoint the liquidator. Right? So far the proceedings were being conducted by the resolution professional. Now the proceedings will be conducted by the liquidator. So, who is going to be appointed as the liquidator? IRP. RP can be appointed as liquidator also, provided he gives the consent. If he does not give the consent, then someone else will be appointed as liquidator. See, as soon as the order of liquidation is passed, that means now the company is going to be dissolved. All the assets will be sold, the liabilities will be paid off. That means it is a deemed notice to all the employees that you are no more needed. It is your termination, right? So it is a deemed notice of discharge to all the employees, etc. Liquidator is appointed. Resolution professional will act as liquidator if he gives his written consent, and he shall have all the powers of board of director or KMP, and personnel, that is the employees, they have to extend the assistance to liquidator. If, however, the plan was rejected because it could not meet the requirements as given under section 31, then if RP was proved to be incompetent in the CIRP process, how can you expect him to be competent in the liquidation process? So in that case, he will not be appointed. If the board recommends that we want some RP to be replaced for reasons in writing, then he will not be appointed. Or if IRP doesn't give his written consent, not request but consent, so he will not be appointed as liquidator. Okay. So in these cases, how the liquidator will be appointed? Adjudicating authority will direct the board to propose a name, and within 10 days, the board, IBBI, proposes a name with his written consent, and such person will be appointed as liquidator. What is liquidator going to do? He is going to verify the claims, invite the claims, settle the claims. He shall take into custody all the assets, protect those assets, carry on business if needed until when needed, sell the property by auction, transfer, or any other manner. He can make negotiable instruments. He can take out in official name letter of administration to deceased contributory. I've explained this particular point in the class in detail. Obtain professional assistance if needed. He can institute suits just to file, to recover money and everything. He has to investigate affairs with respect to undervalued and professional transactions, which I'm going to tell you right now, to take all the actions, to sign the documents, apply to adjudicating authority for necessary orders or other specified functions. Now, liquidator will have the access to all information from information utility, books of accounts and everything. And if the creditor asks for information from the liquidator, then liquidator also has to provide financial information to them within 7 days. Now, liquidation estate. What do we mean by liquidation estate? See, there is a company. What are the assets will be treated, what are the assets which are going to be included in that consortium, and what are the assets which will not be included? So of course, the assets which corporate debtor has ownership rights, any encumbered assets also, all types of assets, whether tangible, intangible. If there are some decisions, there was some suit pending for which court has declared that yes, this asset belongs to the company, so that asset will also be of the company. If there is some asset which has been recovered through proceedings during CIRP proceedings, that assets also. Assets which are collateral. See, whenever there is a creditor, secured creditor, supposedly, he has two choices. He is a secured creditor, he has some asset. He might enforce his security interest or he might let it go. If he enforces his security interest, supposedly he has a loan of 10 crores and he has an asset as a collateral security of say 8 crores. So he has two choices. He can give this asset back, right? And or he can enforce that security interest and realize his money. In both the cases, if company has more money, it will be paid. Supposedly the creditor chooses to sell that asset and realize his money. Now he will be paid the differential amount of 2 crores at a very later stage. The order of preferential payments, that unpaid portion of the secured creditor, comes at a later stage. But supposedly he lets go of his security interest. Now he will be paid here. All that 10 crore rupees. If the company has 100 crore, he will definitely get his 10 crores. But if he chooses to sell off the security interest, he might be get the unpaid portion, or he might not get the unpaid portion, unrealized portion, right? So he has a choice to make. If he lets go of his security interest, then that asset will also be included. The proceeds of liquidation, of course, and all the property that were that belonged to the company at the commencement. What will not be included? Supposedly, I have a building which is on lease, so it does not belong to corporate debtor. It is just in the corporate debtor's possession, so it will not be included. Collateral, which is held by the financial service providers, that will not be taken. As I told you, as I gave you the example, if it is relinquished, then that will be taken. Personal assets of shareholders, assets of Indian or foreign subsidiary, or other as may be specified by the board. So once the liquidation proceedings start, within 30 days, liquidator will collect all the claims with the supporting documents, verify the claims, and can admit the claims or maybe reject some claims. If you reject, then the person has the power to appeal also, that why you have rejected their claim. One person has submitted the claim, they can change their claim within 14 days of submission, or they can withdraw also. Now, after the liquidator has collected all the claims, it is going to check for preferential transactions, undervalued transactions, extortionate credit transactions, and apply to adjudicating authority accordingly. After that, liquidator will sell off the assets and pay off the claims. In what order you have to distribute the assets or pay off the claims? First of all, you will provide for the cost. And secondly, you will provide for these two things: debts of secured creditor, if they have relinquished their security interest, of course, as well as the workman's dues for past 2 years, 24 months. Okay, so if the money is not sufficient to cover both, they will be paid proportionately. The third step, the third stage is wages other than workmen for past 12 months. Then financial debts to unsecured creditors. See, the unpaid portion, if a secured creditor enforces a security interest, then the unpaid portion comes even after the unsecured creditor. So it's sometimes better to let go of the security interest, so you will be paid here, otherwise you will get the unpaid portion at a later stage. So it depends what amount of asset you have as collateral. If it is sufficient to cover your dues, then you should enforce your security interest, otherwise you should let it go, right? So amount due to central government, state government, and this remaining debts and dues, then preference shareholders, and at the last equity shareholders as well as the partners. So liquidator is going to distribute the proceeds. When all the assets are liquidated, liquidator is going to make an application to adjudicating authority for dissolution. Right? So I hope so far the things are clear. We have some preferential transactions. Preferential transactions may be the management had some idea that the company might run into liquidation, so they repaid certain amount to a related party or to a non-related party when the company was not in a very good position. So that transaction looks like a preferential transaction, so the money will be taken back from them, right? RP is going to apply, liquidator is going to apply to adjudicating authority, and those deemed preferences will be reversed. The order will be passed accordingly. Likewise, you also have undervalued transactions and extortionate credit transactions. I think so far you must have understood the whole process. The amendments in IBC, as well as a very important portion of PPIRP, that is pre-packaged insolvency resolution process, is there in another video. Please check that out. Very important for examination point of view. You can expect certain questions from them. So you check out that, it is in the other video. You can of course increase the speed of the videos and watch it at your own pace. I don't teach too fast or too slow just to maintain that pace. Of course, I understand that your exams are approaching, so you don't want any time to be wasted, but at the same time, you can increase the speed. I cannot be too fast, for I have a lot of students to match up to. Now, apart from that, you also have fast track insolvency resolution process, and you also have voluntary liquidation. Very small topics. I think you can just read them, just 2 pages, and do it on your own. That's it, my dear. I'm winding up the IBC session here itself. Hope you would gain that understanding, and of course make full use of these charts. You can incorporate other points on your own to make this chart a more comprehensive one. Thank you and all the best.